lord.
Tomorrow.
Early, please, my lord.
Tomorrow.
They have not come forward.
Just wait. Yes.
TMRES, my lord. Since 1 year, they have not come forward. Make further payment, my lord. Kindly have it on Thursday, my lord.
Good.
My lord.
Date good. Give it.
My lord.
Give your memos. Fresh matters, you write on top fresh matters and give it. It will come tomorrow or day after.
My lord, parole, my lord. If a mother feeling not is.
Pudi.
Kindly have it on tomorrow or day after tomorrow. Date will be
Pudi.
given.
Short date put.
My lord, fresh matter, my lord. Any date, my lord.
Date will be given. Yes.
Fresh matter, my lord. Summons
give it.
were issued to the respondents, my lord, but it's been 2 months, nothing has happened. So we'll take hand summons in this case, my lord. Our date will be fixed today or tomorrow or day after tomorrow, my lord.
My lord, parole matter, my lord. Please kindly on tomorrow or day after tomorrow or any short date, my lord.
Short date put.
My lord, sale did not take place, my lord. Sale did not take place, my lord. Writ petition has been
For the bank here. Other infractions. Give it. Huh?
37.
Give it.
My lord, fresh matter, my lord, pertains to
matter will
notification, my lord.
Give
Tomorrow, my lord.
Fresh matter.
Tomorrow.
My lord, pending matter, threat of disconnection of a dealership, my lord, LPG dealership, my lord. Tomorrow.
Pudi.
Milords, this is a matter pertaining to.
Date good.
Milords, the BBMP is even agreed to give the TDR. Milords, this matter has gone through several rounds of
Local
WPS.
bodies. How does it come here? Local body. To move before local body roster, not here.
Milords, it
27.
was listed in this court last week, Milords, but it was.
It cannot, madam.
Yes, sir.
When you seek for TDR against BBMP, it has to go before local body roster. Classification correct, classification correct.
My lord,
There's some urgency, my
Tender.
lord. The petitioner is a minor, my lord. The name is not being changed in spite of multiple attempts. So due to this, which the admission is at hold, my lords, of the minor.
No, that you have to go before local body roster. How you can move it here? Local body roster, not here. You have to seek for
Again,
direction
Union of
against the
India, my lord.
register of births and deaths.
No,
Not
my lords, Union of India, Aadhaar card.
Aadhaar card. Togo.
Maybe had tomorrow, my lords.
Pending matter, my lords. 2 dispute petitions have been filed
Give
before.
it.
my lord,
Petitions compliant.
Lords, this matter pertains to TM police.
Give it.
My lord, the matter
Tender.
has been listed tomorrow.
Adjournments?
Huh? In the?
As per the Karnataka police manual.
Right.
my lord,
Give it. Short date.
my lord.
I am the auction
My lord,
purchaser,
under
my lords.
KTP,
Property was directed, the matter was directed to be listed 2 times, my lords, for no reason it is.
Then check madadinike.
My lordship, the matter has been listed tomorrow. Kindly, instead of tomorrow, list it on day after tomorrow.
Then check madam.
my lord, under KTP,
When my lord, the PFI was banned, my property, my lord, which was tenanted to them,
Has been seized.
it has been seized.
Kudi.
Emergency, my lord.
Fresh matter.
Fresh matter.
Barutte.
Fresh matter covered by judgment.
All fresh matters you give it. Just write fresh matter and come tomorrow, day after tomorrow.
my lord, pending
My lords, fresh matter
KTP,
covered by
my lord.
judgment.
Kudi. Fresh matter.
Government indicates that it is single bid, therefore earlier.
Kudi. Short date good.
My lord,
Yes.
Tender matter, my lord, KTP Act, my lord, this some court directed to take notice and report immediately with regard to, because of that, my lord, my tender is likely to be cancelled.
I did good.
He is 75 years old. The IO seized my account.
I short date good. Short date.
Lordship, I moved the memo twice. It's a covered by judgment, your Lordship. And fresh matter, it is not listed.
Give the number.
Yes,
Give the-
please, great.
Fresh matter covered by judgment regarding the acquisition, my lords, this honorable court had an occasion to consider and
Give it,
directed
give it,
DC to
give it.
consider.
Yes.
My lord, old matter, my lord, B group.
My lord,
My lord, in fact,
Adjournment
entire sale
list
consideration
last week I submitted.
paid. Entire sale consideration has been paid, my lord. Being a power of attorney holder, I am not able to, sale deed is not being registered, my lord. Notice has been issued. We have served it on the government as well.
Yes.
Please.
Last week I had submitted on memo, my lord. I'm party in person for general miscellaneous, but it has not come.
We'll find out. Give it.
Once more I.
Yes.
I'll give it, my lord.
Yes.
Can we have it on Thursday, my lord?
I party in person. Date good.
Thursday, my lord.
Yes.
Thank you.
Adjournments, list 1, page number 1, 1 and 2, page number 2, 3 to 11, page number 3, 12 to 20, page number 4, 21 to 30.
26, my lordship.
Page
Serial
number-
number 26, my lordship.
Yes.
Rest time, my lordship.
Mohan Kumar,
I request list week after next.
Serial number 25, my lords.
Yes.
I appear for petitioner. Raise time, my lords.
At request list week after next.
Grateful.
Page number 5, 31 to 38. Page number 6, 39 to 38.
At request list week after next.
Page number 6, 39 to 48. Page number 7, 49 to 53. Page number
53,
eight.
my lord, serial number 53.
53.
I seek for
Sagar.
please, my lord. 53 and 53.1, my lord.
Huh.
I seek for an adjournment, my lord.
You have informed the other side.
Please, my lord, have informed the other side. Interim order may kindly be exchanged.
Delist the matter on.
The interim order, it's a public premises, shop belonging to the temple.
Any date may be fixed, my lord.
I think date good.
7th.
Interim order on
My lord, one more submission, my lord. Cause list number 2, serial number 3 is
wait.
also
No, just
connected.
wait.
Page number 8, 54 and 55. Page number 9, 56 to 62. 62.
I can't hear you, counsel. You must speak loudly. 62, week after next.
Page number 10, 63 to 69.
68, my lord.
Ah.
Kindly have it next week, my lord. Council on record is unavailable.
There's no interim order.
There's no interim order.
At request list week after next.
Page number 11, 70 to 78.
74, my lord. 2 weeks.
Have you informed the other side? Have you informed the other side?
Office objection, 74.
ಯಾವುದು?
70.
74.
ಬೇರೆ ಇದ್ದಾರೆ ತೋರಿಸ್ತಾರೆ ಕೇಳ್ಬಿಟ್ಟು. Notice is not issued, madam. List after 2 weeks at request.
Page number 12.
You must inform the other side, madam.
79 to 87. Page number 13, 87.
Reda.
Page number 15, 88 to 94.
Reda, 88, serial number 88. Reda, I am seeking permission of this honorable court to withdraw the petition to avail the remedy before the civil court, my lord, because Deputy Commissioner rejected my application on the ground that, my lord, the Welfare Act has no application to the transaction.
Inform the other side.
Yes.
Memo
Serial
file.
number 90, my lords, I'm applying for the petition.
I have not finished.
I'm sorry, my lords.
88. Petitioner is found, counsel of petitioner filed a memo which reads as hereunder. In light of the same, petition is dismissed as not pressed. All contentions are kept open. You must inform the other side.
With liberty, my lord.
And liberty is reserved to take appropriate action insofar as
Before the civil.
the impugned orders and action before the appropriate forum.
Serial number 90, my
My
lords,
lord,
I'm for
my
the
lord, my
petition.
lord. Here, my lord, the gift deed that has been challenged.
Correct. Appropriate forum will include civil court.
Yes.
Serial number 90, I'm applying for the petitioner. May I kindly request for a date after 2 weeks, my lords?
Just after 2 weeks.
Any date, my lords?
Objections.
Date good. Office objections to be complied in the interim.
87. Page number 16, 95 to 100. Page number 17, 101 to 103.
101, my lord.
101.
Memo for withdrawal. The matter has become infractious.
Counsel for the petitioner filed a memo which reads as hereunder. In light of the same, petition is dismissed as not pressed. All contentions are kept open.
103.
The petitioner has filed a memo. In light of the same, petition is which reads as follows. In light of the same, petition dismissed as not pressed. Yes.
Page number 18, 104 to 105. Page number 19, 106 to 109. 108.
Petitioner has filed a memo which reads as follows. In light of the same, petition dismissed as not pressed.
Page number 20, 110 to 115.
Petitioner has filed a memo which reads as follows. In light of the same, petition is dismissed as not pressed.
Page number 21, 116 to 120. Page number 22, 121 to 124. Page number 23, 125.
125. I'm ready. I'm ready, my lord.
Let us see. Time idre nodana. Let us see.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವ್ ಹೇಳಿದ್ರಿ
Correct. ಏನ್
4 o'clock ಗೆ ಇದ್ ಮಾಡ್ತೀನಿ ಅಂತ.
ಏನ್ ಮಾಡ್ತೀರಾ? Let me see. We'll try to have it at 4. I'll run through the list. We'll try to accommodate at 4.
Page number, list number 2, page number 1 and 2, page number 2, 3 to 7.
Your
page-
Lordship, serial number 5, the
Yes.
counsel on record has some personal difficulty today. The IA for vacating may be heard with the main matter and a date may be fixed in
No,
that.
no, how can that be done?
He's not
No,
aware.
that's a different matter. How can
He'll
you
argue
say
on the IA as well, Your Lordship.
that? Have you informed the other side? You write out a memo, get a signature and give it to the court officer. We'll refix the date depending on your convenience.
Page number 3.
My lord, serial number 3, my lord, list 2.
3.
Seek
Sagar
for a
Mishra.
Sagar, I seek for a short accommodation. It's connected matter, my lord. P3 I have sought for adjournment in list 1.
Relist on.
Page number 3.
Please,
It can be called along with those matters, my lord.
Along with
the first
serial
matter.
number 53 of cause list 1, my lord.
list,
May be connected.
list along with serial number 53
Three of the
list
cause
1.
list 1.
Please, my lord.
Yes, next.
Page number 3, 8 to 12. Page number 4.
Number 12, please, my lord. I'm here for petitioner. I request the matter may be taken up on Thursday. Senior counsel is held up in Dharwad.
Correct, you write a memo, inform the,
Lord, GM police matter.
no, there is a proposed respondent, you have to inform him. Inform him, write a memo and give it to the court officer. Yes.
Page number 4, 13 to 18.
My lord, serial number 14, I have informed the other side a week's time.
At request, relist on.
Next 1 week.
Page number 5, 19 to 20.
Interim order has to be extended.
Interim order and operation extend next week.
Sure. Page number 5, 19 to 22. Page number 6, 23 to 28. Page number 7, 29 to 37. Page number 8, 38 to 40. Fresh matter serial number 1. Venkatesh. Venkatesh sir.
Password.
Either.
Lord, one mention, there was one matter, my lord, pertaining to this Kukke Subramania Trust. The government had appointed a person who was a rowdy sheeter to the management. And he has now become the president. We had challenged it. A date had to be given, my lord.
Give the memo.
Yes. I'll just,
A date could, a short date.
yes. It could,
Fresh matter, pending.
it is pending, my lord.
Date could.
Please. I'll just give them.
Fresh matter serial number 1. Venkatesh.
Government order has been challenged in this matter.
Correct, but what now the government is the employer, technically speaking. Local standard, anyhow I'll issue notice.
I'll accept notice, my lord.
If the government does not want to take action, what to do?
Tribunal order is also there, my lordship. Tribunal order is
Correct,
there.
they don't want to take any action. Let us issue.
Notice has to go, my lordship.
AGA accepts notice for the first respondent, emergent notice for the second respondent.
Serial number 2.
My lordship, 2 IAs has been filed, my lordship. Now, 2 IAs has been filed, my lordship. Certified copies and type manuscripture, my lordship. Kindly condone.
IA 2. That is IA number.
IA number 1 for.
1 and 2 are allowed. IA 1 is allowed. The petitioner is dispensed with production of certified copy. Subject to the undertaking same will be produced in due course. IA 2 of 24 is allowed. Petitioner is dispensed with production of typed copy for the present, subject to the undertaking that if called upon, the typed copy of the manuscript would be produced at the time of hearing of the matter. Yes.
Serial number 2.
Before petitioner, respondents. This case, my lord, it may be heard together. In point 1, my lord, the counsel is not count. Or your lordship may pass over, my lord.
Pass over means like around about 4 o'clock.
Please, my lord, please.
Now there's only one point.
Please.
What I was thinking. Now under the Foreigners Act.
Please, my lord.
You have no doubt you have the power to impose a restriction.
Please, my lord.
Now you are saying you are imposing a restriction consequent to revocation of the visa or cancellation of the visa.
Violation of the visa condition.
Violation of visa condition.
Even otherwise, my lord, section 3, power to make orders, section 3(2)(e), they shall comply with the prescribed and specified requirement to reside in a particular place.
No, correct. That is there. But my only doubt was a clarification which you can address at the time of hearing.
Please, my lord.
Now, the revocation of visa.
Please, ma'am.
could be on the basis of a suspicion or there has to be some
Violation.
In the second matter,
Please.
para 6 and 7 of your statement of objection.
Please,
In
Madam.
Annexure R7 and R8, state police have said there is no material against them.
Please, Madam.
But still you have taken action.
The police CCB has said they are indulged in the drug peddling.
Correct. But I think the police.
Police has said the other way. Initially, police, they themselves, my lord, brought them before the FRRO, and based on that, we have passed an order following the judgment of my lord in the Babul Khan. The Babul Khan judgment, my lord, certain guidelines are formed. Based on that, my lord, they were put in the restriction center. Now, my lord, thereafter, my lord, the police again writes there is nothing found against them. And CCB says there is something, they are indulged in drug peddling. Therefore, my lord, to clear all the doubt.
That you find out.
No, I have verified the documents, my lord. What they say, they were arrested in sense they were found doing unlawful activities by a CCB. Now, CCB is an independent authority, my lord. They do not have a jurisdiction. So they pick them up from different locations. Then what happens? The jurisdiction police, they have to report when they make some arrest. So they've got them to the Artinagar police station and they have said, since he is a foreign resident, my lord, they immediately have to bring it to the knowledge of the FRRO to check. Now, because they are the authority to check whether there is a violation. Now, my lord, now one of the petitioner here, he's saying he's on a student visa and he's studying somewhere in Punjab. And he says if for a period of 8 weeks he's away from the place where the visa is issued, he has to inform the jurisdictional or the resident place of SHO that he is residing in for specific reason. Now, my lord, he can't leave his jurisdiction. Now, he has come for a specific performance on a student visa to study. Yeah, he cannot leave Punjab and come and operate in Bangalore.
The original
These are the violations.
The original student who got the visa to study in Punjab is studying in Punjab. His attendance marks is there. The petitioner number 3 in this case is impersonating him.
Okay, so let us see, but I want to know whether under the Foreigners Act,
please, madam,
there are any guidelines for cancellation of visa? Are there any?
There, madam. I have prepared a brief synopsis along with the judgments, my lord.
Yes.
Please, my lord.
My lords, also, my lords, my contention is that under the act, they do not have the power to detain a person, my lord. It is only the central government who has the authority to detain a person. Because there's a recent judgment of the Honorable Supreme Court also, my lord. My lords, may kindly have
Give it to him.
This FRRO is a central government, my lord. The facility is run by central government.
Let us see
my
what.
lords, FRRO is an executive authority, my lord. It is not central government.
The Foreigners Order 11, powered to impose restrictions on movement. The civil authorities may, by order writing, direct any foreigner shall comply with the condition as may be prescribed in the order in respect of place of his residence, his movement.
Under section 3, isn't
it? Under order 11 of the Foreigners Order 1948.
Apart from that, under section 3.
Please, my lord. That apart from the section 3, my lord, 3(2)(e), my lord. I've prepared a brief synopsis along with the judgments, my lord.
Let us see which some judgment of it. Have a look at that also.
Please.
Now, all your orders imposing restriction on the movement is on the basis of some reasons.
Please, my lord.
Isn't it?
Please. My lord, as a sovereign state, we need not assign the reason at all for a foreigner. There's no violation of Article 19 or 21 or whatever it is, my lord.
My lords, kindly come to page 4, my lords.
Page
4, my lords.
Yes.
My lords, para 5, my lords.
Yes.
Under clause B of section 3(2) of the act, there is a power vested in the central government to issue an order generally or with respect to any particular foreigner or class of foreigners that they shall not depart from India or shall depart subject to observance of such conditions on departure as may be prescribed. The rules do not impose any such restriction on departure from India. However, as noted earlier, according to clause 5, subclause 1, subclause B of the order, no foreigner shall leave India without the leave of the civil authority having jurisdiction. When a foreigner's presence is required in India to answer a criminal charge, permission to leave India must be refused. Under the order, the civil authority can impose restriction on the movement of a foreigner. Therefore, once a foreigner is released on bail, he cannot leave India without the permission of the civil authority as provided in clause 5 of the order. Under clause 11 and other clause of the order, various restrictions can be imposed on a foreigner while he is in India. The said power is wholly independent of the power to grant bail. As of today, there is no order passed by the central government for giving effect to clause G of section 3, subclause 2 of the Act. In any event, even if such an order is issued, the power to arrest or detain a foreigner under the Act is independent of the power of the criminal court to grant bail. Notwithstanding the bail granted by the criminal court, the power to arrest and detain a foreigner can be exercised provided the central government makes an order in terms of clause G of section 3(2) of the Act. My lords, it is only the central government who can make issue an order of detention, my lords.
No, correct. Now it's the central government that has passed.
Yes. My lords, it is FRRO is an executive authority, my lords. It cannot be considered central government, my lords.
That we'll see.
My lords, there
That
is
you
the
just
difference.
examine. That you.
My lord, if your lordship may, for a moment, my lord, I'll just point out, power to make order, section 3. The central government may, by order, make provision either generally or with respect to all foreigners or with respect to any particular foreigner or prescribed class or description of the foreigner for prohibiting, regulating, restricting the entry of foreigners into India or their departure therefrom in the presence of the continued presence therein. This is the section 3. Then, my lord, section 3, subclause 2, subclause E shall comply with the condition as may be prescribed or specified, requiring him to reside in a particular place, impose any restriction on his movement, requiring him to furnish such proof of identity and report to such particular to such authority as such manner and at such time and place, so and so.
Specified with it.
Subsection 3(2)G is, my lord, shall be arrested and detained or confined. An order here is passed under 3(2)E. It's not under 3(2)G. The judgment says it's under 3(2)G. 3(2)G is entirely different. 3(2)E is entirely different. That is what the Honorable Supreme Court in a Chinnapillai's case has followed and upheld, my lord, the judgment of the Madras High Court, and which is relied upon by this Honorable Court in the division bench.
Order passed is by a competent authority.
It's a competent
That's
authority.
only under 3(E) they can pass an order, my lords. Order restricting the person's movement, not detain him forever, my lords. There cannot be absolute restriction on his detention, my lords.
There is a choice. Suppose you want to go back. I'm just saying. Suppose they want to go back. Then how is it that because he is involved, if he is involved in a criminal case, how can that be done? Is a matter that they will see. Suppose you want to go back. You make that submission. They will look into it.
Lord, in suppose he cannot if he doesn't, if he wants to go back.
Just one minute. If you want to go back, suppose you want to go back, you make such submission. We'll put it forward. We will put it forward to the central government.
My lords, he wants to go back, my lords, but he's been in detention
Okay, let
center
us
from
see.
past 2 years.
Then let us see. Now we have made the statement. They will look into it.
No.
In some of the matters for preventive detention, the state, the stand of the police authorities, including narcotics department, is that they
deport them.
No, they get stuck voluntarily sometimes in
Yes.
some small offences.
Yes, sir.
And then violate condition and indulge in. Now, suppose he wants to go back.
Please.
Is there any, just one. Suppose they want to go back.
Please.
Is there any way out which would subserve your interest also? Just look into it.
Please, my lord.
If it is that even you want to get rid of him, that let him go back.
Please.
And if within the framework of law, there can be some sort of arrangement, you can.
Till the trial is concluded, my lord, he cannot leave the country.
But there are two scenarios.
There are 2 cases
My lord,
registered
my lord,
against
in
him,
this
my
case,
lord.
in the two different cases, there are the two different scenarios. One is where FIR is registered. If an FIR is registered, he has to conclude the trial, take an order of acquittal, then only he can leave the country, because the criminal liability is there. In case if there is no, and if it is a preventive detention for the violation of a visa, in that case they can be deported, provided the FIR gives a
foreigner's order.
In the second case, I think there is no FIR on suspicion.
Please, my lord, there is no FIR.
So in that case, I'm just asking. In that case, in the event he wants to go back,
please,
that could be considered.
Please, my lord, with the honorable exit, and we will see that, my lord, with the authorities, civil authorities, we will drop him to the, drop them to the airport, and the flight is taken off. We will not come back.
So that we'll see.
Please, my lord.
Lords, in
Now
this
your
case,
case,
my-
because the pendency of the cases, there's no way out of it.
My lord, that is at,
But that case was registered in the year 2015, my lord. It's been 10 years now, my lord. From past 3 years, he's not appeared before the court, my lord. NBW has been issued, but he's still in the detention center. He's
No, no,
not
that
able
we'll
to appear in
find
the
out.
matter.
That insofar as that grievance is, it's a genuine grievance, that we will issue direction. Whoever's in charge of that place, they cannot do that. They
My
have
lords,
to
there were
present
3
him.
cases registered against him, my lords. One of the cases disposed of for non-prosecution, my lords. The other 2 are pending against him and is not appearing in that matter, my
So
lord.
that we'll give direction to that.
My lords, my contention is that, my lord, restriction on movement cannot be absolute, my lord. They do not, the FRR do not have the authority to detain a person.
that is a
There
civil
are
authority.
judgment of
It is-
several-
there's a-
My lords, there are
there's-
several judgments, my lords.
That we'll consider.
Lord,
We'll
for
hear
a
it.
moment, my lord.
My lords, restriction of the movement, the purpose of restricting his movement, my lords, so that he faces the trial, my lords, and he should be prevented from leaving the country.
We'll issue appropriate direction for expediting the trial and also that he is present, that you must ensure.
My lord, the
Now,
moment-
Once, correct. Now, once the trial is pending, if the trial is to be concluded earliest, then you must ensure that he is
Lord, it's for
presented
the state.
whenever required by the court.
My lord,
The state, my lord. It is
Huh?
for the state because we are only executing authority, my lord, civil authorities. The
That's
state
my
has
lord,
to do it.
Then you have to do that.
Lord.
Now, the fact that he's there doesn't mean that it means more reason why you have to produce him on the dates.
The foreigner's order, my lord, order 5, power to grant permission to depart from India. It says, my lord, no foreigner shall leave India unless, my lord, leave shall be refused by the civil authorities is satisfied that the foreigners has failed to comply with the formalities of departure prescribed under registration of foreign rules 1939. The foreigner presence is required in India to answer a criminal charge. So there is order 5 of foreigners order 1948 makes it very clear. My lord, in that event, my lord, he cannot escape the trial. Insofar as the second petition is concerned, my lord, where the 3 petitioners are there, my lord, absolutely no.
That will consider.
Please,
my lord,
Now,
restriction.
but just think about it, because the police authorities have been saying that these people once are get entangled in a case, because the case takes a long time.
Please.
They are misusing sometimes by getting bail coming out and redoing the offense.
Yes.
So is there any way out of it? Just look into it, which serves the interest of the state also. Let us see, apply our mind to it.
My lords, and also, my lords, they say that they have complied with the order of this honorable court in Babulkan versus State of Karnataka. My lord, subsequent to that, they've released me from the detention center, my lords. 3 orders have been issued. One, they have detained me, again released me, again detained me, my lords.
We'll examine that. We'll examine that. We'll examine this. So we'll have it, let the other side, that other counsel who's appearing in the other matter. Yes, Mr. Counsel.
My lord, I'm here.
Just 1 minute. There is a submission that in your matter, in the event you are ready to go back, then you will be released forthwith and subject to whatever conditions, and you can consider it. If you are willing, you just think about it.
Because they become illegal
My lord,
migrants.
there is no question about that. No,
Okay,
my
let
lord,
us,
just
then
a
we'll
minute.
hear the
My
matter.
lord,
We'll hear
my
the
lord,
matter. We'll hear the matter.
May I submit, my lord? See,
No, we'll hear the matter.
consequence of
We'll hear
when,
the
my
matter.
lord?
On merits, we'll hear the matter. The proposal was that in the event you wanted to go back because there is no criminal case pending against you, something could be considered or we could pass direction. But if you are not willing, then we'll hear it on merits. Let us see.
My lord, may kindly hear me. Just one minute only one submission. I have not made any submission, my lord. See, this case is clubbed with someone who has a criminal case pending and who is not having visa. My case, I am a student. I have visa and valid passport, and I have no criminal case pending. So there is no question of clubbing the 2 cases together, my lord, and there is no question of withholding me for any reason. So they are not the same, my lord. The case of deportation does not arise except I am illegal in the country. I am not illegal, my lord.
Okay, just 1 minute. His matter, we will have it separately tomorrow. 2.1 delinked list in preliminary hearing list tomorrow.
This matter also may be listed tomorrow, my lord.
Two,
Any day after 30th.
two relist the matter on
Any 30th.
You
30th.
two.
30th month. Release matter. That is this month.
ನಿಮ್ದು 2.1.
30th.
30th.
Yes, excuse me.
My lord, in preliminary hearing, my lord.
In preliminary hearing. Yes.
The only purpose which is served that petitioner is this.
My lord, preliminary hearing also.
Yes, yes, yes.
If he wants to come back to India for further studies also, my lord. There's a problem.
Please, my lord, mine may be heard differently and not together with your case. I request.
Yes, separately tomorrow. Separately
Obliged, my
tomorrow.
lord. Grateful, my lord.
Yes,
D.
please.
MS Devaraju.
In this case, my lord. My lord, cannot kindly pass over, my lord. The advocate will be here.
Don't reach, madam.
My lord,
Petitioner.
last date also same thing happened and got adjourned, my lord. They did not even repay the amount for the interim order which was mentioned on the profit date.
Now, there's no interim order, isn't it?
There is interim order, but they did
It
not
will
repay. on
stand
the-
correct. If it's, is it conditional?
It was, but they repaid lately, my lord.
Huh?
Now, the remaining amount, it has to be repaid. They told that they'll agree for that and
Okay,
the
pass
date
over
will be
it.
fixed for that.
Pass over.
Much.
4. Mahesh.
Appearing for the petitioner in this matter, Your Lordship.
Appearing for second respondent in this matter, my lordship.
Your Lordship, this matter pertains to an notice issued by the Registrar of Societies to the petitioner. The
Now they're
petitioner,
contending that it's a firm, not a society. Then where is jurisdiction?
Point 1.
They're saying under section 25, it has to be a society.
It has to be a
Good,
society,
act good.
It is
Now
a-
show me a deed. Show me a partnership deed. That is the only point. Otherwise, we can't interfere.
we have not enclosed the partnership deed in this matter.
Correct. You have raised the contention that
Annex-
there is no jurisdiction.
Annexure B is this registration certificate.
It's an
Annexure?
MOA of
Annexure
the.
B, my lord.
Page 18. Page 18, my lordship.
It's a Sakara Sangala Upanondanigara Jilla.
It is a society, my lordship.
The complainant,
How do you get over this?
Your Lordship, the complaint, there are two ways section 25 can be invoked. Section 25 is invoked against a member of or a society under the Karnataka Society Registration
Now you are a
Act.
society annexure B.
Even if you go by the complaint, Your Lordship, the complaint is filed by one member. They have not even satisfied the criteria of the majority.
Can be also suo moto.
It is not suo moto.
It is a suo moto.
No, last time I pointed out,
The complaint may be.
That's for the petition. I'm sorry, that's the complaint, that's which is enclosed. Or even the order itself, it is by a complaint, by one person, Mr. Guru. Sorry, Vabi.
Second respondent, my lordship.
Right. So, that's the section, what it mandates under section 25.
now is it suo, just one, is it suo moto?
Your lordship, it's a suo moto complaint here. No, I have.
Now you have to show that it is treated as suo moto.
Yes.
My lords, I may be permitted to make one small submission, my lords. I appeal for the Residents Welfare Association, my lords. The contention what the petitioner has raised here, whether section 25 can be invoked against the petitioner company or not. Lords, my humble submission here is that because
in terms of annexure B,
yes, my
that
lord.
question will not arise. Just wait. Now
Yes.
I want to know.
Yes,
Now we are only on the jurisdictional point. We cannot enter
Yes,
into
my
the
lord.
merits.
Lords, this is purely related with the misappropriation of the
Yeah,
funds.
so
my
that's-
lords.
that- that's
even
a
the
matter-
subject. But our contention
that's
is
a matter
the
on-
funds which is owned by the
That's a
petitioner
matter
belongs
on-
to the
Just
position.
that's a matter on merits.
Yes, ma'am.
Now is it suo moto or not? You have to say.
So your lordship may have this matter tomorrow. I'll clarify.
Just wait.
May I make one submission on the exact issue, It is not suo moto, even on the face of it, If they want to create a record behind, now for the purpose of court, it may not be done. May see the inquiry order, which is impugned, or the appointment of an inquiry officer. They say that, the reference is ullekhanti. Even in, page 37, the first reference which they have given.
complaint may be taken note of and then treated as sumo.
It's not so.
Just wait, let us see.
Yes,
Just
Millards,
wait.
yes, yes.
List tomorrow. You have to substantiate on that.
I'll substantiate.
List tomorrow in the same
The
stage.
most important content here is
On merits,
so far.
we are not hearing on
Yes, my lord.
merits.
Petitioner has not.
Only
handed
whether it
over-
has been treated as
Even-
sumo or.
Even if it goes, it would be remanded for fresh consideration according to. Just wait.
No,
Tomorrow.
it can't be reminded, Millards.
Let us see. That tomorrow we'll see.
Yes,
Millards, the very issue, Millards, came up for
Let
consideration.
us see. Let us see.
Five.
Tomorrow. Yes.
It's not tomorrow, Millards. Millards may have it the day after or Friday.
Yes.
Thursday.
Thursday.
Yeah.
In same
My
stage.
lords, one more submission, my lords. In the list, R3 has been reflected as Vinod Kumar, my lords. I'm appearing for Residents Welfare Association. It should be R4, my lords. Kindly.
Office to show name of Vinod Kumar
R4, my lords.
as representing R4.
Residents Welfare Association.
Perhaps the interim order, Millards, maybe.
Interim order is there, is it?
Yes.
By mistake, somebody has given. Interim order earlier granted is extended till the next day. We'll discharge it.
Your lordship may have this on Thursday. We'll let clarify.
Millards will convince Millards on what basis.
Let
the
us see,
interim order
let
was
us-
given.
let
It's
us-
Based on a division by judgment, Millards, saying that.
I'll hear you.
Minister cannot have a-
I'll hear you.
Five. Lakshmi
You share that judgment with the government advocate.
Yeah, we'll do so.
That let him have a look at it.
AG. Five.
Yes. Yes,
So
respondent.
this, my lord, the Human Rights Commission has to answer. The notice was served upon Mr. G.K. Sudi, my lord.
B.B. Patil.
Gopal Krishna Sudi.
A.V. Patil.
Here. He's here.
Yes.
He's here.
There's office subjections there in petitioners.
Huh?
Office subjections there, petitioners.
We're not on that point, sir. We're on the point, what is the power of the Human Rights Commission to issue a positive direction?
Only recommendatory
Then
things has to
we'll
be done.
state and we'll hear it.
Only recommendatory things. Kindly put up for hearing, Madi, then I'll.
Huh?
Final hearing, Haki.
It's the stand of the learned counsel for the respondent.
Number two.
The Gopal Krishna Sodi.
Please, I'm standing counsel.
Standing counsel for the respondent, that the
number 5.
direction is
R5.
recommendatory of the Human Rights Commission, recommendatory. Accordingly, it is clarified that the subject to further consideration, the recommendation of the Human Rights Commission is to be treated as recommendatory and it's up to the authorities to take action in accordance.
As per the law.
Yes. List after 2 weeks. Yes.
Six.
Interim order. Interim order.
I've stated it's recommendatory. No stay. They can consider, they need not consider. If the government wants, they can take action, but they're not bound by it. Yes. Next.
My lord, in that B.B. Patil's name is being shown in the list.
I'll delete.
You have to delete that.
Office to registry to delete the name of B.B. Patil. There are some judgments which say it's mandatory. Have a look at it. Madras
Reported
High
judgments
Court-
are there.
Huh?
Reported judgments are there. I myself appeared.
Let us. Yes.
I will.
Six.
This,
Lord, this
you
matter.
just have a look at that Supreme Court direction. The Supreme Court, just one. Just one. A Supreme Court. Jewelry seizure. Just have a look at it.
Yes.
And if you
This honorable court also, my lord.
No, correct. But
issued
now
certain-
Supreme Court has passed one order. Kudu. Our Nandi idea. Shall I have it tomorrow? We just go through it.
Please, my lord.
In case it settles the issue, okay. Otherwise, you make submission. I'll consider.
Lordship may pass over, my lord.
Reach agat kashta. Tomorrow or day after tomorrow.
Tomorrow.
ಅಲ್ಲ tomorrow ಅಂದ್ರೆ list ಅಂದ್ರೆ reach ಆಗಲ್ಲ. Day after tomorrow you day after tomorrow and same stage. Have a look at it. This appears to be being followed. If it serves your interest, because you are the complainant.
Yes, madam. I'm the
correct.
complainant.
But now this has given some detailed directions. So you see how your interest can be addressed in this. Day after tomorrow and same stage.
Please.
7. Harish Pandari.
I appeal for the petitioners here and Lordship.
Please go. Yes.
Lordship, this is a petition filed by the petitioner where the DC has set aside the order of the AC where the DC petition was filed under
Take out
section
notice.
16.
Take out notice.
Lordship, the order passed by the DC itself is not maintainable, and already a division bench of this honorable court has passed a judgment where under 16, before the DC, only the senior citizen or a parent can maintain an appeal. But here the children have filed the appeal. In spite of that, the DC has set aside the order passed by the DC. Firstly, 2,500 is the maintenance amount, Lordship.
In light of the contention that
My
apart
lord,
from
the
the senior
the petitioner
citizen,
before the deputy commissioner are not their own children. The dispute is that the proprietors had two wives. So they are the children of the first wife. That is the
correct, but on jurisdictional point, it has to be stayed.
Yes.
Isn't it? In light of the contention of the petitioner that except the senior citizen.
Senior
right?
citizen and parent.
And
Parents.
and parent. Right of appeal not available before the deputy commissioner. There will be stay of annexure A, emergent notice to respondent 3 and 4.
I except for R1 and 2, my lord. Rest are all private response.
TA 1 and 2, emergent notice to the other respondents. List in preliminary hearing list after 2 weeks.
Please, grateful.
8. Akash?
It's appeal for the petitioners, my lord.
You take out.
And this is the RERA recovery.
Correct. We have to find out now what is it.
My lords, I've asked for interim prayer in this. Basically, if
we can't do that. That has to be done in a.
My lords,
that has to be done in execution proceedings.
No, I
can't do it here.
No, there's a direction for the RERA, my lords, to address this issue.
So you execute it.
Execution, but
we'll
I'm saying-
find out what is the difficulty in execution by asking the state to get instruction, and then we'll issue appropriate direction.
But in the meanwhile, interim directing RERA not to give any extension to the builder because he's the biggest. 25% of the total state recovery is by this particular builder, my lords.
We'll find out.
Interim order may.
If we are passing such order, it must be in the presence of the other side, isn't it?
Sorry, my lord.
If we are passing such order, it should be in the presence of the other side. So you take out notice, we'll fix a date. Let us see. If we make out a case in their presence, we'll pass an order. AGA accepts notice for respondents 1 to 3. Emergent notice to 4. Gautam so and so, Gautam Ullal. Gautam De Ullal, director, accept notice for 5. Petitioner is liberty to take out notice by 4 by way of hand summons as well. Relist the matter. Date good. 7th. Let us see.
9.
Petitioner.
Yes.
This petitioner.
Police
The
protection.
representations has not been.
Police
considered.
protection.
Yes.
Just 1 minute.
As circular annexure L, my lord, page number 144.
No, just 1 minute. Is there any civil dispute pending?
There is no civil disputes, my lord. Recently purchased the property in October.
Let us see. Now we'll club it along with that. Where is that? There was one batch of matters state.
And annexure
We'll club it with that also.
Their own circular, my lord, 143 page.
We are hearing that. We are hearing that. AG accepts notice for the respondents. The list along with WP number so and so. Yes.
10. Bill number 10.
Petitioner. My lord.
You serve the other side, we'll hear.
My lord, mandatory provision. Now, the mandatory provision is given a go by, and the court which has no jurisdiction again extends the time. Kindly see the order. One is the order dated 27 to 25, page 89, annexure J.
There is no other alternative remedy for you.
There is no other alternative.
Page?
Page 89. That is on 27 to 25, my lord.
Order on IA 1 and 2.
Yeah, yes, order on IA 2 was passed. IA 1 notice at page 93. Page 93. Issue notice on IA number 2 and temporary injunction order on IA number 2 and emergent notice on IA number 1. IA number 1 is only notice. In respect of injunction, order is granted. Now kindly see the application which is at page 94. An advocate, it's not by the party, an advocate, he files a affidavit. Mandatory provision is given, go by page 94. This, please to permit the petitioners to comply with the order 39 rule 3. Order 39 rule 3 says that it should be immediate.
You take out notice.
My lord,
You
I have
serve the
sought-
council.
I have sought for an interim order
Not
because
ex parte. We'll pass an order. Emergent notice to the respondent. Petitioner is permitted to serve counsel appearing before the commercial trial court.
it is the arbitration.
Trial court.
Trial.
Before the
Before-
tribunal.
Yes. Not tribunal, ma'am.
Ah.
Trial court.
Before the trial court.
Yes.
Relist the matter on 8th.
7th. Location.
Yes.
Appear for petitioners, my lord. My lord, in this case, the petitioner number 1 and petitioner number 2 are the daughter-in-law and grandson of respondent number 2. Similarly, respondent number 3 and 4 are also daughter-in-law and grandson of respondent number 2. There are totally 4 children to respondent number 2.
There would be,
Two
in light
sons
of the
and-
contentions raised, there would be stay of the order
Yes.
at annexure A.
Annexure A.
Emergent notice to the respondents 2 to 4. AG accepts notice for the first respondent.
Copy
Yes.
has not been served on me.
Serve copy, senior citizens. Matter. Yes, next.
12. WSK.
For the petition. This is a matter pertaining to the subvention scheme, Millards, wherein the builder, in spite of the cancellation request,
All
has
matters
failed
we
to
are
honor.
staying.
My lord.
All
Yeah.
matters subvention scheme we are staying.
Please,
because,
in fact, earlier there is
Just
an-
1 minute.
So sorry, Millards. So sorry.
On the premise that the loans are being released without reference to the stage of construction.
I do agree.
Any of the matters.
My only contention is that where these type of similar matters, where the Union of India is made a party, we have no direct nexus or direct contact with any of the loan transactions between the
No,
parties.
correct. It's only
So we have filed many of the memos directing us, we might be deleted from the proceedings and this.
correct. The Supreme Court in one of the matters.
Yes.
Is now hearing.
Himanshu Singh. So sorry.
Is now hearing whether CBI inquiry, what is to be done because of the builder nexus. So you stay, we'll see. You must be there. So when
Only
some
contention is-
direction.
No, we will have no role to play.
No, correct. If some inquiry is ordered, you must be in a position or be informed of what is happening. In that sense, you are necessary. You have to wait. Let us see.
In many matters in the previous roster, we have just filed applications and we have been permitted to be deleted from.
No, that may not be. You just wait. You are there.
In fact, we have sought a prayer for direction against them as well, Millards.
Now, let us see.
That
That's
is
what-
the reason. Earlier order I have passed on.
It submits that in identical factual matrix, this court has passed orders restraining recovery from the homeowners as regards matters under subvention scheme. Reliance is placed on the order passed in WP number 14717 of 2025. In light of the same, respondent number.
Millards, respondent number 5, Millards.
Respondent number 5 is restrained from taking any coercive steps for recovery insofar as the loan account is concerned.
Please.
Land Council MB Chandrachud appears
For respondent number 3.
3. Emergent notice to the other respondents. Petitioner is at liberty to serve standing counsel if any for the institutional respondents. List along with WP number so and so.
My only respectful submission was not in any other way, my lord.
No, we understand.
The respondent number 3, there's no prayer, no pleadings. Even there is no prayer against the respondent number 3. It's the Ministry of Finance. So that is the reason why we were instructed in all these particular matters where there is a matter of the loan transaction between the petitioner and the banks.
Correct. For the larger issue and large macro, any direction is to be passed, you may be required. We'll
No,
see.
RBI, I'm not speaking about.
No,
RBI.
correct. Government may be directed to take appropriate steps. Okay.
Maybe, Your Honor.
If
I
they-
just leave it to your lord.
Let us see. Yes.
Right, that's the only submission which I just wanted to bring it to the knowledge of the court.
Let us see.
13.
This matter for the petitioner. At the sought for the mandamus to consider the representation at Annexure C.
No, now it has been rejected.
No, my lord. See, what they ordered is, my lord, I have to deposit that gun, my lord. On the basis of that, I surrendered the gun to the jurisdiction police. But till today, my lord, they are not ready to consider my representation.
My lord, there are two different aspects to this. If your lordship may kindly see, he says he has preferred under 18 of the Arms Act, if the licensing authority revokes the license for any reason and also suspends the license, then
Arms
appeal lies to the the
That
government,
appeal we
that is
have
the Additional
filed.
Chief Secretary of the Home Department. But here, my lord, what has happened is the representation of the year 2022. And in 2022 itself, he says he has deposited the weapon way back in 85 because there was discrepancy in his name. He had sought for a change of his name. There was some confusion over the name. Then my lord, the licensing authority has revoked his license. Now that he says he has challenged in his own representation, my lord, which is at page 20, which your lordship may kindly see annexure C. In the last paragraph, he says, ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬಂದೂಕು ಪರವಾನಿಗೆ ಕೊಡದೆ ಇದ್ದುದರಿಂದ ಗೃಹ ಕಾರ್ಯದರ್ಶಿ ವಿಧಾನಸೌಧ ಬೆಂಗಳೂರು ಇವರ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿಕೊಂಡನು. ಆದರೂ ಸಹ ನೆಪ ಮಾತ್ರಕ್ಕೆ ಪರಿಶೀಲಿಸಿ ಪುನಃ ದಾವಣಗೆರೆ ಜಿಲ್ಲಾಧಿಕಾರಿ ಮೇಲ್ಮನವಿ ಕಡತಗಳನ್ನು ಕಳುಹಿಸಿ ಕೈ ತೊಳೆದುಕೊಂಡರು. No, my lord, he does not even say whether that appeal of his was disposed on merits or even reverted back to the licensing authority.
What has happened to that?
On the basis of that, my lord, Deputy Commissioner has passed an order in there of 2012. Immediately, my lord, I means surrender that gun. My lord, kindly come to the last para, my lord, page 21.
My lord, there are two different aspects again, my lord. The weapon surrendering. Surrendering the weapon and depositing the weapon.
I have a certified copy, my lord, in
the procedure is, my lord, during the course of elections, or even there is 144 proceeding declared in this thing. All weapon holders, license holders have to deposit the weapon with the jurisdictional police which they have. So that is a preventive measure. If the weapon is not returned, then his grievance is different. Here he says if he has surrendered his license, then he has given up that license. If he wants a fresh license, my lord, then he has to make a fresh application.
What has happened to
Lord,
this?
on the basis of that, my lord, Deputy Commissioner has passed that order. In the morning, my lord, my client has handed over it. Kindly see the operative portion, my lord.
Copy.
So yes, I'll ಕೊಡ್ತೀನಿ xerox ನನ್ನ ಹತ್ರ.
You examine it.
I will check your instruction.
Copy
I'll accept notice for R1 and 2, my lord.
of order passed by the Deputy Commissioner is filed along with the memo. The say of the government, relist on. Yes. AG accepts notice for the respondents. Yes, next.
Grateful.
14.
This case I have challenged the notices issued by the Registrar of Companies, my lord.
Yes.
Lord, in fact, CIRP proceedings are pending before the National Company Law Tribunal, Bangalore, my lord. Lord, section 32A of the IBC, Lord.
Why are you coming when pending? Matters are pending still.
Lord, the ROC has issued a notice saying that I have violated few provisions of that is the corporate debtor has violated few provisions of the Companies Act, and it has imposed penalty on me, my lord, by issuing notices under section, by issuing notices as per annexure F, G and H, my lord. Lord, these offences, what I am alleged.
Don't you have any provision under the act?
No, my lord. In fact, this issue was precisely the issue before Bombay High Court, my lord. when once the CARP proceedings have commenced, my lord, even if the prior to the date of commencement of the CARP, my lord, if there are any allegations of offences committed by the company, my lord, that will cease to exist, my lord. Kindly see 32A of the IBC, my lord, for a moment, my lord.
But how is there a moratorium for criminal matters?
Yes, my lord. Not criminal cases, my lord. These are all civil kind of penalties only, my lord. Not maintaining the registered addresses and not maintaining the minutes of the meeting, not having full-time office bearer. Liability for prior offences.
Just one minute. It has been approved, is it? Resolution plan?
Lord, it is pending before the NCLT, my lord. I am told today is the date before the
So
NCLT,
let
my
us
lord.
see, let us see. I'll have it next week. If it's approved, there ends the matter. If it's approved, there ends the matter.
My lord, this
You're saying
notice issued by,
commencement, huh?
this notice issued by the ROC, my lord, will have the effect of resolution applicant backing off from the proceedings before the NCLT, my lord. Because such a notices cannot be issued by the ROC at all, my lord. Lordship, kindly see annexure F, G and H for a moment, my lord.
No, when is the notice issued? Is it issued after the IBC proceedings?
Yes,
have
my lord.
started?
In 2022, IBC proceedings have commenced, my lord. In 2025, my lord.
When did it commence?
Your lordship, kindly see in annexure A, my lord. Annexure A at page number 26, my lord. On 6/1/2022, my lord. Copy of the order of the NCLT initiating CARP proceedings. And order of moratorium is at annexure B, page number 34, my lord.
6/1?
6/1/2022, my lord. Annexure A, page number 26.
This is an order accepting.
Yes, my lord. Initiating CARP proceedings in respect of.
When is the notice issued?
Lord, notice is at annexure F, G and H, my lord.
In light of the submission that notices have been issued at F, G and H.
F, G and H, my lord.
Regarding penalty with regard to provisions under the Companies Act after the initiation of proceedings under the Insolvency and Bankruptcy Code, there would be stay of F, G and H till the next date. Emergent notice to the respondent. You serve the standing counsel.
Yes, sir.
Petitioner is able to serve standing counsel for the respondent. Yes. Yes.
The petitioner is an eyewitness in a murder case. But the accused number one, not either rowdy shooter. He started threatening not the petitioner.
He started
threatening the petitioner. So he filed a complaint not before the police and not the police treated it as NCR. Thereafter, he filed an application for.
No, just 1 minute. Petitioner is a
eyewitness.
Eyewitness
in a murder case. So, not the accused number one is a rowdy shooter, and he started threatening this petitioner not to give any statement. In fact, 164 statement is also recorded. But the complainant petitioner herein not filed a petition before the jurisdiction police to give protection. They did not give. But thereafter, not he also gave one more application that I will engage myself my protection. That is also rejected. In fact, there is a scheme called witness protection scheme.
Find out.
And in fact, it is the duty of the state to protect.
Yes. I'll have it. When do you want? Shortest date.
But
it is a very serious apprehension. That's the duty to protect the witnesses. Witness protection scheme is on paper or in the wind.
But in fact, the Honorable Supreme Court has also given guidelines stating that it is the duty of the state, at least till the rules are made or some enactment is done.
Now I'll pass an order to give whatever protection, at least on the dates of hearing. Dates of hearing, you must escort when they are making.
But I don't want the police protection. At least not permit me to engage my own private.
I'll have it on Monday. You find out. AG accepts notice for respondents 1 to 4. Relist the matter. Same stage on Monday. Actually, we can ask the Legal Services Authority also to involve itself because their directions to implement the witness protection scheme.
Isn't
Well,
it?
let my learned friend only my lord make it, my lord, otherwise it may consume some time. In fact, he is unable to come out.
Monday,
Please, my lord, bless.
in the preliminary hearing is, now you find out. No, we'll see, let the legal service authority be there. At your expense, let the society be benefited.
If that is done, my lord, it's very good. Even if they are, when, no, so far as not my application is concerned, but they are not allowing me
Now,
to.
what I was thinking,
Please, now
that
bless.
in this matter, we can give some directions also. So the rules, let it be implemented. We will give your private.
But in fact, but I searched not for some authority not of this honorable court. There is no such authority not except not the honorable Supreme Court.
My lord,
But this may be
no,
made
then-
not mandatory wherever not such
Correct.
witnesses come before the
We'll
authorities.
We'll issue some directions.
My lord,
Obligation.
similar matter had come before the coordinate bench, my lord. There is an order of the coordinate bench of this court, my lord. I will give the order where the Supreme Court has said witness protection scheme, setting up of safe houses to vulnerable witnesses where there is a real-time threat, not to all the witnesses that they are involved in this matter. Then, my lord, in Dharwad bench, there is an order. I will supply a copy to my learned friend.
We'll have
In
it
fact,
on
a similar matter had come up before the court.
There must be an assessment also.
No, in certain, yeah, the real-time threat assessment should be there. And in case if they want any police security and escort, it cannot be mandatorily given, but even at the cost of the witness also, my lord, it's given. It is very clearly Supreme Court has said it's a vulnerable witness, my lord.
Correct, that
copy
we'll
will-
see.
Yes,
That we'll see.
But in
That you
fact,
get
not
instruction.
report of not the ACP says, put CC camera, put not that visiting book, etc. That may not help us.
Let us see. We'll see. The member secretary, High Court Legal Services Committee is to be notified regarding the present matter and is to file an intervention application. Copy of the order to be communicated. Yes.
Obligation.
16, giving a Simon.
My lord, I appear for the petitioner. My lord, petitioner is a journalist, my lord, running a fortnightly magazine. My lord, bringing in various instances of corruption to the notice of the public. My lord, my lord, the present proceedings are challenging the order at Annexure H, my lord, wherein the Deputy Superintendent of Police has granted permission to the Inspector of Police to open rowdy sheeter proceedings against me, my lord. My lord, there are 5 proceedings, my lord, which are pending against me, which are mentioned according to the said endorsement. And my lord, I have an interim order of stay from this honorable court with respect to 3 proceedings. And with respect to 1 more proceedings, my lord, there's an order of acquittal. There's only 1 case pending and there's no conviction till date. My lord, according to clause 1059 of the police manual, my lord, the permission of Superintendent of Police is mandatory to open a rowdy sheeter. My lord, how the rowdy sheeter has to be opened is being discussed in the judgment of B.S. Prakash of this honorable court. My lord. My lords may take Annexure J for a moment. My lord. At page 31. My lord, the relevant paragraph is at page 48. My lord, there are 9 guidelines, my lord, issued by this honorable court as to how the Superintendent of Police has to take the procedure of including a person in the name of rowdy sheeter. Page 48, my lord, paragraph number 9. Lords may take serial number, sub-serial number 3, my lord. In terms of clause 5, order 1059 of the manual, the Superintendent of Police or the subdivisional police officer shall not accord approval for entering the name of individual concerned to the register of rowdies without calling for records and objectively considering the same.
They are saying they have not taken note
No,
of
my
that.
lord. My lord, the permission was sought on 28/7/2024. Permission was given on 29/7/2024. My lord.
I'll have
Lords,
it- Just wait.
please.
I'll have it on Thursday. Just find out. Now, if you have not followed, the procedure, it has to go. Just find out on that. AG accepts notice for response 1 to 6. Release the matter in the preliminary hearing list on Thursday.
Please, grateful.
Yes.
17, Maitreyi Krishna.
Yes.
The petitioner has filed the application regarding the Public Information and Revenue Department, my lord, for the order seeking of RD 32 LA D62. After the first applicant only, we got the information of the maps and other things. Kindly take, we take it to Annexure A, my lord. The Xerox copy of the order is already be presented.
No, no, what are you seeking to set aside now?
Not set aside, my lord. We are seeking for the certified copy of the order, my lord. And the order documents, maps, and all the proceedings of the.
Annexure A is the Xerox copy, is it?
Yeah, Xerox copy, my lord.
No,
We
yeah,
need the certified copy of the.
Huh?
We need the certified copy of the.
Now, what is the endorsement given? What is the final order of the Information Commission?
The Information Commission has been stated that they don't have the information regarding the issues, my lord. It's an Annexure D, my lord. After the second applicant only.
Page? Annexure L.
Annexure L, my lord, 49. Page number 49.
Okay, you take out notice, we'll fix it, we'll find out. Now, this is the Annexure A is which department of the government?
Revenue Department, my lord.
Department, I accept notice for R2 and 3, my lord. R1, Sharad Gowda appears for information.
Joint Council, Sharad Gowda is directed to accept notice for first respond, AGA for 2 and 3. Now, if this annexure is furnished by them before the commission.
Yeah, my lord.
Then
I
you
will
find
check
out.
out the instruction.
Huh?
I will check out the instruction. As to
Find out. If this is so, you give certified and it will
It'll
be
end the
closed.
matter.
List the matter in preliminary hearing list on. Third, yes.
Much obliged.
Priya?
Yes, yes, you must say, not yeah, yeah. Yes, yes.
First appearance.
Huh?
This is my first appearance.
So they have not told you, even before first appearance, you must know.
Okay. Sorry, my lord.
Okay.
18?
I'm appearing for the petitioner, my lord. My
Yes.
lord, the petitioner is a registered Residents Welfare Association of the Providence City Wellworth Apartments. So the grievance here arises from the fact that there was naked electricity wires in and around the swimming pool area. Multiple complaints were raised by the petitioner, and despite no action being taken,
What is G?
Annexure G, my lord, is a representation to the district magistrate to make the conditional order absolute, my lord. The district magistrate had passed a conditional order to remove all the naked electricity wires and to make good the nuisance. And then an on-spot investigation was directed to be conducted by the Tahsildar. And the Tahsildar's report stated that there was presence of naked electricity wires. Now that there was continued violation, despite the conditional order, it ought to have been made absolute. The matter has been pending disposal, my lord. Therefore, we are requesting that a direction may be given to the district magistrate to make the conditional order absolute by considering a representation, my lord.
Find out.
We'll accept notice, my lord.
AG
Copy
accepts notice
copy
for
is
the
not served on us.
respondent. You serve copy.
Copy.
List the matter in preliminary hearing list on. Just find out.
Yes, madam.
19?
Much obliged, Lordship.
Yes.
Recreation club.
Recreation club. ನಾವು ಒಂದಿನ ಒಂದು ಮಾಡಿದೀವಲ್ಲ ಒಂದು ಆರ್ಡರ್. So we'll dispose it off. I think some order we have passed, isn't
So
it?
there, last week your lordship had passed.
That you give that number on same terms.
Yes, ma'am.
Huh?
So
Dispose.
in that matter, it was for registration. No NOC is not required.
No,
for-
correct, not that. One more matter. We said that unless some action, you recall.
Unless the police do
Unless some offense is made out. You recall, you appeared or you appeared?
No, I appeared in.
In
One
which,
matter was relating to NOC not being required for registration.
not that. This is not to interfere. Some order we passed.
Unless they interfere.
Correct, correct. Unless they do some illegal act. AGA accepts notice for respondents. Matter is disposed of in terms of order in WP number so and so. The petitioner has sought for Issuance of writ of mandamus to direct respondent number 2 to 4 not to interfere in the activities of the recreation club. It is noticed that the facts made out and grounds urged require a direction to be passed as passed in the order in WP 15303 of 2025. Order in WP 15303 of 2025 reads as follows. Next, accordingly, the present petition is disposed of in light of the observations made in para 3 as extracted above. Accordingly, petition is disposed of. Yes.
20.
Yes.
Second round litigation for license to the running of homestay. The first round litigation, my lord, annexure G, running page number 36, wherein this honorable court order made a specific order with respect to the, my lord, approach the competent authority. Accordingly, my lord, annexure K, running page number 44, last annexure of the writ petition. The Panchayat, PDO of the Panchayat, Kannamangala Gram Panchayat Devanhalli, who has stated that, my lord, ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದಂತೆ ಕನ್ನಮಂಗಲ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯ ಜೇಡ ಗಾರ್ಡನ್ ಬಡಾವಣೆಯ ವಿಲ್ಲಾ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಅವರಲ್ಲಿ ಈ ಹಿಂದೆ ಜೇಡ ಹಾಸ್ಪಿಟಲ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿ ಮಾಲೀಕತ್ವದಲ್ಲಿ ನಡೆಯುತ್ತಿತ್ತು. ಪ್ರಸ್ತುತ ಸಿಲ್ವಿಯಾ ಮೆರಿಜೆ ಅವರು ಆದ ನೀವು ವಿಲ್ಲಾ ಸಂಖ್ಯೆ
NOC now by the
Panchayat. Now, my lord, police has annexure A, my lord, which I have challenged before this honorable court, running page number 16, my lord. Police has stated that, my lord, earlier there was one crime, so that now, my lord, I have purchased that property. The earlier crime which has, my lord, happened in that villa, maybe villa number same, that now ownership and title of the property is changed in favor of the, my lord, petitioner. The police endorsement is like this, my lord. ಸದರಿ ಹೋಮ್ ಸ್ಟೇಗೆ ಸಂಬಂಧಿಸಪಟ್ಟಂತೆ ಅಕ್ಕಪಕ್ಕದ ನಿವಾಸಿಗಳು ವಿಚಾರಿಸಲಾಗಿ ಪ್ರತಿಕೂಲ ಅಭಿಪ್ರಾಯ ನೀಡಿದ ಕಾರಣ ಜೇಡ ಗಾರ್ಡನ್ ಓನರ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಮತ್ತು ಸ್ಥಳೀಯ ಜೇಡ ಗಾರ್ಡನ್ ನಿವಾಸಿಗಳು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿರುವ ಕಾರಣ ಹಾಗೂ ಸದರಿ ಹೋಮ್ ಸ್ಟೇ ಮೇಲೆ 2022ನೇ ಸಾಲಿನಲ್ಲಿ ಸಿಸಿಬಿ ಅವರ ಅಕ್ರಮ ಚಟುವಟಿಕೆ ಪಡೆಯುವ ಬಗ್ಗೆ ಮಾಹಿತಿ ಪಡೆದು ಹೋಮ್ ಸ್ಟೇ ಮೇಲೆ ದಾಳಿ ಮಾಡಿದ್ದು 2022ನೇ ಸಾಲಿನಲ್ಲಿ ಕೆಂಪೇಗೌಡ ಅಂತಾರಾಷ್ಟ್ರೀಯ ವಿಮಾನ ನಿಲ್ದಾಣದ PS ಮೊಹರು ಸಂಖ್ಯೆ 74/22 ಕಾಲಂ ನಂಬರ್ 345 ಆಫ್ ITP Act ಮತ್ತು 370 ಆಫ್ IPC ರೀತಿಯ ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿ ತನಿಖೆ ಕೈಗೊಂಡಿದ್ದು ಸದರಿ ಪ್ರಕರಣವು ಪ್ರಸ್ತುತ ಮಾನ್ಯ CCH ಕೋರ್ಟ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೆಯುತ್ತಿದ್ದು SC ನಂಬರ್ 1 so and so ಆಗಿದ್ದು ಮುಂದಿನ ವಿಚಾರಣೆ ದಿನಾಂಕ so and so ಆಗಿರುತ್ತದೆ.
Now the village panchayat is given NOC. Yes. Now your inquiry should be independent of it.
That is against the earlier owner, my lord.
Now they are saying the new ownership.
Yes, my lord.
Whatever it is, it's only limited to that. In case there is a violation, they can't do. Any business can be carried on.
Yes,
unless there is something going on or they've given a direction to him, he's not following. Only in such circumstance you can deny an NOC. Otherwise, you must put him on terms.
Please.
When do you want?
Monday.
You find out.
We'll find out. There. No
You can impose conditions, but you can't say you can't carry on. That is not within your power. EGA is directed to accept notice for respondent 1, 2, 3.
Yes, my lord.
Now we are only seeking for setting aside of the endorsement.
Endorsement, that's all.
So the others we can say deferred for the present.
Please.
Eventually he has to take from everybody. Now only on your endorsement.
Endorsement.
Notice to Kannamangala, Devaraja.
PDO has already given, my lord. Already given.
Notice deferred to respondent 4 and 5 for the present.
Only state, my lord, home department
This
has
is the matter in preliminary hearing list on. Yes.
Oblige.
My lords, 21, I represent the petitioners. This has become infructuous, please, my lords. It may be dismissed as being infructuous.
Counsel for the petitioner files a memo. In light of the same, petition is dismissed as the relief sought for does not survive for consideration. File a memo.
Please, my lords, I will. Oblige.
Creation Club. Annexure E, my lord, produced.
So same order.
Yes, my lord.
So I think we have to pass a order for all those. AGA accepts notice for respondents 1 to 7, same order.
23.
Yes.
Insurance, on amended section 166, my lord has issued notice.
Issue notice to the respondents. Yes.
24.
For petition.
Yes.
This petition is filed for the application for releasing the accused convict on parole. The petitioner is the sister of the convict accused. He has filed application to the jailer that he has not produced a consent document about the medical statement. Now he has produced the document about the
Get
medical.
instructions.
Yes, my lord.
AGA accepts notice for the respondents. Relist on parole matter. Relist on. Yes.
25, 26, Sergeant. 27. 27.
Authorized.
Withdrawal memo.
Counsel for the petitioner files a
Withdrawal
memo. Which reads as follows. In light of the same, petition is dismissed as not pressed. Yes.
8. 28. 7 by
Yes.
On behalf of the respondent bank lordship.
Yes.
I may be permitted to file statement of objection. They may be directed to go to the DRT lordship.
Yes.
This is the thing that the fraud had been played by the petitioner, and he, during the subsistence of the registered mortgage, he transferred the entire property to the another person lordship. That is there at the annexure 35.
27. 28.
In this case, my lord, on the request made by my client, my lord, the petition was allowed, and I was directed to pay the amount on or before 31st of December, 15 lakhs, and thereafter the remaining amount within January. But since I didn't get the particulars, in time I was unable to pay, and later I have paid, and they have also issued the no due certificate. And also.
No due certificate?
Yes, I have produced along with the writ petition, saying that the entire dues are clear.
Page?
5th May, my lord. Page number. Page number 22, my lord, annexure D. It is issued on 9th May. Page number 22.
I may permit, my lord. There are 2 loans had been given to the petitioner lordship.
That is some other property.
I may be permitted to finish my submission. There was relating to the first loan, which the petitioner is before this honorable court, and the second loan, that is the housing loan lordship. When, as per the RBI guidelines, when the petitioner or the borrower makes a default in any one of the thing, and it's classified as an NPA, the loans will be classified as an NPA. It is the borrower wise, not the account wise lordship.
Which is that?
The RBI guidelines, the dated 1/7/2011 lordship. That guideline was not been produced, and it is been followed by all the banks.
You produce it, let us.
Yeah, I will produce it, that guidelines. If lordship permits.
But suppose he releases one loan, how you can tag it with the other?
Yes, that is the thing I just want to make a submission. Because of that classification of all the loan accounts gets into an NPA, he approached it before the coordinate bank relating to one loan account lordship. And he got an order as per this attachment.
Your lordship, kindly see page number 12, my lord, annexure A, and page number 14, my lord.
And my lord?
14.
14 is the order of this honorable court.
Yes, last para. Upon closure of the loan account, the respondent bank is directed to return all the original title deeds to the petitioner within 2 weeks from the date of settlement. And apart from that, my lord, the other loan, what my learned brother is saying.
My lord, I may be permitted.
Just one. Now, 1 minute. Now, this WP 25958 is with respect to this loan account which is closed.
Same. There I was directed to pay 15 lakhs on or before 31st December, that I have paid. Then for the subsequent payment, I was supposed to pay, there no amount was mentioned, my lord. Therefore, I approached the bank, what is the amount due? They didn't disclose. And only in May they disclosed, and on 8th May, I paid the entire amount.
No, then you find, then you place that on record. Let us have a look.
That they are not opposed in the earlier saying matter, this is particular to this properties.
Once you have suffered an order
Yes,
with
Lordship.
respect to a particular loan account, it may not be available for you now to
My lord,
raise any
the
of
thing is, if there is an order has been passed by this honorable court with a direction, it cannot be pick and choose of a one particular point. And it is very clearly written at the page number 14, paragraph number 3. Page number 14, paragraph number 3 of this honorable court's order. In the event the petitioner fails to make any of the payments stipulated above. That means, my lord, the last date of payment was fixed on 31st January 2025. If the petitioner fails to make any of the payment before the stipulated date, this order does not have an valid to them.
So when was it paid?
It was on 9th of May 2025.
But don't be so technical.
No, we have already
You
initiated.
can't have a pound of flesh.
My lord, based on this order, we already initiated DRT proceedings on 4/4/2025.
Now he has paid it, isn't it?
No, the thing is, lordship, the property that is been attached in the second loan account had been forgibly has been translated.
That's a different matter.
My lord, the entire.
That's not it before this court.
No, the thing
What
is.
is before this court is only this loan
My
account.
lord, the NPA was relating to the borrower wise. It is not relating to the account wise.
Once you have suffered such order, you can't raise such.
My lord,
Why didn't you open your mouth in the before the coordinate bench?
My lord,
You have suffered. Have you challenged this order?
The order has not been challenged,
Let us-
and the date is he's not been paid in accordance with that order date also, lordship.
That's a different matter. He has paid it. You have given a note. Who told you to give him a no due
No
certificate?
due certificate only relating to this particular account.
That's all. That's all he's asking.
No, the thing is.
He's asking only the documents of this loan account.
The thing is, he has been already been attached with the DRT proceedings based on this order, lordship. Because the phone 4, he has not been paid anything. On 31st one, he
How
has
did
not
you
paid.
issue an NOC, no due certificate?
Notice, only he cleared that, the entire loan amount.
What is this?
Then
Is this an argument you're making
No,
before
no,
the
no,
High Court?
lordship, no, lordship, but thing is, we already initiated DRT proceedings.
So you call the man, we'll ask the manager to be present. I'll impose exemplary cost. There's a limit for stretching. No doubt I'm strict, but not, this is not the manner of
This is not
abusing the process.
It is
No,
not.
no,
the
you
case.
ask the manager to file an affidavit. Who's the concerned one? Regional manager or
Authorized,
chief manager?
chief manager and authorized.
The thing is, lordship, he has played the fraud on that particular thing.
Is this loan closed or not? You tell me.
This particular loan account had been closed, right?
There
no
ends the
issue.
matter. Don't attach any other adjectives to this matter.
No,
If the loan is closed, you have suffered an order which says give the documents. No doubt he has paid late. But after paying late, you have given no due.
Yes, that we have to.
Then that's all. I'm going to take action again. You let him file an affidavit. No
thing
due
is,
certificate is given on 9/5.
Yes, correct. Because the moment he cleared it, we given that one.
There ends the matter.
The thing relating to this particular.
There
matter,
ends the matter. No relating,
I
no
may be
further.
permitted to place that RBI guidelines, its lordship permits.
No. I'm not going to look into that. You are a party to an order of the coordinate bench.
Yes, sir.
Once the court has said, you have to give him, once he discharges the loan, there ends the matter. No further argument. This is not the way to stretch proceedings.
No, it is not. The thing is,
You
lordship.
you are an institution. You are not a private money lender. This is closed because of the order of the coordinate bench. Now you give him back his documents.
But the thing is, we already filed a complaint also before lordship. Lordship can able to peruse that particular complaint. In 2022 itself, we have filed the complaint, lordship. At the statement of objection, I have enclosed, lordship.
Annexure D is dated 9/5/25.
My lord,
Annexure D is dated 9/5/25.
annexure D is the no due certificate, the lordship is.
Is 9/5/25.
Yes, lordship.
There ends the matter. You have waived everything else. Come on, you have to be reasonable. This is not the way to deal with this. You are not some private money lender
No,
or
no,
a pawnbroker.
My lord, if the lordship can able to look into that fraud complaint that we have been filed in 2022.
How many times, counsel, you ask your chairman to appear through VC? Let us, the petitioner, you ask your chairman of the Canara Bank and your managing director to appear through VC. If this is how you are handling matters.
My lord, the statement of objection that is filed.
Petitioner, I am rejecting it. I'll ask him, ask him to appear through VC. Then the heat will.
The responsible person is the chief manager. He has been filed a statement of objection, lordship.
I'm rejecting that. I'm saying you You can't have such stand before the court of law. The petitioner has sought for issuance of a writ of mandamus to direct the respondents to return all the original title deed and other documents given by the petitioner at the time of borrowing the loan account, bearing number so and so. Full stop. It is to be noticed that the petitioner on an earlier occasion was before this court with respect to the same loan account in WP 25958 of 2023. Order passed is as follows. Next. It is clear that in terms of clause 4, Roman 4, that upon closure of loan account, respondent bank was directed to return all original title deeds to the petitioner within 2 weeks from the date of full settlement. Counsel for the respondent bank submits that the petitioner has not paid the amount within the time prescribed. It is to be noticed that the order was passed on 25th November 2024. Admittedly, petitioner has cleared all dues and NOC, no due certificate issued by the bank on 9/5/2025. Once the bank has accepted all dues, though paid outside the time schedule prescribed by this court, and a no due certificate is issued, it is not open for the bank to raise any fresh contention. Full stop. Admittedly, order at annexure has not been challenged. Now you have initiated proceedings against him.
Because he was not completed the entire payment within 31st of January 2025, we initiated the proceedings before DRT on 4/4/2025.
What has happened to that?
That is still been pending before the DRT. It is not been disposed of. I have produced that particular annexure.
How did you issue no due certificate?
Sorry, Lordship.
How did you issue no due certificate?
No, before issuing the no due certificate only we have initiated, Lordship, because
how did you issue the no due certificate?
Particular relating to that particular loan account, he had been cleared.
No, is it closed or not? You tell me.
This account is been that outstanding in that particular loan account number 1, it is closed, Lordship.
Then how are the DRT proceedings still continuing?
Relating to the loan account number 2, because it is
that's different. We are not touching that.
It is the outstanding of entire loan account number 1 and 2. It is been initiated, Lordship, because on that particular day of initiation, he was not cleared.
Now he has cleared, isn't it?
That is the thing, because both the properties had been attached, because he is the two liabilities. That is the thing that you just.
Is that property paper document also a security in the other loan?
It was totally two different securities. One is for business loan, one is for the housing loan, Lordship.
No, correct. I'm saying this loan of 399.
Yes, Lordship.
The property that was offered as security.
Yes, Lordship.
Was only for this loan.
Yes, this is for only for this loan.
There ends the matter. Then there ends the matter.
Because he is in the other security, whatever he given, that is before the DRT and club together along with this, that he has been sold and we have given the criminal complaints also.
That is different from this. Has not been challenged. No, but now if this loan is cleared, you give a no due certificate. How you are holding on to his document unless it is given as security?
My lord, when there was
given as security in the other loan.
My lord, when there is a particular thing had been declared as an NPA, we have to before DRT we have to attach that property, whichever he is having that, because we have to secure the entire debt. That is the thing. We have both the loans original document with the bank. It is not like we are being handed over. But when subsistence of that original document he had been transferred. Second security, we don't have anything. And that is the reason when there is a particularly the property had been owned by the petitioner. That is the thing we just initiated.
Why did you issue no due certificate?
Relating to that, because account is clear, Lordship. He has been paid. Then we cannot able to do it. But the thing is, he has been still having the debt. That needs to be cleared.
That is different, sir. That has nothing to do with this loan account.
But when there is a, both are NPA, that is the as per the RBI guidelines. That is the thing that I said, I may be
Then you
permitted.
should not have agreed before the single judge. Not been challenged. Full stop. If the bank has suffered an order, has accepted an order in WP 25958 of 2023, and despite there being minor lapses in repayment within the time prescribed, on issuance of no due certificate, unless the bank is required to adhere to the direction at Roman 4 extracted above. Full stop. Other contentions by the bank relating to the power to withhold documents cannot be accepted in light of petitioner, in light of the bank being party to the order in WP 25958 of 2023. Any objections of the bank for release are construed to have been waived upon acceptance of the order in WP 25958 of 2023. The respondent bank is directed to comply with the direction at Roman 4 within a period of 2 weeks from today. Accordingly, petition is disposed of. Needless to state, the rights of the bank as regards its dues in other loan accounts can be proceeded with in accordance with law.
29, 29.
Yes. So and so accepts notice for the respondent bank. Yes, 29.
29, my lord, this is porting of the information from the old software to the new software. The module was prepared, my lord. We had made a submission. I'll secure instructions in this matter.
Here is a matter, my lords, where the gifted minutes which has been registered, minutes has been kept under process and pending registration despite payment of stamp duty. Initially, minutes.
You find out.
Well, the crux of the matter is this, my lord. Whatever is the instrument that is registered, the case is not regarding the payment of the stamp duty. The case.
Because they're saying minutes
that from
exposed.
Just
Yes,
read.
yes.
It's a very simple thing, my lord. We have dealt this matter before. What had happened was there was Kaveri 1 software wherein manual uploading of documents were permitted. Now, my lord, the Kaveri 2 regime is in force. There was a problem initially, my lord. A lot of matters were heard before this coordinate bench. An order and direction was passed. I am informed that there was a module that was prepared to port all the information from Kaveri 1 to Kaveri 2 and then release the documents. The lordship may have it after a week's time, my lord. I will secure instructions and I'll
AG accepts notice for the respondents. List the matter in the preliminary hearing list on.
37.
Yes.
Sangamesh RP.
There was a very simple issue which was involved.
Let us see, let them make the stand.
That circular is ex post facto. That is all, minutes.
Some software, let us see.
ಹಳೆ registration ಗೆಲ್ಲ ಈ ಖಾತೆ ತಗೊಂಬ ಅಂದ್ರೆ
Let us see.
registration ಆಗಿಲ್ಲ, how am I supposed to get the e-khata?
Let us see. Yes, please.
30. Sangamesh RP.
Lords, 30 lords, this is a matter where there is an interim order, interim direction lords to issue the work order in respect of tenders where I have stood as L1. In spite of that, lords, they did not issue the work order.
My instructions, my lord, the officer is also present, my lord, that they will issue work order in a week's time, my lord. My instruction.
Your lordships may record that so that let them issue the work order to me within a time stipulation, lords.
Counsel for the respondent submits upon instructions that the work order would be issued in a week's time. Relist the matter on.
May I request, lords? May I request the presence of the officer because once we go there, lords, they will not even talk to me, lords.
Instructions off on the official. Relist the matter on.
1st of June, my lord.
1st of July. 1st of July in
Same stage.
Much obliged.
The connected matter, lords, is the interim order in which it may kindly be extended, lords.
Interim order in 30.1 is extended till the next date. Yes, next.
31.
Obliged.
For the Kevin respondent 4 and 5. My lord, a family temple is now declared
under section 43 of the Act, my lord. My lord, may I kindly see the section 40.
Yes.
Section 42. Declared institutions. The state government may, where it is satisfied on a report of the commissioner under section 43 or otherwise, that any Hindu religious institution, whether or not governed by a settled scheme, is being mismanaged, declare such institution to be subject to the regulation of this chapter. My lord, the first and foremost that there should be mismanagement. Mismanagement could be either financial or administration. Now, the complaint by there is no complaint by the family members. It is a family temple. That is defined under section 214.
No,
defined.
correct. Now what have they done?
Now, what they have done is, somebody gives a complaint that this temple is on a government land and that there is mismanagement. They have not kept the ornaments of the temple in the locker. It is not accounted. And the government, this state has provided for the welfare of the temple, therefore declare it as a declared institution under section 42. My lord, and the state shall be satisfied. My lord, kindly see the order impugned. The state does not say that it is satisfied the requirement of section 42, and that, my lord, it is my respectful submission.
There must be a report of the commissioner and
A report of the commissioner is available. I have placed it before the court, my lord. Inquiry report. At annexure N.
Page 83, my lord.
The Karanagalu is at page 83, ink page 83. It says, ಕಂದಾಯ ದಾಖಲೆಗಳಂತೆ ಕುಂದಾಪುರ ತಾಲೂಕು ತಲ್ಲೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಜಮೀನುಗಳ ಪಹಣಿ ಕಾಲಂ 9ರಲ್ಲಿ ಕುಂತಿಯಮ್ಮ ದೇವರ ಹೆಸರು ದಾಖಲಿಸಿದ್ದು ಕಾಲಂ 10ರಲ್ಲಿ ದರ್ಖಾಸ್ತು ಎಂದು ದಾಖಲಿರುವುದಾಗಿದೆ. ಫೈಸಲ್ ಪತ್ರಿಕೆಯಲ್ಲಿಯೂ ಸಹ ಕುಂತಿಯಮ್ಮ ದೇವರ ಹೆಸರು ದಾಖಲಿರುತ್ತದೆ ಹಾಗೂ ಸದರಿ ಜಮೀನುಗಳ ಚಿಟ್ಟಾ ನಕಲುಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ದಾಖಲೆಗಳು ಸಹ ಕುಂತಿಯಮ್ಮ ದೇವರ ಹೆಸರಿನಲ್ಲಿ ದಾಖಲಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. It is in the name of the deity. ಪ್ರಸ್ತಾವಿತ ದೇವಸ್ಥಾನವಿರುವ ಜಮೀನು ದೇವಸ್ಥಾನಕ್ಕೆ ಸರ್ಕಾರದಿಂದ ದರ್ಖಾಸ್ತಿನಂತೆ ಮಂಜೂರಾದ ಜಮೀನಾಗಿದ್ದು ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಉಭಯ ಪಕ್ಷಗಾರರಿಗೆ ಯಾವುದೇ ಹಕ್ಕು ಇರುವುದಿಲ್ಲ. Milord, how can that be? That is to be decided not in this proceeding. ದೇವಸ್ಥಾನದ ಪೌಳಿ, ಹೆಬ್ಬಾಗಿಲು ಹಾಗೂ ಗರ್ಭಗುಡಿ ನಿರ್ಮಾಣ ಕಾರ್ಯವು ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆಯ ಅನುದಾನ ಮತ್ತು ಸಾರ್ವಜನಿಕ ದೇಣಿಗೆಯಿಂದ ನಡೆದಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಈ ದೇವಸ್ಥಾನಕ್ಕೆ ವಾರ್ಷಿಕ ಸುಮಾರು 8 ಲಕ್ಷಗಳ ಆದಾಯವಿದ್ದು ಸಮಿತಿಯ ಅಧ್ಯಕ್ಷರು ಸರಿಯಾದ ಲೆಕ್ಕಪತ್ರವನ್ನು ನೀಡದಿರುವುದು ಹಾಗೂ ದೇವಾಲಯದ ಹಣವನ್ನು ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಪಡಿಸಿಕೊಂಡಿರುವುದು ಜಮೆ ಮಾಡದೆ ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. My lord, this is one. I have placed the statement of account of the temple that is not considered. Statement that is placed before the authority. ಈ ದೇವಸ್ಥಾನವು ಹಿಂದೂ ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆಯ ಅಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿಲ್ಲವಾದರೂ ಸಹ ದೇವಳದ
Just one, just wait, let us see. Now you take your stand.
No, we already declared, my lord.
Correct.
Order has been passed.
No,
At page-
order has been passed, order
Page
is
89, my
not
lord,
proper.
ಸರ್ಕಾರದ ಆದೇಶ,
Ah.
the last paragraph. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳನ್ನು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಡುಪಿ ಜಿಲ್ಲೆ ಕುಂದಾಪುರ ತಾಲೂಕು ಮಣ್ಸೆ ಹೋಬಳಿ ತಳ್ಳೂರು ಗ್ರಾಮಕ್ಕೆ ಶ್ರೀ ಮಹಾದೇವಿ ಕುಂತಿಯಮ್ಮ ದೇವಾಲಯವನ್ನು ಅವಸ್ಥಿತ ರೀತಿಯಲ್ಲಿ ನಿರ್ವಹಿಸುತ್ತಿರುವುದು ಮತ್ತು ಹಣ ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿರುವುದು ಹಾಗೂ ನಿರ್ವಹಣೆಯಲ್ಲಿ ಪಾರದರ್ಶಕತೆ ಇಲ್ಲದಿರುವುದು ಕಂಡುಬಂದಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿತ ದೇವಾಲಯವನ್ನು ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆಗಳು ಮತ್ತು ಧರ್ಮದಾಯ ದತ್ತಿ ಅಧಿನಿಯಮ ಸೆಕ್ಷನ್ 42 ಮತ್ತು 43 ಅನ್ವಯ ಘೋಷಿತ ಸಂಸ್ಥೆ ಎಂದು ಘೋಷಿಸಿ ಆದೇಶಿಸಿದೆ. He has to challenge this order, my lord.
This is what I have challenged, because unless there is an order, I cannot challenge it.
Now, my lord, the previous, whatever my learned friend read, those are the reasons why we have come to pass this order, to make it as a declared institution. Now, once it is declared, my lord, now the managing committee has to be appointed.
It is not yet appointed, my lord. What they will do is they will appoint an administrator to the temple. So far, it is not done. And the satisfied, the government should be, state should be satisfied. Where is the satisfaction recorded, my lord? It is not recorded. A report is received, verbatim report is reproduced, and they say that the order is passed. And it is a temple belonging to the family.
No, my lord, it is not a family.
It's a, it comes under section, subsection 14B. And the requirement of 42 is not satisfied.
Section 14B.
14B, my lord. Subsection 14B of the Act. Family temple.
Section 14.
Yes, subsection
14B of the
14B,
Act, my lord.
section 2, 14B, my lord, definition. Family temple means any temple established or maintained
Now you are
exclusively.
saying a family temple cannot be notified.
It can be notified, provided there is a mismanagement. My lord, mismanagement can be of a financial or administrative.
Now you
And
place-
that it should be
I will
satisfied.
Place the
Place it
entire
on record. Place
I
it
will
on
place
record.
on record, the entire record which has led to passing of this
Let
order.
us,
Lord, may I make
Yes.
one submission?
let us see, we'll see. Now, the only point is, when you're taking over a religious,
Please, Lord, that the temple
Institution.
itself is on a government land.
no, but when you're, maybe, let us see.
Yes.
When you're taking a religious institution hitherto being run,
Yes.
interference must be only if strong grounds are made out.
Yes. I will place the entire record before the court.
Subject to further consideration. Respondents to maintain status quo as on date insofar as the institution is concerned. AG is directed to place before the court records justifying leading to initiation of proceedings under section 42, 43, 42 of the Act.
42, my lord.
Yeah, you place it on record. You appear
43,
for,
43 culminates into 42.
yes, you
I appear for respondent number 4 and 5.
4 and 5.
Lord, on the basis of the complaint of my lord, my lord, I was secretary of the temple. Lord, on the basis of the complaint of the secretary and other public, my lord, it is not a family temple, my lord. It is a, my lord, the government temple, because land was granted by the government in the year
Who was
2005.
managing till date now?
My lord,
Yes.
they are managing illegally, my lord, since last 20 years. In between, my lord, one committee was constituted. My lord, they approached the assistant commissioner and they obtained an interim order. Against that, we filed a writ petition before this honorable court, and this honorable court, my lord, directed the commissioner to conduct an inquiry, my lord, in the year 2018. My lord, till 6 years, my lord, inquiry is going on. In the meanwhile, one more writ petition was filed by these petitioners. My lord, lot of public money was
So
misused
that
by the.
inquiry report, you place it before.
Even my lord, assistant commissioner has filed an, my lord,
My lord,
inquiry.
as
That
it-
report they have not produced along with the petition. Only, my lord, commissioner report they have enclosed along with the writ petition. My
I will
lord,
place
commissioner
the
has
entire
authorized
file,
the assistant commissioner to conduct an inquiry, my lord.
You place it on record.
Please. Even I will also file my objection, my lord, in the meanwhile.
AG accepts notice for respondent 1 to 4. Emergent learned counsel, Prasanna Shetty appears for 5 and 6.
Please.
Relist the matter. Date for after 10 days. 10 days are
Because it is not a hereditary temple. My lord. If it is
It is-
hereditary trust, hereditary
My lord,
temple, my lord, we don't
it
have
is
any.
not my claim that under 25A, my lord.
But I'll.
3rd of July. 3rd of July.
Please. Grateful. Lord.
Serial number 32, Sangamesha B.
My lord, appearing for the petitioner, my lord.
Yes.
My lord, in this writ petition, we have sought for quashing of the endorsement issued by the respondent number 1, my lord. The crux of the matter is that, my lord, the father of the petitioner was an authorized dealer, my lord, who authorized to, and he was running a fair price depot, my lord. On 8/8/2024, my lord, the father of the petitioner expired, my lord. And the authorization was initially granted in the year 92 to the father of the petitioner. My lord, subsequently after his death, we gave a letter stating to transfer the name to my name, that is the son of the deceased person. My lord, they issued an endorsement stating that you are not eligible since you have already crossed the age of 65 under the provisions of the Karnataka Essential Commodities Public Distribution System Control Amended Order of 2021.
Now this condition cannot be imposed.
My lord, this condition, my lord, and one more point for your lordship consideration is that,
Is
my
this
lord.
covered?
My lord, it is covered by judgment. It is here, my lord, at para 8.
What is the age of this?
My lord,
on
the age
on-
of the petitioner is 65, my lord. And also, my lord, point for
when did the father die?
on 8/8/2024, my lord.
Yes, what is the observation?
My lord, the observation made is that,
Paragraph?
my lord, para 8, my lord. Para 8, my lord.
In terms of
Also, my
observation-
lord, one more, please.
In terms of observation made at para 8, authorization was before 92.
Before 92, my lord. And one more point, my lord. On 1/1/23, my lord, the father of the petitioner he got renewed the license, my lord. Even at the time of the renewal, the age of the father of the petitioner was above 65 years.
The petitioner has called in question validity of the order at annexure A, which is in the nature of an endorsement, whereby the request of the petitioner to transfer the authorization into his name consequent to the death of his father has been rejected, placing reliance on condition under section clause 13.
Please, my lord.
Clause 13, full stop. It is to be noticed that in terms of the endorsement, it is clear that the respondent authority has observed that the petitioner had completed the age of, had attained the age of 65 years. And in light of the restriction under clause 13, which provides that the transfer of authorization cannot be made in the event the person in whose favor authorization is sought to be transferred is above 65 years. Full stop. It is to be noticed that the coordinate bench in WP 765 of 2024 at para 8 has observed as follows. Full stop. It is also noticed that the authorization in the present case was issued before 92.
Please, my lord.
When was it first issued?
My lord, it was issued, my lord. In number 90 to 93 it was issued, my lord. In the year 90 to 93, I'm not clear about the date. Oh,
Was issued under the control order of 92.
92, my lord.
If that were to be so, in terms of observation made at para 8 in WP number so and so extracted above, the said restriction is to be treated to be prospective and cannot apply to authorizations issued under the control order of 92.
Please, my lord.
Accordingly, the endorsement is set aside. The respondent number
1.
1 is to pass appropriate orders for transfer of authorization if all other legal requirements are fulfilled within a period of 3 weeks from today. 3 weeks.
Please, my lord.
AG accept accordingly. Let them dispose of these matters there without you please issue necessary instructions.
But the problem was that, my lord, they were not getting the sanction from the commissioner. Now they have got all the permissions. Now they
Much obliged.
Bill number 33, Puneet BS.
For petition in this case, my lord. Surprise acknowledge challenging pre-sale notice, my lord, for the respondent. 15 lakh is the outstanding amount, my lord. 15 lakh change, my lord. Ready to deposit 30%, my lord. 4 weeks time is granted.
Now, if they want to clear it, you want to give some time?
Please, my lord, I will clear it.
The outstanding, this thing as of now is my lord 17,32,000. 17 lakh 32. In fact, the petitioner had approached the bank for one-time settlement, but they are seeking for more, less than 50% of the outstanding. That is the reason why one-time settlement was rejected. Let my learned friend make some efforts and get the loan closed. It's a small amount. It's not a huge amount. Let the petitioner closes the loan account, because once they obtain the interim order, my lord, they do not pay, even pay for 2 or 3 years, and the matters are not being listed and the interim order being continued. That is the only difficulty what the banks are facing today. There is an alternative and efficacious remedy before the DRT. And moreover, they will seek for restoration once they pay that 30%. The physical possession of the property has been taken. Section 14 is under challenge before this honorable court. That has become infructuous now. We have taken physical possession of the property. Only thing what we have did is we have issued a pre-sale notice. See, we are giving you one more opportunity. If you want to pay the loan, kindly close the loan. We have not issued auction sale notice as alleged in the petition. We have issued pre-sale notice stating that kindly pay the loan or else the property will be put for auction.
My lords, even
Not auction sale notice.
Yes, so
even
no,
50% I am ready to deposit, my lords.
No, you pay it to them. The remaining within how much time you say? I'll ask them to look into it.
My lords, 50% within first 4 weeks, my lords.
No, correct. I'm not going to stay. You give them a proposal. I'll record the proposal.
Even after paying 50% only, the matter may be stayed, my lord. 50% immediately we are ready to.
I'm not going to grant any order of stay. You give a proposal on affidavit. I'll put it to them. And then they will undertake not to take any action if that affidavit condition is adhered to.
Please, my lord.
So 50%, then remaining how much, how you are going to pay, you give, you file.
I'll file an affidavit, my lord, for closure.
Relist
Day after tomorrow, my lords.
Relist the matter, the same stage. Learned counsel so and so undertakes to appear for the respondent. Relist the matter in the preliminary hearing list on
30th. Day after tomorrow, my lords.
The property is not put for auction.
Monday.
Grateful.
By then,
I'll file.
You show them what affidavit you are filing.
Let my learned
I'll serve copy prior.
provide the copy
of the affidavit in advance.
Please.
So he will get instructions from the bank.
Grateful.
Yes, next.
Bill number 34, Siddharth Suman.
One small submission. My name is shown as only C. Avinash, caveator. It should be B. C. Avinash.
Office to show the name of learned counsel representing the bank as B. C. Avinash.
B. C. Much of.
Lords, I seek for a short passover, my lords.
It won't reach. It won't reach.
It may be connected with serial number 15, my lord. The private protection there.
AG accepts notice for the respondent.
My lords.
List along with WP number so and so. Yes.
My lords, he's right here, my lords. If you can kindly.
I'm not deciding these matters. I'm clubbing it and hearing it and then going to pass order. Yes, next.
Please.
Yes.
Therefore, the petitioner in this matter, seek for a short pass over, maybe taken up with serial number 44, it's a connected matter.
It won't reach.
So serial number 44, it's a connected
Pass
matter.
over.
We taken up with
Yes,
it.
pass over. Next.
36.
And the petitioner is already served the respondent one bank.
My lord,
They
the
are
land
conducting
council,
the-
Vignesh Shetty will file undertaking wakalat for
Vignesh
Harvard.
Shetty. So what are your instructions, madam?
My lord, we are for Harvard, my lord, Bank of Baroda. We put property auction today, my lord.
Auction is there today.
Yes, ma'am. The petitioner is only the agreement holder, my lord.
The registered
Agreement
agreement holder
holder.
and also,
Agreement holder.
Agreement.
yeah, registered.
He entered agreement of after my mortgage, my lord. My
No, no.
mortgage in the year of 2008, my lord. They entered agreement on 2015, my lord.
Entered the agreement in
2015.
50.
Mortgage on 2008, my lord.
now you take part in the auction now.
No, I have already paid the 32 lakhs direct to the respondent one bank through check. And
My lord,
20
the
lakhs
outstanding-
respondent bank. Is the multiple attachments is there.
No. Now you want to clear the loan, you clear it. You want to clear the loan?
Yeah, I am ready to clear the, by way of special treaty, or the respondent 1, 2, 3. There is attachment of, if I pay respondent one bank, other bank also taken a,
My lord, the
Action.
borrower is not coming forward to pay it, my lord.
No.
It's an agreement.
the second respondent also announced an action. And third respondent.
Correct. So there's no escape from you from this.
No, I will negotiate with you. Conditional stay. You can stay
No
the
stay.
conditional stay.
No stay.
No, conditional stay.
I don't stay in any
No.
surfacey matter.
My advocate office also residing in the same premises.
No stay in any
What about
surfacey
Is
matter.
an humble request.
No. I
Is
don't pass
a
any.
hard
interim-
earned money.
I don't pass any interim
No,
order
any
in
third
any
party,
surfacey.
I will say that. 1 minute, sir.
It's between you and the bank. Now there are several claimants. So there is no way of settling this issue.
Lease registered order. If it is any fraud, the stay can be granted.
Sorry, you go before the DRT and you raise it.
Yeah, very difficult. If an action is proceeding is over, very difficult to stay
I'll ask
in
them
the-
not to confirm it for 2 weeks, you go there. I'll ask them
At
not to
least,
confirm it.
at
too.
least stay for 2 weeks. I can go for it.
And that I will pass.
Ah.
I will protect.
Yeah.
I will protect it for 2 weeks.
Ah.
And then don't confirm the sale for 2 weeks. You go ahead with the sale. I'm not preventing the auction, but don't confirm it for 2 weeks. Let him go before the DRT.
For stay for the time being. If it is, ನನಗೇನಾದ್ರೂ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ they can proceed.
They will not
They are
confirm
liberty to
this.
proceed the
They
action.
will not confirm the sale. That is the protection I'm going to give you.
For stay action, there is a humble request because I am residing in this advocate office in same premises. I have paid the 33 lakhs about the respondent one, 20 lakhs for the
You
respondent
can't
two.
settle this problem. You can't settle this problem because there are multiple borrowers.
Like multiple attachments is there. I have to negotiate with this special treaty.
So
That is
go
my
before the
humble
DRT.
request.
Go before the DRT.
No, I am ready to purchase. No, in the sense of special treaty. No, stay for the action. Time being, if it is disobey, I can vacate the action.
Yes, what do you say?
ಅಲ್ಲ ಹೇಳಿದ್ವಿ ಅಲ್ಲ ನಾನು ಸ್ಪೆಷಲ್ ಟ್ರೀಟ್ ತೊಗೊಳ್ತೀನಿ, ತೊಂದರೆ ಏನಿಲ್ಲ. ಐ ಆಮ್ ಇಂಟ್ರೆಸ್ಟೆಡ್, ಸೆಕ್ಯೂರ್ಡ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ. ಅಲ್ಲ
You ask
ನಾನು
Vignesh-
ಸೆಕ್ಯೂರ್ಡ್ ಆಮೇಲೆ
you ask
ಮೋರೋವರ್
Vignesh Shetty to appear, pass over. Yes. It's you must negotiate with the bank. Don't expect the court to pass an order. Yes.
37.
This is a covered matter, my lord, your lordship. Next year, F series. Seeking similar directions, my lord. May kindly see F3, my lord, page 42.
Same order as in
Page 42.
serial
my
number?
Serial number 22, my lord.
Yeah.
19 and 20.
AG accepts notice for the respondent. Same order as in serial number 19. Yes.
38, 39. 39. Sirajuddin Ahmed.
This writ is not maintainable with this
For
court.
petitioner, Lord.
30.
39, Lord.
In all other matters, you have taken adjournment.
Yes, Lord. Yes, Lord.
2 matters have taken urgent
So what is special about this matter?
for parole lordship.
Huh?
For parole lordship.
Let them verify. You find out.
I'll find out, my lord, because police have given
AG
me
accepts notice. No, I'm saying you adjourned all other matters, so
Well,
except this. So I'm asking you, what is so special about this matter?
Actually, senior is busy in that.
Huh?
Senior is busy in trial court. lordship.
AG accepts notice for the respondent. List. Date. Yes.
40. Suman Kel.
I appear for the,
For petition minutes.
the writ itself is not maintainable, my lord. He is seeking for appointment as a guardian.
So you heard.
Yesterday I
what-
heard mirrors, but my was
Correct. So you will have to get a declaration under the guardian and what.
Guardianship Act matters, it deals with the persons in case of minors.
Ah.
Here, the person to whom we are seeking guardianship is aged up to 40 years. She is parentless, mentally retarded, unmarried, uneducated girl.
But there must be some provision.
Well, sir, in similar circumstances, very recently, April, this honorable court passed an order appointing the wife to be guardian of
No,
husband.
correct. What is the substantive provision under which you're getting a guardian appointed?
Well, there, it was discussed, when there is no specific law.
No,
220,
how do you say there is no specific law?
that is observed in that judgment.
That petition, my lord, where the husband is in a vegetative state, the wife was allowed to operate his account.
Kindly see the prayer, the
Nothing to
first
do. My lord,
paragraph.
what happens is.
The petition before this court
Factual
seeking
aspect is
following
completely
prayers.
different between this judgment and this, my lord.
No, facts are identical, my lord.
And why do you say under the guardian and wards act there is no provision?
Plus, it deals with the case in which minors are minor, only for minors it was applicable.
Minor.
For minors, the act is applicable, my lords.
But here is a case where, my lord, the.
There no provision for appointment of guardian.
No, this is discussed in this judgment.
Of
my
a-
lords. By relying the judgments of
No,
Honorable
my lord. There
Kerala
it
High Court
says-
and Apex Court, this judgment was delivered appointing the wife as a guardian of husband, since he is in a vegetative state.
What about mental health act? Mental health act?
It is, that is also discussed, my lords.
No. Mental health act has a provision. Mental health act.
But here, what has happened is.
Section 52 of mental health act.
Well, sir, page 12, my lords, in the judgment.
No, why do you say mental health act doesn't apply?
There, my lord, even in the judgment at page 10, it is discussed. The mental health act provided for appointment of a guardian for mentally ill person. Now this.
Now
this,
what is the ground now you are seeking appointment?
Mentally retarded.
Well, as recently, doing a
No, on what ground you are saying that she is mentally invalid, is it?
mentally retarded, my lords, I have produced the
Correct.
certificate.
So go under the mental health act.
Yes, my lord.
Unless you say it's not applicable.
My lord, what has happened here is there is some property also involved. This disputed questions of fact, they will have to go to the civil court, declare before the civil court, because the civil court is the custodian of all the when there is no natural guardian, my lord.
Now you find out and you let me know. Why guardian, the mental health act is not applicable, is there no procedure?
No, my lord, it very clearly says the act conferring the power upon the district court to pass an order under section 53. And
You're reading
appointing
at section?
53 of the Mental Health Act.
You just verify that and you come back.
Please, my lords, actually, it was discussed in this judgment also.
No, correct. If there is a separate provision under an act for appointment of guardian, I will not exercise this power of a writ court. You find out if there is no provision, you make a submission.
My lord, this case was a limited purpose for the husband to be in a vegetative thing. There was a direction sought by the wife to operate the accounts of the husband to pay the medical bills. My lord, however, it is discussed about the Mental Health Act, but here she was not appointed as a guardian. Tomorrow the husband may regain his consciousness and then he can become a normal person.
Examine this point. examine. AG accepts notice of the respondent. This is the matter in preliminary hearing list on 9th of July.
Some earlier date, my lord.
So let us see, you make out, once the legal position is clear, you file a memo
Please.
for disposal, I will take it up.
Certainly,
And you share it with the government advocate, let him also have a look at it.
please. My lord.
41. Appear for objection in this case.
Appearing for the respondent bank, my lord.
I'm challenging the criminal miscellaneous number. That is annexure A and annexure H, my lord. It's a annexure H. Seeking an interim order to
So
stay.
yesterday, isn't it?
Yes, my lord.
Lord?
Yesterday's matter.
Yes, my lord, my lord. Yes.
There was an issue in respect of the item number 1.
Whether the loan comes within the purview of the act, on
Yes.
the face of it, is a loan, what is the purpose?
I'd like to point out a few judgments, my lord. Lord, what has happened? Lord, whether it's an agricultural, my lord, out of the 3 properties, my lord, 2 properties are residential properties.
So what is the purpose of the loan?
Purpose of the loan is for establishment of the poultry unit, commercial poultry unit.
Absolutely wrong, my lord.
No, my lord.
It is,
that
there is a document
No,
which clearly.
May I submit,
Just
my lord?
wait, just wait.
Please.
Lord, this is agricultural term loan is a nomenclature, no doubt. But it is for the establishment of commercial poultry unit in association with Venkateshwar hatcheries.
So where is the sanction?
My lord, I have the sanction. They've not produced it, my lord. This is the sanction.
Yeah, I have the sanction letter.
Lord, sanction is, my lord, we kindly see at page 40, my lord, second page, my lord. Yes. My lord, it says to establish broiler layer breeding farm having capacity of 30,000 layers in cages for production of hatching eggs under the contract breeding farm with Venkateshwara hatcheries and a total project cost of 293.20 lakhs. My lord, next page, my lord, is the detailed of the land and development
No, correct.
buildings.
What is the classification in your books?
My lord, classification is poultry unit, my lord.
Not agriculture.
No, my lord. My lord,
No.
I've produced the decisions, my lord. In the decision.
No, that will go legal position later.
Yes, my lord.
Now there's an exemption in so far as under the Surface Act, so far as
For agricultural land, that interpretation, my lord, has evolved.
correct, but
Yes,
now,
my lord. Section 31, my lord.
Section
Yes, section 31 of the Surface Act.
31A.
That
I
is the
think,
exemption, my lord.
Exception. Class
31 classification I, my lord. I. Lord, may I read, my lord?
correct, but then it appears to say
Yes.
Act shall not apply to a security interest created in an agriculture property.
Yes, ma'am.
Irrespective of the loan.
Lord, agricultural land. What is an agricultural land? How do you identify that as an agricultural land under Surface? My lord, is not merely by revenue entries. My lord, actual agricultural activity has to be carried out. That is as per the decisions, my lord. And that is a question of fact. My lord, the first decision, my lord, which I have cited is Supreme Court decision, my lord, where a similar circumstance, my lord, all these decisions have essentially held that it's merely because it's in the RTC extract still classified as agricultural land, does not make it agricultural land for the purpose of surfacing.
So there has to be an inquiry.
Yes, my lord, there has to be an inquiry, my lord, all these decisions, my lord. First, my lord, is K. Sridhar versus Rao's Constructions, my lord. In this,
No, then just one. Then I'll protect you.
My lord.
Just 1 minute. I'll protect you.
Please.
And I'll make an observation.
Please.
Of your contention regarding agriculture.
Yes, my lord.
And I'll tell we'll direct the tribunal to record a finding
lord.
on
Please.
that after inquiry and proceed further.
My lord, prior to that, my lord,
this
just I would
is the-
like to bring this honorable court notice that
yes, my lord, what he is, my lord, challenged. First of all, there is no ground he has raised in the pleading. There is no ground that it's an agricultural land.
it is
Secondly, my
there
lord-
it is there in my pleadings, my lord.
They have challenged the CMM order and sought for interim prayer of stay of sale notice.
Just 1 minute. Now, I normally will not intervene.
Yes.
But I say if it goes back, I will make an observation. It's a jurisdictional point.
Yes.
It may be raised at any point. Now he is saying that it's exempt under that. So let there be an inquiry on that before you proceed.
Yes, my lord,
Suppose you were to, suppose the tribunal were to hold otherwise, there ends the matter. If the tribunal were to hold in his favor, then it will come to an end.
My lord,
It's a jurisdictional point.
My lord, it is not my humble submission, my lord, it's a question of fact, which
No,
has to
I'm
be
not
established.
interfering.
Yes.
I'm not intervening. What I'm saying is, before the DRT, needless to state, it has to record a finding.
Yes, my lord.
In light of the.
In light of the evidence that he produces.
Correct.
Yes.
And the objection raised.
Yes.
Because it goes to the jurisdiction of the applicability of surface.
Yes, my lord.
So I will not
My lord,
get into the merits.
My difficulty is sale, my lord, it's sale.
No, but you have to determine.
No, my
You
lord,
have to determine.
let the sale go on, my lord. Confirmation may be stayed. No, it's only, my lord, two other properties are residential properties.
That I'm not coming in the way. I'm not coming in the way of that. Insofar as your security, only in the apparent, what he's saying, agriculture land, only that you'll have to record a finding. Remaining, you're at liberty to go.
Lord, even the agricultural land, my lord, in fact, poultry farm also, the court has held.
Correct, let the DRT hold an inquiry.
Provided the sale goes on, otherwise it becomes infructuous, my lord. The question again will arise. Let the sale go on. Confirmation may be stayed, my lord, based on this.
No, they'll be creating rights in the agriculture property.
No, my lord, it is, my lord, may kindly see.
No, I have no time now to sit and.
No, not
hear.
like that, my lord.
Okay,
I am
we'll
only
hear
saying-
it. Some other day I'll hear it.
My lord,
I'm
even
saying
poultry farm.
That property, that one property you leave, you go ahead with the remaining property, it's up to you.
My lord, what will happen, my lord, is again it will get agitated here, again they will come before this.
So that's why
Let there be a specific finding, and it's for DRT to decide whether
Yes,
agricultural land or not.
I will say
And in
that.
respect of other two properties, let the sale
My
go on,
lord,
my lord.
my lord, all the properties are of joint family and ancestral property, my interstate properties, my lord. And even at the lifetime of the deceased Ramakrishna Reddy, my lord, everything has happened. I am the daughter of Mr. Late Ramakrishna Reddy. I was not aware, even I was not made as a party in the trial court also, my lord.
Auction, when is the auction?
It's day after tomorrow, 26th, my lord.
My lord.
Don't confirm it for 2 weeks.
Yes, my lord.
Let him go before the DRT.
Yes, my lord.
But in so far as agriculture property, don't proceed further till the DRT records.
Let the DRT make a finding.
I may be
I only
permitted.
want what happens, my lord, if the sale does not take place, normally it is an infructuous and even finding will not be given. Then again, it will give rise to a cause of action for them
So
to.
I'll make a fine.
Yes.
In so far as agriculture property, you don't take steps till there's a determination.
Yes.
I will say he has raised that contention, that may be taken.
Yes.
In so far the remaining, it will go ahead, but don't confirm it
Yes.
for 2 weeks. Let him go before the DRT and seek for substantive relief.
My lord, 4 weeks may be granted, my lord.
We are
Why,
not-
why I'm submitting is that, my lord.
My lord, my lord, let it be recorded that the bank has contended it's a poultry unit.
I will say.
The poultry farm is a part of an agriculture, my lord. As per
Fine,
the-
that let the DRT decide.
Yes, my lord. The thing is, one more submission is that, my lord, I have been, I have not been made as a party in this case, my lord. Everything has done behind me, my lord. Even I approached the bank authorities, they didn't give the entire details of the whatever the loan transaction taking place between the.
I will direct them to give you up-to-date loan extract of the loan account.
Please.
And whatever detail he wants, you give it. It's up to him.
My lord,
My lord,
mother has
even
come-
earlier to this, my lord,
Your
earlier
son
to.
and husband have raised
No,
the
no,
loan, my
no, my
lord.
lord.
He will give. It's not a problem. He will give.
Because.
But I'm only saying, the mother has come. It is a son and the husband who are borrowers.
No, there is another son is there, madam.
Let us-
Another son and daughter is there.
That is the petitioner.
At least 4 weeks time may be granted because I have to negotiate with the bank authorities also, my lord.
3 weeks I'll give, not a day more, not a day less.
Not my lord, maybe 4 weeks, my lord, because I'm a lady and an aged person. I have to go on with the bank authorities, my lord. 4 weeks may be granted, my lord. 4 weeks time may be granted so that I have to go through entire documents and also, my
But
lord.
he has been,
Please, my lord. Because I'm staying in Chikaballapur district. I have to come all the way from Chikaballa to.
The more you argue, the time will become lesser. You just wait.
Please, please.
The petitioners have called in question the validity of the order at annexure B passed in criminal miscellaneous 177 of 2023. Various contentions have been raised, including that there is no provision under the SURFACE Act to proceed against the security interest created in agriculture land in terms of section 31 of the SURFACE Act.
item 1, my lord, is agriculture. Item 1 is what that. Item 1 is what they are saying is agricultural. Item 2 and 3 are residential.
Item 1 of,
Item 1 of the.
Item 1 of the
writ
petition.
Writ petition.
as regards item 1. Several other contentions have been raised regarding the procedure adopted by the bank while passing the, following, leading to passing of the impugned order. Learned counsel for the respondent bank submits that the substantive remedies before the Debt Recovery Tribunal in terms of section 17. It's further submitted that the inapplicability of provisions of SARFAESI insofar as security interest created in agriculture land is a matter that needs to be inquired into and has relied on several judgments, including judgments of the Apex Court.
Yes.
It's submitted that the security interest created in the agriculture land ipso facto does not render unenforceable provisions of the SARFAESI Act, and certain preconditions for claiming such exemption are required to be demonstrated.
Yes.
Repeat para 1, 2, 3, 4, 5, 6. In para 4, 3 weeks from today.
Lord, sale may, because what he's challenged to CMM order, sale may go on.
Para
Madam,
4, just one.
Annexure H may be still.
Just one. Para 4. In light of disposal of the writ petition, you would meet ends of justice by directing the respondent bank not to confirm the auction sale if concluded as scheduled. If concluded as scheduled for a period of
3 weeks.
Anyhow, what is the time it takes for him to pay?
Lord, confirmation happens within 24 hours. Has to happen within 24 hours. He has to pay 25%. And confirmation, and then he is given 15 days to 3 months to pay the balance amount.
3 weeks from today. Yes. All contentions kept open.
Lord, item
And the bank,
2
the
and
respondents
3.
may be directed to provide all the details of the loan transactions, my lord. The respondent may be directed to provide all the.
One paragraph. Needless to state, insofar as Schedule 1,
Yes.
it is in light of the contention raised by the petitioner regarding inapplicability of provisions of SARFAESI Act with respect to Schedule 1. It is observed that the steps under the Act insofar as Schedule 1 would be taken only after there is a finding regarding applicability of SARFAESI as regards Schedule 1. As regards the other scheduled properties, observations made above would apply. The bank, respondent bank, to furnish upon request the accounts extract and other documents as may be sought for. All contentions are kept open.
Yes.
Yes.
Bless me.
I'm filing a memo, my lord.
Yes.
Withdrawing the petition.
Yes. The petitioner files a memo.
Surface proceedings, amount loan has been cleared.
Which reads as follows. Later the same petition is dismissed as not pressed.
Please.
Yes.
43.
Great.
Again, the ninth R.
Hearing for the petitioner, my lords. My lords, the petitioner in this writ petition is seeking a writ of mandamus to direct the respondent number 5, who is the Honorable Lokayukta, to investigate into the irregularities in the distribution of agricultural equipment which is provided to the farmers, my lords, under the government subsidy. My lords, and also to initiate action on the complaints given by the complainant, my lords.
Have you approached the Lokayukta?
We approached the Lokayukta. A complaint was filed dated 8/11/2024, and the acknowledgement of the same is produced as per Annexure B, my lords.
They are espousing a public cause, my lord. They are an organization. There is no locus standi for them to file. They have to file a PIL.
My lords.
This is an organization which works for the benefit of the farmers. Now, my lord, there is no specific allegation or a relief sought against the authority.
My lords, the irregularities which they have committed, my lords, is that the companies have supplied substandard materials, substandard irrigation systems and sprinkler sets, my lords. Due to this, crops have been damaged and the farmers have suffered agricultural losses, my lords.
AG accepts notice for
My lords,
respondents.
my lords, a direction may be given to the
1 to 4.
respondent number 5 to
Just
initiate
one.
action, my
1
lords.
to 4. Learned Counsel Sri Venkatesh Arbati is directed to accept notice for the 5th respondent. This is the matter in preliminary hearing list on. In their presence, I'll pass some direction. Let us see.
My lords, a short date, my lords, not
That's the shortest date available. Let us see. We'll see.
5-4. Sorry, 5-8.
Yes.
My lords, date, my lords.
44.
Lordship, 34 and 44 are connected matters. 35 and 44 are connected matters.
This matter, kindly see Lord, page 222.
In which writ petition?
In 17599. Serial number 35.
44, right?
17599. 35. Serial number 35. But earlier we were before this honorable court.
Which page?
Page 222. 221.
Yes.
This petitioner was before this honorable court, seeking the correction of the voters list. Now, my lord, kindly see, my lord, para 4 and 5. Then at senior counsel for the petitioner submits that before publishing the final voters list, the respondents may be directed to consider the objections, if any, to be submitted to the petitioner in accordance with law. In view of the aforesaid facts and circumstances, submissions made by both sides, the respondents are directed to publish the final voters list within a period of 2 weeks from today, and after considering the objections to be filed with the petitioner within a period of 1 week from today and in accordance with law. Therefore, my lord, specific directions were given. This order was passed on 30th September. And on 15/10/24, very next page, my lord, we filed a detailed objection bringing out various illegalities in the draft voters list. And we repeated this by a subsequent representation. Now, my lord, the draft voters list is published at page number 80. Apparently, my lord, in this for this
What
Sangha,
was your objections
my lord, objections was
regarding the voters list?
regarding the voters list. There were manifold, my lord. One was that in about actually in the previous approved voters list, there were only 162 taluks, but they had included members from 192 taluks without the resolution of the governing council. Certain members had been illegally added. This was one.
Yes.
And then, Lord, we had given the names of various persons where these persons had manipulated the documents. That is one part, Lord. Then kindly see internal page 3, that various people were residing in 20 to 25 people were residing in various other places, but they have been given the voters list for Magadi. That was the other one. And ಹಾಸನ ಜಿಲ್ಲೆ ತಾಲೂಕಿಂದ ಸುಮಾರು 175 ಜನರ ಸದಸ್ಯರನ್ನು ಅಧಿಕೃತವಾಗಿ ಪೇಜ್ 226 ಮುಂದುವರೆದು 2 paras from the bottom. Shall I read there?
Now, what is this?
This is the objection.
This is your objection.
Yes. ಮುಂದುವರೆದ PV ಸೀತಾರಾಮ್ ಮಾಗಡಿ ತಾಲೂಕಿನ ಸದಸ್ಯರನ್ನು ನಾನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬಯಸುತ್ತೇನೆಂದು ಸುಮಾರು 20-25 ಜನ ಸದಸ್ಯರು ಮೂಲತಃ ಮಾಗಡಿ ತಾಲೂಕು ನಿವಾಸಿಗಳಾಗಿಲ್ಲದಿದ್ದರು ಮೈಸೂರು ಬೆಂಗಳೂರು ಕುಣಿಗಲ್ ಅಧಿಕೃತವಾಗಿ ವಾಸವಿದ್ದರೂ ಸಹ ಅಂತ ನಿವಾಸಿಗಳನ್ನು ಮಾಗಡಿ ನಿವಾಸಿಗಳೆಂದು ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರಿಸುವುದು ಸಹ ಅಕ್ರಮವಾಗಿದೆ. And then on 225 top nut. Second para. ನಾವು ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯ ಸದಸ್ಯರಾಗಿದ್ದ ಅವಧಿಯಲ್ಲಿ ಸದಸ್ಯತ್ವ ಕೇವಲ 162 ತಾಲೂಕುಗಳಿಗೆ ಮಾತ್ರ ಸೀಮಿತವಾಗಿತ್ತು. ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಗಮನದವಿಲ್ಲದೆ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಈ ತಾಲೂಕುಗಳ ಸಂಖ್ಯೆಯನ್ನು 192ಗೆ ಏರಿಸಲಾಗಿದ್ದು, ಅಧಿಕೃತವಾಗಿ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಅನುಮೋದಿಸಲ್ಪಟ್ಟಿರುವುದಿಲ್ಲ. ಹಾಗೂ 162ರಿಂದ 192ಕ್ಕೆ ಏರಿಸಲ್ಪಟ್ಟ ಅನಧಿಕೃತ ತಾಲೂಕುಗಳಿಂದ ಸೇರಿಸಲ್ಪಟ್ಟ ಸದಸ್ಯರ ಅರ್ಹತಾ ಬಗ್ಗೆಯೂ ಸಹ ಪರಿಶೀಲಿಸಿ ಕ್ರಮ ವಹಿಸಲಾಗಿದೆ. ಇದುವರೆಗೂ ಅನೇಕ ಬಾರಿ ಲಿಖಿತ ಮನವಿ ನೀಡಿದ್ದರೂ ಸಹ ತಾವುಗಳು ಕೈ ಬರಹ ಪಟ್ಟಿಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಇದು ವಿಷಾದನೀಯ. ಹಾಗೆ ದೆನ್ ಲಾರ್ಡ್ ವಿ ರೇಸ್ ದಟ್ ಸುಮಾರು 1,000ಕ್ಕೂ ಹೆಚ್ಚು ಗಂಗಾ ಮತಸ್ಥ ಸಮುದಾಯದವರಿದ್ದು, ದಿಸ್ ಇಸ್ ನಾಟ್ ಗಿವಿಂಗ್ ಆಪರ್ಚುನಿಟಿ ಇನ್ ಅದರ್ ತಾಲೂಕ್ಸ್. ಲಾರ್ಡ್ ದಿಸ್ ಮೇ ಬಿ not be directly on the voters list. Then Lord, kindly see 226 last para. ರಾಜಣ್ಣ ಚಿಕ್ಕತಿಮ್ಮಯ್ಯ ಸಂಘಟನಾ ಕಾರ್ಯದರ್ಶಿಯಾದ ನಾನು ಈ ಮೂಲಕ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬಯಸುತ್ತೇನೆ. ಮೇಲ್ಕಂಡ ರೀತಿಯಲ್ಲಿಯೇ ನೆಲಮಂಗಲ ತಾಲೂಕಿನ ಮೂಲ ನಿವಾಸಿಗಳಾಗಿದ್ದ ಸುಮಾರು 25ರಿಂದ 30 ಜನರನ್ನು ಅಧಿಕೃತವಾಗಿ ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರಿಸಲಾಗಿದ್ದರೂ ಸಹ ಅಂತಹ ಸದಸ್ಯರನ್ನು ವಿನಾಕಾರಣ ಕೈಬಿಟ್ಟಿದ್ದು, ಅವರನ್ನು ಪರಿಶೀಲಿಸಿ ಅವರ ಸದಸ್ಯತ್ವವನ್ನು ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಮುಂದುವರಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು HV ಗೋಪಾಲ್ ಮಾಜಿ ಉಪಾಧ್ಯಕ್ಷರ ಹಾಸನ ತಾಲೂಕು ಆದ ನಾನು ಈ ಮೂಲಕ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬಯಸುತ್ತೇನೆ. ಹಾಸನ ತಾಲೂಕಿನಿಂದ ಸುಮಾರು 175 ಜನರ ಸದಸ್ಯರನ್ನು ಅಧಿಕೃತವಾಗಿ ಸದಸ್ಯರೆಂದು ಸೇರಿಸಿದ್ದರೂ ಸಹ ವಿನಾಕಾರಣ ಅಂತಹ ಸದಸ್ಯರ ಗಮನಕ್ಕೆ ಮಾಹಿತಿ ಇಲ್ಲದೆ ಸದಸ್ಯತ್ವವನ್ನು ತೆಗೆದುಹಾಕಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿದೆ. Comprehensively we had made out lot. Then Lord, they published a final voters list.
Now there is an administrator, is it?
Administrator was there at the time when this writ petition was disposed of. So responsibility was given to the administrator to set right the voters list. Administrator published a draft voters list at page number Annexure B. A is the bylaw. Annexure B, page 52, Karnataka Rajya Ganga Matasthara Sangha, Nagarat Pette, Ajiva Sadasira, Antima Matadara Patti. Here, my lord, kindly see at the last he records at page number 78. ಮಾನ್ಯ ಸಂಘದ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿಗಳು after the signature. ಮಾನ್ಯ ಸಂಘಗಳ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು 2ನೇ ವಲಯ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಅವರ ಪತ್ರಗಳ ಸಂಖ್ಯೆ 11/11/24, 16/11/24, 21/11/24 ಗಳಲ್ಲಿನ ಸೂಚನೆಯ ಅನ್ವಯ ಸಂಘದ ಸದಸ್ಯರ ವಿಳಾಸವನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಕಂಡಂತೆ ವರ್ಗಾಯಿಸಲಾಯಿತು. ಶರ ಮಾಗಡಿ ತಾಲೂಕಿನ ಸದಸ್ಯರ ಪಟ್ಟಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 24ರಲ್ಲಿರುವ ಶ್ರೀ ರವಿ KM so and so ಮುದ್ದಯ್ಯ ರವರ ವಿಳಾಸವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿಯವರು ಕನಕಪುರ ತಾಲೂಕಿನ ವಿಳಾಸದವರು. ಈ ತರ they have made about 11 corrections, but nothing is referable to the objections that I have made. They say these communications were received from the deputy registrar, upanibandhakaru, ಹಾಗೂ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿಗಳು, registrar of societies and deputy registrar of societies, but the directions that were issued to examine the voters list was to the administrator only, who was the returning officer.
When is the elections?
Elections is on 6/7. 6/7. Yesterday, apparently, they have started the nominations. This matter came up last week in CS.
On 12th.
Where is the calendar?
Calendar is at page Annexure P, page 232. ನಾಮಪತ್ರವನ್ನು ಸಲ್ಲಿಸುವ ಸ್ಥಳ ಹಾಗೂ ಪ್ರಾರಂಭದ ದಿನ 23/6/25 ಸೋಮವಾರ. And then Lord, next page, serial number 6. ಅಗತ್ಯವಿದ್ದಲ್ಲಿ ಚುನಾವಣಾ ದಿನಾಂಕ ವೇಳೆ 6/7/25 ಭಾನುವಾರ 9ರಿಂದ 4. Clearly, my lord, the directions of this honorable court have been flouted and they have not even considered any of these objections.
No, you just look into it and make a submission regarding each of their apprehensions. If it requires redoing, we will pass some direction. What is the stand you have taken pursuant to that? I'll have
My
it on Thursday.
preliminary instructions are that they have verified all the addresses and then.
Correct. So now insofar
I'll
as the
find out by-
objections raised in their representations, each one of it you make a list and then you tell us what is Thursday. We'll have it on Thursday.
Yes, in the meantime, Lord, if the elections continue, what will happen is
No,
they will
because,
file
Calendar
nominations.
of events have been published and
That
it has
will
been
say-
advertised also. It's a state level
Correct,
election.
but now I'll make it clear that this will be subject to orders to be passed, and then we'll see. If it requires to be redone, it has to be redone.
Yes.
Finally, the voters list, if it is redone, it will further the election process.
Yes, in aid of the election process.
And one more petition, which they filed is seeking for reservation, but the
It's a
bylaw
Nataraja
doesn't
case.
say for reservation and then
Nataraja
the
Sharma.
act also doesn't say for reservation.
That at this point of time, we may not be able to
Yeah.
do it. It should have come little earlier. Anyhow, we'll see, we'll see.
See, my
Because
lord.
now calendar of events is published.
Yes, my lord.
Now we can't redo the clock,
Yes.
but we'll see. Let us
But my lord, not only with regard to the violation of not reserving the women, there are a serious multiple violations in the.
So for that surcharge proceedings are going on. Because there
but-
were membership amount which were not collected properly. So there's for recovery of that proceedings are going on. So that second serial number 44 petition that will be, we'll look into the complaint given by the petitioner in serial number.
Far as,
34.
No, we can't stall the election
Hello.
process. If there are some defects in the voters list, we will direct them to redo it and go ahead. Remaining is all a matter for decision.
My lord,
We can't
firstly-
stall the election
No, no, my
process.
lord. Firstly, with regard to the voters list, my lord.
That
Some of the areas, even this Ganga Matastha community is in Kannada we says it is a Besta community, my lord. Coming to a part of a Karwar, my lord, there are nearly more than 2,700 members were there earlier. Well, coming to a reservation, my lord, earlier bylaw in 2002, my lord, it specifies that there should be a 2 members reservation for a female. But when it comes to a matter of amended bylaw, my lord, they have deleted that. Very nature of the bylaw cannot be, my lord.
Questioned now
The
after
validity of the
calendar of
bylaw
events.
cannot be entered into in this proceedings. That we'll see.
My lord, it is a constitutional right of a woman, my lord.
Correct,
It is,
but not
it
at
is
this-
upheld by our Supreme Court, my lord, in our own case.
Not at this stage, not at this stage of the process.
My lord, otherwise, my lord, the entire bylaw itself, it become infectious, my lord, amended bylaw. If the reservation
Bylaw
is
of
not given.
the, bylaw of the Advocates Association cannot be treated on par with
No, 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 no.
other
Not,
bylaws.
not like
Let
that,
us
my
see.
lord. But even there are some
What
other.
Supreme Court did was, they interfered in the last moment and postponed the election for 15 days. It was postponed for 15 days. Because of the last minute interference.
My lord, that also maybe, same may be considered here also.
No, no,
my
no,
lord.
every
At the end
society-
of the day, it is a right of a
Because the
woman.
act doesn't permit.
No, that.
Karnataka Cooperative Act, it is there. Society Act
So
doesn't.
we may
provide.
pass an order providing, directing if a case is made out, but it may not, it will not come in the way of the present election. We will see. Let us.
But it is a statutory provision, my lord, under 25
No,
class 2 of the
not under the Societies Act. Under the Cooperative Societies Act, it is there, statutory. Not
No,
under
no.
the Societies Act.
May I read, my lord,
No,
25
no,
section
that is
26?
Cooperative Society Act, not Societies Act.
We can't now stall it. We'll see. Vivek will not support you. Because
But we are a victim in
Huh?
the Advocates Association election.
we are following the direction in other associations also.
Actually, Lord, it is something which is
Lord,
good.
in the entire.
It allows participation because they are totally neglected in this election process. It is something that has to come.
One more came up,
Sometime-
Madhur Association.
Except, Lord, in a society where a society is dedicated for men's welfare only. That is a rare situation.
That's what 243 says, my lord, Article 243 class 1.
No, correct. We will issue after hearing, but we may not be able to do that in this election. But we'll keep it pending and we'll consider.
At least, my lord, the other districts also may be considered, my lord, for the voting, inclusion of the voting. There is a
let us-
mass
let them get
tradition, my
this.
lord. It is not one or
Let us
two
see.
votes.
AG except in idರಲ್ಲಿ 17958. AG accepts notice for respondents 1 to 4.
1 to 4 years.
1 to 4. Now 5 is also government officer, is it?
Yeah. Five,
5
is also a government.
1 to 5. Which is the other one? Idರಲ್ಲಿ 17599. AG accepts notice for the respondents. Release the matter in the preliminary hearing list on
But can it be
Thursday.
Friday.
No, your lordship, not Friday beta. Your lordship may have this on Tuesday. Tuesday, but
That will be too late.
no, your lordship may have it on Thursday itself.
On Thursday. Needless to state, in light of submission made, that the directions of the coordinate bench regarding rectification of voters list has not been complied with, as made in WP 24137 of 2024. The calendar of events issued is subject to orders to be passed. List on Thursday.
If the interim order may be granted, madam, otherwise what happens, madam? The new voters may come, but those who wanted to really contest for the matter already
Once
started.
the draft list is published, we cannot
No,
include.
Tuesday is the two,
include
Tuesday is the
anyone.
two for, my lord, because the 23 starts from 23 and
Thursday.
25th is the.
We'll see
Thursday
what,
maybe.
we'll see what is to be done. I have reserved liberty to pass appropriate orders regarding the calendar of events.
Suppose the vitiating grounds are.
It has to be redone. It has to be redone and election be held.
Oh, much.
Let us.
45.
Notes the respondents, notes 1 and 2, notes with the assistance of respondent number 3. Notes have conducted notes a search and seizure measure notes at the residence of notes the petition number 2. Thereafter, notes a notice was also issued to the petition number 2 notes wide annexure E at page number notes 32. Notes notice calling upon him notes as a witness. Notes, however, notes.
Yes, you take out notice.
Please.
Now, who appears?
Notes for respondent number 3 notes. Government advocate notes 1 and 2 notes is NIA notes. Prasanna Kumar notes.
Prasanna Kumar, directed accept notice respond 1 and 2. EGA for 3. Relist the matter on. Yes.
It's in the same stage notes.
Will come.
Please.
Preliminary hearing. List.
46.
Appear for the petitioner. This is pertain to.
Also, I'll take notice in this matter.
This is a matter squarely covered by the order of this honorable court. Wherein, the issue is, my passport renewal application has been kept pending on the reason that, there's an FIR against me, but that FIR is also stayed.
This issue is already
Covered
settled by the concurrent bench, my lords, in Sharat Chandrasekhar. The petition may be allowed, my lords. It's just the FIR stage.
For 12 minutes.
What is that passport called as? The issue for a limited period.
My lords, no, this is just the FIR which is filed and the investigation is stayed.
Paragraph?
Paragraph 12 minutes. The court referred to the circular of the central government in paragraph 11 for office memorandum dated 10/10/2019.
Just take me from para 10. What is the procedure, etc.?
Yes. The aforesaid para 10, the aforesaid narrated facts are not in dispute and requires no reiteration. The issue lies in a narrow compass with regard to the action of the respondent in not reissuing the passport as sought by the petitioner. As observed, the petitioner is a holder of an Indian passport, which was issued to him on so-and-so and valid up to so-and-so date. The petitioner, 6 months before the expiry, submitted an application seeking renewal of his passport. Not considered on the score that there are 3 cases pending against the petitioner, which are
Now
noted.
we come to para 11 or 11, then afterwards what is
Yes, yes. In para 11, my lords, in furtherance of the aforequoted statutory provision, the Ministry of External Affairs has issued a notification in so-and-so number as to what must be done in cases where there are pending cases before the criminal court against the holder of a passport. This is further clarified by another office memorandum dated 10/10/19, the relevant clause of which reads as follows. In case where the secondary police verification also adverse, it may be examined whether the details brought out in the police report match the undertaking submitted by the applicant. It may be noted that mere filing of FIRs and cases under investigation do not come under the purview of section 6(2)(f), and that criminal proceeding would only be considered pending against an applicant if a case has been registered before any court of law and the court has taken cognizance of the same.
In your case, no cognizance.
No cognizance. FIR register madidare, I approached this court and obtained the stay. Squarely similar circumstances. And in para 12, my lords, in the light of the aforesaid clarification, in cases where the proceedings are pending against the holders of the passport, when they seek for renewal or reissuance, it cannot be denied on the ground that the proceedings are pending against those holders of the passports only in cases where the proceedings are at the stage of crime and the concerned criminal court has not taken cognizance of the offences. Any other proceedings pending invoking any other law will not become an impediment to the passport authorities for issuance or reissuance of or renewal of the passport. Therefore, it is expected of the passport authorities to act in accordance with the classification as obtained in the office memorandum dated so and so, and not to deny renewal of the passport to those passport holders against whom pending criminal cases are at the stage of investigation and the concerned court
Here
is
we have to only say that no
Yes.
cognizance is taken.
not yet taken.
So in terms of 10/10/2019,
19.
They can take note of it and
Yes,
proceed further.
proceed further within a time bound period because that's the
The petitioner. Now you appear for
For both the respondents.
so and so undertakes to appear for the respondents. Present petition has been filed seeking for issuance of writ of mandamus to direct the respondents to process and issue the passport to the petitioner in accordance with law as regards his pending application to and
next
so.
year B.
Real. Next, it's the case of the petitioner that the petitioner was issued a passport on 14/8/2014 and as the validity had expired on 13/8/2024. Petitioner on 21/5/2025 has applied seeking renewal of his passport. It is further submitted that the renewal has not been considered and upon inquiry.
Yes, bro. Annexure E, my lords, page 22. Police verification report is not clear and application is under review.
And upon inquiry.
Page 22, my lords, annexure E. Status last.
The petitioner noticed that in the portal that an entry was made under the caption status as follows: police verification. Report is not clear and application is under review at regional passport office. The petitioner is given to understand that in light of a proceeding initiated against him, police verification was not, his application was not cleared during police verification. It is submitted that an FIR dated 4/4/2025 was lodged against him and registered as crime number 83 of 2025.
Yes.
However, as regards the said crime number and registration of FIR, petitioner had approached this court in WP 5846 of 2025.
Criminal petition.
In criminal petition 5846 of 2025, and an interim order has been passed
22
paying further investigation.
Yes.
Full stop. As per the order of this court
22
dated 22nd April 2025. Counsel for the petitioner relies on the observations in WP 18066 of 2023, and counsel for the respondent submits that appropriate directions may be passed taking note of the observations made in WP 18066 of 2023. The observations made in the said aforesaid writ petition are of relevance and discuss the aspect and legal consequence of absence of taking cognizance as regards complaints. Observation at para 11, 12, 11 and 12 RS is extracted for reference. Next. In light of the stipulation in the office memorandum of 10/10/2019, there appears to be no warrant for the authority not to proceed further in the event court has not taken cognizance of the complaint. In light of the order of stay passed in criminal petition number so and so, and noticing the assertion which stands uncontroverted that no cognizance has been taken, the respondents are directed to proceed further, taking note of the observations in WP 18066 of 2023 and process the application for renewal and pass orders in light of observations made above within a period of
10
4
days.
weeks,
my
my
lords.
lords. 4 weeks, my lords.
No, 4 weeks is too much because he's already scheduled a foreign tour in July, second week, my lord.
2 days, my lords. We'll do it in 2
2
days.
weeks from
Two-
today.
2 days, they are telling 2 days, my lord.
We'll do it in 2 days, my lords.
It can be
days,
given.
huh?
It can be given 2 days. my lord.
Within 2 days.
Within 2 days, it will be given.
Yes.
Obliged.
47.
But the other clarification is this, my lord. In this case, my lord, the FIR was stayed. Even though FIR is not stayed, they're entitled for the passport.
As long as cognizance.
As long as cognizance
Cognizance.
takes. That is clear, my lord. Great.
ಅದು ಇಟ್ಕೊಂಡಿರೋದು ಬೇರೆ matter ಬೇಕು.
My lords, petitioner is seeking,
Connected with those matters, my lord.
Huh?
petitioner is
Matter
seeking,
may
my
be
lords.
Connected with those matters, my lord, police protection they are seeking.
Police protection.
View of the temporary injunction order.
AGA accepts notice for the respondent. List along with the WP number so and so. Yes,
Lords, interim protection may be granted, my lord.
we are passing some directions.
Much.
48 appearing for technical counsel.
Therefore, the caveat.
Granting of leasehold rights of fisheries, 5 years commencing from 2022. 3 years, 4th year is running. Lord, at this stage, this honorable court quashed the earlier notification where I am the beneficiary.
After 4 years.
After 3.5 years. Now matter was reconsidered. Now it is denied to us. Against that matter, the present petition is filed.
Now you have completed how many years?
I have not yet. Only 3.5 years I completed.
Correct. So you are now, as of now, you are functioning.
I am functioning, but my lease is now terminated. By virtue of an order passed by this honorable court, validity of right to grant the lease was tested, in which I hold that I am ineligible. Therefore, my claim was declined. Now, my lord, your lordship may kindly see.
But now at this stage, how we could intervene? If he has already completed
No,
three
my
and a
lord,
half
it is
years.
every year, my lord, year to year.
Not
My lord,
e-
though
not
it is
every
for 5
year.
years.
It is
Year
not
to year
correct, my
lease.
lord.
My lord, initially it was granted in my favor. I got the lease. That was set aside, remanded back. My lord, then that was denied to me and it was granted to the petitioner who was ineligible. We challenged it. This honorable court said, again remanded the matter on the ground that whether the authority did not verify, my lord, whether they were eligible or not. If both are eligible, my lord, auction has to take place. Then, my lord, it was remanded back. Again, my lord, another order was passed without assigning reasons, my lord. We challenged it. That order came to be allowed, my lord. We pointed out the illegalities and so ineligibility. That was, my lord, allowed by this honorable court. This honorable court said the previous year, the submit fresh documents. We will see as on today what is the status is. Then, my lord, both of us submitted the documents. They were held ineligible and it is granted in my favor. My lord, up to June 31st.
30th.
This year, my lord, 30th, it will, my lord, it will end. This season will end. Next season, my lord, starts from July 1st. We have to release the seedlings from July 1st. It will grow up to, my lord, December. We cannot. Then, my lord, we have to harvest it. So they were allowed, my lord, even after setting aside the, my lord, grant in their favor, they were allowed to fish, my lord, up to the end of the season. That was the intention. My lord, that was only up to, my lord, the authority passes the order. However, authority says till June 30, my lord, you can continue. That is the order. That order attained finality, my lord. this honorable court grant extended only for a period of 4 weeks. That came to an end. My lord, they cannot seek an interim order because, my lord, even if, my lord, this order is stayed, my lord, they cannot be allowed to continue because the previous order, my lord, it set aside 4 weeks was granted that attained finality. My lord, if order is stayed, my lord, already I have deposited 10 lakhs because for the lease amount, my lord, after the passing of the order. My lord, I have to release the seedlings. The entire year will go waste, my lord.
Correct.
My lord,
So,
as per the equity, my lord, they were, my lord, allowed to continue up to June 30th.
okay, we'll hear the matter.
Please, my lord. And also, my lord,
Instructions. Complete your
I will
instructions.
also file objections, my lord. Your lordship may
File,
have it
file.
next week.
VGA. Accepts notice for response 1 to 4. So and so undertakes to appear for the fifth respondent. Fifth respondent. The respondents to complete their instructions and file statement of objections, if any. Relist the matter on short date.
Please.
On my lord,
Second.
my lord, 30th I have to vacate. According to the impugned order, I have given time to harvest the fish up to 30th 6/2025. That
Not
was
only,
the
my lord,
order.
Correct. Now.
Now, my lord,
we
what
have to-
happened? My learned friend is may not right in saying that it's a 5 years lease commencing from 2022. Every year there is a hike in the lease amount to the extent of 5%. By 5% hike, we have to deposit, then they will grant a permission to lease the thing. It is not a renewal. That is not correct. It is 5 years.
Where is the original lease?
Original lease
Order
commencing
granting
from,
lease.
original lease commencing from my lord. Your lordships may kindly see.
My lord, that was set aside in the previous order. My lord,
Well,
page
first
120.
lease was granted on 2012-2022 in favor of the respondent number 5.
Where is that? Let us see.
Beg your lordships.
My lord, page 120 is the previous order, my lord, passed by this honorable court. My lord,
No, I just want to have, I'll come to that. I want to see the original lease.
Original lease is for
Order-
5 years. Madam.
Where is that?
I will. My lord, your lordship may kindly go to page 73, annexure D, my lord. 10/3/2023 order.
Yes. It's for 5 years.
5
for
years.
5 years. My lord, kindly see
Commencing
page
from 2022
75.
23.
Page 75 may be kindly seen. My lord. Each
75.
year, my lord, the ಗುತ್ತಿಗೆ ಮೊತ್ತ ಬೇರೆ ಬೇರೆ.
No, that
There,
is,
hike is there, every 5%, the hike will be there to the existing lease amount.
no,
That we have to deposit.
that is there.
Yes.
But it's a 5-year lease.
Total
Yeah,
5
5
years.
years,
my lord.
please.
Once it will be granted for 5 years, my lord.
Correct.
Every year, my lord, from season will start from July 1st. They have to deposit the amount.
No, no, correct. Now what is the direction passed by the coordinate?
Direction passed by this honorable court.
My lord,
Your
kindly
lordships
see
may kindly
page
see.
145, my lord.
We'll continue at 2:30.
Please, my lord, this order, my lord, this lease order is set aside by this honorable court.
2:30.
Please.
One submission in serial.
Government advocate, just serve a copy.
It's already served.
ಅದೇನು ಇನ್ನೊಂದು ಕೇಳ್ತಾರೆ ಕೊಟ್ಬಿಡಿ.
My lord, one submission in serial number
Copy is
41.
advance copy is already been served. If they want this copy, I can serve it. Your lordship may have this matter day after tomorrow, I can ask.
My lord,
In the
one
fresh matters list.
Please.
Day after tomorrow. Release the matter in the same stage.
Yes.
My
lord, serial
all,
number 41.
all mentioning at 2:30, if both sides are there and you want an adjournment.
No, my lord, this is relating to the earlier matter. I just want to change. Lord specifically saying that sale to go on because no precipitative.
I've changed that paragraph.
Yes.
When I
Sale
was
to go on, yes.
when I was dictating para 4, I've changed.
Please, please. Great.
Yes, I will survey a copy on the government advocate, my lord. Day after tomorrow, my lord. Very.
The roll petition.
In the very
This
same
honorable court
stage,
has directed the judicial central superintendent to grant an emergency parole, but they have rejected your honor for marriage.
I postponed.
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ ನಿಮ್ ಕೈಲೇ ಕೊಡ್ತೀನಿ ಸರ್ ನಿಮ್ಮ ಹತ್ರ
ಒಂದೇ ಅಲ್ಲಿದ್ರೆ ಕೊಡುವ ಬಟ್ ಸೈನ್ ತಗೊಳ್ಳಿ.
Okay. ನೋಡಿ ನಾಳೆಗೆ ತಗೊಂಡು ಹೋಗಿ.
ಸರ್ ಇದು
ಒಂದಷ್ಟೇ.
ಈಗ ಲಿಸ್ಟ್ ತಗೋತಾರಲ್ಲ, ಈಗ ಲಿಸ್ಟ್ ಲಿಸ್ಟ್ ತಗೋತಾರಲ್ಲ ಈಗ, ಇವಾಗ ಲಿಸ್ಟ್ ತಗೋತಾರಲ್ಲ, ಲಿಸ್ಟ್ ತಗೋತಾರಲ್ಲ ಈಗ,
ಎಷ್ಟು ಫಸ್ಟ್ ಮುಗಿದ್ಮೇಲೆ
ಹೌದಾ?
ಆಫ್ಟರ್ ಲಾಂಚ್
ಅಲ್ಲ ಅದು ಬರಲ್ಲ ಚೇಂಜ್ ಮಾಡಿದಾರಂತೆ.
Where is? I thought same contention. Your colleague.
She'll come.
Huh? ಆಯ್ತು ಒಂದು ನಿಮಿಷ ಬರ್ಲಿ ಅವ್ರು.
Passport matter.
Serial number? Huh? Huh? 100, huh? Huh. That request, DRT matter, huh? Huh? ಎಷ್ಟು? ಬ್ಯಾಂಕ್ ಕೌನ್ಸಿಲ್ ಯಾರು?
Ganesh.
ಟ್ವೆಂಟಿ 22 3 ವರ್ಷ ತಡ್ಕೊಂಡ್ ಬಂದ್ ಬಿಟ್ಟಿದ್ದೀರಾ?
ಪಾರ್ಟಿ ಇಂಟಿಮೇಷನ್ ಇಲ್ಲ, ಪಾರ್ಟಿ ಫಾರ್ಮ್ ಮಾಡೋ ಸುಜಿತ ಒಂದು 2 weeks ಟೈಮ್ ಪಾರ್ಟಿ
1 week only.
One week.
Whatever you want to do, you do.
1 week.
My lord.
Reset, just one. Relist on 1 week date.
Second.
With my lord's kind leave.
Interim order iದ್ರೆ extend till next week.
My lord, serial number 67, I have informed the other side, petitioner, my lords, I am for the respondent. They have considered it may be taken up on Monday, my lords. I will complete my instructions. Please, my lords.
67. Huh?
I know. They have considered, morning I have requested, they have considered
Relist
for
on.
Monday.
Relist on.
Taken on Monday, my lords.
Monday.
30th.
Much obliged, my lords.
With my lord's kind leave, my lords. Serial number 27 in list number 2.
Huh.
My lords, I'm not insisting for hearing me today, my lords, but there is an urgency. I'll just state it in 2 lines, my lords.
That you, at the end of the day, you'll mention.
May 2 lines, my lords.
Huh.
My lords, what has happened is the National Highways Authority, while constructing the road, my lords, they have damaged the drain. Because of the damage, my lords, the agricultural lands abutting the highway, my lords, is completely flooded. My lords, in view of that urgency, my lords, if my lords may kindly take it up at 2:30 tomorrow, my lords.
Let us see. Just wait.
Because of the monsoon, my lords.
Correct. So you tell the council, this is the difficulty. Let them get instruction. If after it reaches again, I'll have to give a date unless the council has taken instruction. You tell Shilpa, Madam Shilpa.
I will keep her informed and again mention
keep her
it.
informed. Let us see. Today it looks unlikely.
That is the reason, my lords.
Tomorrow also same. So let us see. If there's a chance, I'll take. You just wait. We'll see.
Please,
My
my lords.
lord, serial number 107, my lords.
Huh.
In this, we have come. I have filed my NOC wakalat today and also complied with the office objections. The copy for the respondent number 3 will be served, my lords. I have intimated the respondent number 3. In this matter, we have engaged the senior counsel Udayola.
But you don't have to make, isn't it?
My lords,
You are making submission. I am not denying adjournment. Then why do you make other submissions?
my lords, the thing is, a date may be fixed in.
I will do that. Yes. Date code. 107. Date fixed. 7.
Next week, my lord, the matter is regarding the defreezing of the bank account. Kindly, there is some.
Short date code. Yes.
Obliged.
Passport matter, serial number 3.
The respondent.
MS Devaraja.
For the petitioner.
MS Devaraja.
Memo of undertaking.
Kudi.
Copy is.
Counsel for the petitioner. What do you say, madam?
Okay, my lord.
Huh?
Yes, okay, my lord. 3 months.
I'll observe. Huh?
From today, 3 months, my lord.
Yes. Petitioner files a memo of undertaking, which reads as follows. Third counsel for the respondent bank submits that the petitioner is to adhere to his undertaking as contained in the memo. In light of the same, petition is disposed of, not calling for any adjudication.
My lord, let it be disposed of after they repay the entire amount.
The memo of, otherwise I'll permit you to revive the petition.
Okay.
Huh? any adjudication in light of the offer of the petitioner being agreeable to the respondent bank. Needless to state, in the event of petitioner committing breach of the undertaking, the petition would stand revived.
Outstanding balance may be mentioned in the order sheet.
That you have to work it out amongst yourself.
So I'll tell my lord.
No, that correct, that you tell him. Now anyhow, if it is not, it will revive.
Okay, that's all.
36. Praveen R. Mitesh Shetty.
Petition number.
Let sale is sailed before this honorable court. Let the petitioner, my lord, is the subsequent to my mortgage, my lord, he has entered an agreement to sale. Lord, in eyes of law, my lord, he don't have any, unless and until, my lord, I have given a permission. My lord, he don't have any eyes. My sale, my lord, today is the auction. There are some bidders which I got instruction. But at the most, my lord, let them agitate before the DRT. My lord may give some time. Till such time, my lord, not to issue the sale certificate, that direction may be issued, my lord, I'll communicate to my client.
Don't confirm the sale.
Confirmation may not, the reason is this. My lord, first and foremost, my lord, his sale agreement in the year of 2015. My mortgage in the year of 2008. My lord, if the sale agreement, my lord, if I'm not able to confirm it, my lord, I may not be able to get any buyer also. That's a practical difficulty which I have. I'll not issue sale certificate for a period of 2 weeks or 4 weeks, whatever my lord says.
And they will not issue sale certificate. You go before the DRT.
Today is the action is there. That is, has to stay.
No, correct. Sale certificate they will not issue. The auction proceedings will be subject to the outcome of proceedings to be instituted by you before the DRT. They will not issue sale certificate for 4 weeks.
At least 8 weeks. There is some adjustment is 8 weeks. That is a humble request, 8 weeks. Yeah, 8 weeks. At least 8 weeks.
The petitioner has called in question the validity of the petitioner has called in question the validity of the auction proceedings stated fixed on 24/6/25. Various contentions have been raised, including procedural violations as regards the proceedings under section 13. Petitioner submits that apart from the contentions raised, petitioner is willing to satisfy the claim of the respondent bank. Mr. Learned Counsel, Sri Vignesh Shetty, appearing on behalf of the respondent bank, submits that the contentions of the petitioner are one to be raised before the debt recovery tribunal under provisions of the Surface Act. Full stop. Manjunath, the draft code.
Any provision to private treaty to negotiate with the respondent 1 and 2?
I will keep it. Repeat. Para 1, 2, 3, and 5 and 6. In light of petitioner being relegated to avail of the substantive remedy, the respondent bank, though is permitted to go ahead with the auction, is not to issue sale certificate for a period of 4 weeks. Needless to state, it's open for the petitioner to approach the bank and place a proposal which may be considered by the bank appropriate.
Grateful, deeply obliged.
Accordingly, petition is disposed of. Yes.
My lord, in this case also, my lord, notice along with the report was not served.
Not served.
Not same order.
Writ petition 16233, yesterday, your lordship has passed order.
Identical.
Even serial number 18 in the second list, my lord.
Just 1 minute. WP Order passed
16233/25.
16233.
233.
Barkoli. In terms of disposed in terms of order in WP 16233 of
25.
2025. Same identical order.
Yes, ma'am.
Draft ಇದೆ.
One more matter also, my lord.
Which is that?
Second list, serial number 18, my lord.
Serial number?
Serial number 18, my lord, in second list. WP 16395 of 25.
No, number is wrong. Serial number?
Serial number 18, my lord.
Serial number 8, my lord.
18. 18, my lord, 18.
16090. Identical order.
Identical order.
But what is that order?
That, my lord, they
It
have not
hasn't-
followed the
Correct.
procedure.
No, I'm saying in a lighter vein, I have not yet, that order is not yet out. Okay, same order. If there's any clarification, I'll.
Yes, my lord.
So report is not.
A report was not annexed with the Shokas notice, my
Shokas
lord. No,
notice.
notice was not served. That is, the procedure was not followed, my lord. Only on that ground, liberty was reserved with the state
Yes,
to
yes.
proceed in accordance with.
Same order.
Much obliged.
Serial number 49.
I'm appearing for the petitioner. Your Lordship, my humble submission to before this, Your Lordship is, Lordship kindly take serial number 80 and then 81 in this matter only. All three are similar matters. Serial number 80 and then 89, my Lordship.
80 and 81.
81. I am the same advocate for all three petition, my
No,
Lord.
you are same. Parties are different.
No, my Lordship.
Respondent bank.
In this matter, Lordship,
Respondent banks are different.
respondent banks are different, but the classification are same. My humble submission to this, Lordship, I prepared based on serial number 80, read petition 18108. Lordship, this is first I filed. As per the FR number, this should be the first. Serial number 80, WP number 18108, Lordship.
Does it say there?
Office objection only, that is not an office objection, my Lordship.
You serve on the council.
Lordship, here I have, Lordship, my main prayer, Lordship, my main ground is ex parte interim orders. I have annexed 5 ex parte interim orders passed by this honorable court, my Lordship. I rely on.
That is not a precedent for me.
It's
not a precedent for me.
Lordship, opposite parties are bank, my Lordship. I rely on annexure D2 and E2, my Lordship. Page number 34, my Lordship. It is a matter for.
No, I'll pass orders. I'll hear them and pass an order.
No, my Lordship. My humble submission, I will convince your Lordship. Then Lordship
I
decision.
am not convinced.
Lordship.
I don't pass ex parte orders.
Allow me, Lordship. Lordship, the relief I'm seeking is it is not harming to anyone.
That is not the criteria for me to give an ex parte order. Wherever debit freeze has been ordered, without hearing the other side, I do not pass any ex parte.
They have the rights to detain the disputed amount, not my entire operation of bank account, my
Correct.
Lordship.
That I verify from them and then pass.
Lordship, I place the Honorable Supreme Court of India citation along with total 25 writ petitions. I have annexed this petition, my Lord.
Don't tell me what to do. Don't tell me what to do.
Lordship,
I
I'm
follow-
sincerely apologize, my Lordship.
No, I follow a certain procedure and there is no warrant for me to not follow that procedure.
In this case, my Lordship, my Article 21 is violated. Right to trade is violated. My humble submission to this Honorable Court, defreeze the bank, keeping the disputed amount as a lien. I
know what to do. I've been doing this from day one. There's a certain procedure I follow and there's no warrant for me to not follow that procedure. I will not pass an order without hearing the bank. I will fix a date, you serve the council and I'll have it.
My lordship, company's bank account cannot be frozen, my lordship. The very harmful,
Take notice to the respondents.
lordship, make a hand summons. Lordship, make an hand summons.
Just wait. That's why I'm saying you must understand the mood of the court. I pass orders, but not without hearing the bank. I will give you relief. So you wait. Emergent notice to the respondents. Petitioner is permitted to serve. Now, which is the bank which has passed the order?
Lordship,
Which bank?
1 minute, lordship.
Respondent number?
1 minute, lordship. Respondent number 8 freezed my bank account.
Yes.
Rest other banks not freezed my bank account.
The petitioner is at liberty to serve standing counsel for State Bank of India. Anybody is there? Yes, Vignesh Shetty accepts notice for the 8th respondent. Eighth respondent. Now he has to make the state as a party.
Please, my lord.
No, lordship.
No, pursuant to, my lord, in most of the cases, my lord, pursuant to, my lord, directions made by the state only, my lord, will freeze it. I think, my lord, state is necessary party in this matter.
Not the state, my lord, the originating police station has to be made. For
Please,
example,
please.
if it is the state of West Bengal or the police in West Bengal, then the state of West Bengal has to be made party and that respective police station.
Please.
But on any police station in Karnataka, yes, my lord.
Yes.
So
Depending on which police station. has
So
issued
what is the instruction to the bank from which authority?
Lordship, they have to get the freezing letter from the police itself.
No, so
They didn't.
Are you aware which police station has given the?
They didn't give any information. Bank not given any
To
information.
find out. Then you find out.
Have it after week's time, my lord. Let me know.
Relist the matter in preliminary hearing list on.
Lo-
3rd of July.
Lordship, serial number 1 to 8 hand summons, my lordship. I will take hand summons.
Petitioner is at liberty to take out notice by way of hand summons as well. Which is the next matter?
Serial number 49, WP number 18100. Serial number 49.
Jana Small Finance
Bank.
They have exercised the lien.
Lordship, here they specifically given what is the disputed amount.
No, which bank? Now?
Jana Small Finance Bank.
You serve them.
Respondent number 1.
Emergent notice to the respondents. Petitioner's liberty to take out notice by way of hand summons as well. Vignesh Shetty accepts notice for the 3rd respondent, State Bank of India. Petitioner is at liberty to serve the standing counsel, if any, for respondent number 1.
1 to 3, my lordship.
1 to 3.
3.
Relist on.
That copy of the petition may be served upon.
Serve copy. Yes.
Serial number 81, last petition.
81.
Here, lordship, I made a
81.
81, serial number 81, WP number 18139 of 25. Lordship, here I made a proper party because the account frozen by police. I made a party as state of Kerala. Permit me to take out the hand summons against respondent number 1 to 8, my lord.
Respondents 1 to 8 is at liberty to take out notice by way of hand summons as well. Then Axis Bank. JM Patil is directed to accept notice for the 8th respondent. Relist the matter on.
Lordship, one humble submission, lordship.
Yes.
In interim prayer, page number 10,
Yes.
direct the respondent number 7 and 8. Here, I have to make respondent number 3 also, my lord. I made a mistake.
That is B.
A and B, my lord.
Petitioner is permitted to rectify error stated to have been kept in interim prayer A and B.
Much obliged, my lord.
Continue. 4 o'clock.
50, cell number 50, Srihari.
ಚಂದ್ರಶೇಖರ್ ಹೇಳಿ 4 ಗಂಟೆ ಮೇಲೆ ಬರೋಕ್ಕೆ.
Challenge in this matter is the action of the postal
requesting to pass over the matter, my lords. Senior is in other court.
Urgency in this matter, we are moving.
Huh?
There is urgency in this matter.
Huh. What have you sought?
Kindly pass over, my lords.
It won't reach by pass.
Urgency in this matter, my lords. We have been moving this matter persistently.
Huh?
We've been moving this matter persistently. The postal department, I'm an e-commerce company, my lords. I'm an e-commerce company and I rely heavily on the services of the postal department. The postal department is a non-discretionary service. Unless I'm transporting some prohibited service, items, I cannot deny the service. No, the services have been denied to me. On the ground, that several criminal cases are pending against me.
What cases?
Several criminal cases are pending against me. Because criminal cases are allegedly pending against me, that is not a ground for the postal department to deny its service to me.
Yeah, have you been using these postal parcels to do any illegal activity?
Absolutely not, my lords. In fact, there is a record. Can you take to page 95 in the petition? 306.
Where is their endorsement?
Page 95, page 30600. WP number 30600.
Page?
WP number 30600. WP 30600.
Page?
Page 95.
Yes.
Page 95, the respondent number 3 on being inquired by respondent number 2 about the nature of services availed.
Annexure L. Annexure L.
Annexure L, perhaps, please.
Ah.
Annexure L. Watch it, kindly see second paragraph. First paragraph, with reference to the above subject, it is to intimate that Behind Direct Selling India Private Limited is a advanced customer since 2018. Booking speed parcels from PPC, India and revenue being accounted under secondary division. The customer is giving average business of 2 lakh rupees and the amount is being credited in advance. The payment is regular without any default and they are booking around 6,000 parcels per month approximately and the contents of the parcel are all home need items. It's clearly mentioned home need items. When it is home need items, they cannot deny me service under any conditions.
Now, what are the criminal cases pending against you?
Cases are pending because I'm a direct selling company, my lords. I'm a direct selling company and the industry itself is such that it is unregulated until 2021. Until 2021, there are no direct selling rules.
Could it?
I conduct business under the direct selling rules. Check to page number 1. All the criminal cases pending against me are stayed by the Supreme Court.
No, what are the matters now?
I'm in the business of e-commerce through the direct selling. There are 2 types of doing business. One is the goods are sold through retail business, where it is through distributors and it is funded in shops. The second mode of business is the direct selling, where I don't go to the retail and instead the person who purchases the product has the option of selling it to taking the product to the different consumers, which is called direct selling. Now, this is a recognized mode of business under the Consumer Protection Act. In recognition thereto, Consumer Protection Act rolled out direct selling rules until the year 2022. Until the year 2022, the industry itself was largely unregulated, on account of which various complaints came to be raised even in those cases where they are entitled to refund.
Just let us see. I'll pass over or repeat it tomorrow.
Please pass over, I'll take a chance.
I have to raise 4:45 tomorrow because 4:45 I have to get raised today. We'll have it tomorrow. Relist the matter in the same stage tomorrow. Yes. Tomorrow on the first round you must be present.
Yes, my lord.
Yes. Next.
51.
Let us see. Yes.
51.
Should I appeal for the not point involved in this matter? The fourth respondent hearing and issued a tender notification calling upon the tender for fishing rights ruled on 1/7/2022 for a period of 5 years. The petitioner was arraigned as highest bidder. But the petitioner, the respondent authorities followed as per Annexure B, had called upon the petitioner to deposit amount on or before 1/10/2022. Then, Lord, I was ready with the DDs. By the time I reached the office, office was closed. I could not remit it. Then, Lord, 2nd October was holiday. 3rd, I paid the amount. In the meantime, Lord, on 3rd itself, they awarded the contract in favor of the 5th respondent. Thereafter, Lord, I filed a writ petition before this honorable court. As per Annexure B, this honorable court has directed the 4th respondent to issue award the tender in my favor. As per the order of Annexure B, operating portion is at page 55. then, my lord, I have paid the amount that has been adjusted towards the fifth respondent, who was the second highest bidder. Again, they told me once again to pay the amount. I have paid the entire amount.
Take your instructions, madam. Find out regarding.
My lord, your lordship, I kindly appreciate, my lord. This tender is for the period from 2022 to 2027. For the last 3 years, my lord, I am not allowed to pitch in, my lord, having paid the entire bid amount. I have tendered my entire bid amount in the year 2020 on 3rd October 2022 itself.
No,
But
but
in
now,
fact, the
correct.
person who has been misappropriated that amount.
No, that other person was not made a respondent in your writ, is it?
He is made as a party to this earlier petition.
Okay,
also.
fine. Yes. Find out.
I'll find out. In the last occasion, this is the now, my lord, the fifth respondent is also not claiming. They have to issue. Your lordship, I kindly for a moment peruse annexure element.
No, correct. Let them complete the instruction. When do you want it?
Or weeks
after tomorrow.
Just wait.
Several adjournments in this regard. Day after tomorrow. Otherwise, my right.
Friday, 27th. Friday, ma'am.
This is the matter. In preliminary hearing list on Friday. Yes.
52.
Interim order may kindly be extended.
Interim order in operation is extended till the next day. There is an interim order.
Yes, sir.
Okay, just check.
And they have, instead of awarding, passing award in our favor, they have issued a notification for fresh tender during the subsistence period of the tender.
Let us see.
Please. Annexure N is there.
52, Satish.
Your Lordship, this is the second round.
I'm appealing for the petitioner.
Second round petition, Your Lordship. The first, they have filed an affidavit stating that within 31st December 2024, they will clear the entire dues. But they have not complied. So immediately we have taken a position. They trespass. And again, they have filed this writ petition. And this writ petition also, this honorable court has directed to pay 20% of the amount. Till the date, they have not complied.
No, one, it is a school, not school sufficient. It is a school, Your Honor. According to the school, nearly about 2.25 crores I paid to the bank. Still, there are 1.25 crores is there. Then the matter is to be sent to the local adalat. We have to settle the matter. Otherwise, we are also sending a mail, Your Honor. The school will be closed and the school property is to be sold.
From January to till the date, he has not paid a one EMI, Your Lordship. One EMI. Forget about the interim order, Your Lordship.
Property. 2.25 crores.
I'm not entering into the merits. You settle it with the bank. You can go before the DRT and settle it.
Hello, matter is to be go to the local adalat.
No, I'm not going to refer. I'm not going to refer to local adalat or mediation.
Otherwise, then the matter is to be one-time settlement is also I offered.
You work it out with the bank. You work it out with the bank.
Sufficient because it is school, Your Honor.
No. I don't look at anybody. No school, no authority, no individual. Surface matters, you have to go to DRT. I will give some time for you to go there. There ends the matter.
2 months maybe.
No. To go to DRT, why you need 2 months? No, that's between you and the bank. Now, bank has not sold your property now. You have time. You settle it. I will give you protection for 2 weeks. You go before the DRT.
There is no interim order, Your Lordship. There is no interim order because it's already vacated in the month of February 2025. Because they have not complied.
Not 1 month. I will give you 2 weeks. You go before the DRT. Because you have not complied with the interim order. If you had complied with the interim order, I would have given you some more time. The petitioner has called in question.
I gave the representation to the bank.
I'll ask them to consider it.
Because they have not allowed.
I'll ask them to consider it. Kodi. That I'll ask them to consider.
Send it to the Gmail, Your Honor.
I'll ask them to consider.
All the efforts was made.
I will ask them to consider.
Because
I'll ask them to consider, but I can't compel them. That is something between you and the bank. The petitioner.
kindly be granted for 1 month, Your Honor. I will go for the DRT. Suppose if there is any possibility to settle within the month,
Not 1 month, anyhow, we'll see. The petitioner has called in question correctness of the order at annexure A, whereby the respondent bank has issued a possession notice. Possession notice. Full stop. Various contentions have been raised by the petitioner regarding the procedural violations. Full stop. The counsel for the petitioner submits that due to reasons beyond their control and closure of schools during the pandemic, petitioner was unable to pay the EMIs. Accordingly, it is submitted that petitioner intends to settle the dues of the respondent bank. Third, counsel for the respondent submits that the substantive remedy of the petitioner is before the Debts Recovery Tribunal in terms of section 17 of the Act. It's further submitted that petitioner has not adhered to the conditions imposed in the interim order dated 10/2/25 and hence is not entitled for any discretionary relief. Full stop. Repeat para 1, 2, 3, 5, 6. Para 4 again. In light of disposal of the petition, it would meet the ends of justice by directing the respondent bank not to take any further precipitative steps for a period of 3 weeks from today.
See, Your Lordship, in this matter, what happened? From the day one, there is no interim order. So because the interim order is vacated in the month of February, so till the date, Your Lordship, again, if at all, they will take the benefit of that.
Now within
because kindly go through Your Lordship for a
correct,
moment.
Correct.
Page
Now,
37, Your Lordship.
Now 3 weeks will go in a jiffy. 3 weeks
Because
will go. After 3 weeks, he is before DRT.
I leave it to the Honorable. Please.
Yes, next.
54. Sachin BS 54.
Yes.
So I need 1 week's time. I have to. They filed. They in the last occasion, they stated, I have not filed my applications for being selected as one of the member of the managing committee. I have sought my copies from the endowment melodies. I'm yet to get. So 1 week's time may be given for me to file my statement of objections, the documents.
In the meanwhile, I'll also get the instructions, madam. Committee is formed, madam.
And they have taken in
Chairman
charge.
of the committee. Chairman of the committee is formed.
And they have an alternative remedy before to go before.
Let us see. They're saying that it's order passed under dictation. Relist the matter in the same stage on. Short date could be 3rd of July.
Represent the state in the matter, my lords. The lords are directed us to give a timeline. Yes. And just pass this across, no?
In case of the affidavit.
Today there are about 5 matters listed.
Yes.
Not to kindly permit me to say this.
We were on the larger issue of directions of
Yes,
the
Lord.
In
Apex
compliance
code.
with my lord's directions, we have. No, so what I'm saying is, what I intend to do, that now only some people are before the court.
Yes.
So what we could do is, we could have an arrangement where they need not every time each person come to court. So first is, he had filed a copy of the a judgment of the Apex Court in special leave to appeal 529 of 21,
Please.
in which some time schedule was given.
Please.
Now, on that basis, the petitioner has filed one, in terms of the state policy, he's filed one separate memo,
Please.
superimposing the directions of the Apex Court. This is filed on 18/6. 18/6. On 18/6 he has filed,
Yes,
which is, according to him, this timeline would be in consonance with that of the Apex Code.
kindly permit me to go through my, place my timeline also.
Yes.
Which along with the memo I filed today.
Yes,
From page 2 onwards, Lord.
yes. Just take me through that.
Yes, Lord. Page 2 would indicate what would be stepwise, Lord. I've indicated from step 1 to step 4. And the tentative timeline, the procedure to be adopted, and the authority who has to consider. In so far as step 1 is considered 3 months time for 4 things, Lord. Identifying the persons eligible for premature release, collecting documents pertaining to those convicts. All documents which are collected will be placed before the advisory board, and the meeting of the advisory board will be convened. Advisory board will consider the recommendations along with the guidelines and recommendations of the petitioners for further proceedings. This is to be done by the jail authorities. The next would be, once again, 3 months timeline. Documents pertaining to the convicts of all the prisons in the state of Karnataka will be verified along with the recommendation of the advisory board, and the meeting of the LCRC will be proposed. Second one, the meeting will be conducted and would consider the recommendation of the advisory board and then send its recommendation to the state government. Third would be, a cabinet meeting will be convened to consider the prisoners for release on prematurity, and after consideration, it will be recommended to the government. The last will be the governor will pass orders in excess of powers under 160 of the Constitution. Not to permit me to come to the next page, page number 4. This is what timeline we adhere to, that is from step 1 would be from May to July, where we do the procedure as shown in column number 3. Step 2 again from August to October. Step 3 November to January. That is the reason in the previous pages I have indicated as 3 months to be the timeline. But however, in so far as step 4 and 5, since it is the office of the governor who has to, the excellency governor has to pass the orders, we cannot fix the timeline within which that could be done. That's the reason why we have kept it vacant.
No, but let there be some nodal officer appointed.
My understanding, there is no, we have.
No, what I'm asking. This process should start 6 months.
14 years complete ಆಗುವುದನ್ನ ಮೊದಲೇ ನೋಡಿಕೊಂಡು 6 months ಮಾಡಬೇಕು ಅಂತ we have requested the officers to do so.
No, correct. So that's why, no, it should be done, which we should push them to do.
Yes, no.
So what I'm saying is the first step, first step of identifying the prisoners.
Please.
That one must start 6 months prior to
completing of 14 years.
That
Yes.
one.
That could be done.
Now you go through this. If there are any further,
Come back if they have any other suggestions.
any further suggestions, you come back. I'll have it on Monday. So you make any constructive suggestions you want, which the state can incorporate, you make it on Monday. And then we will convert it, there should be an undertaking also. For you identify, Banu Prakash, you identify who will be the officials who can give an undertaking for each stage.
I've indicated in my thing. We are following it as per this one.
No, it's not. It's not being done. It's not being done. Now let us see. And then you propose a nodal officer, and we'll see what suggestions they also will give. We'll have it on Monday.
Meanwhile, I'll press for interim order in 55.2. Other day I made a submission.
Actually, 55, the recommendation has been done. In 55.2, they are not eligible and premature for premature release.
It is
He has to
rejected.
challenge it, he has to challenge the rejection order.
That we'll see on Monday.
Please.
Grave urgency because
They're saying you're not eligible now.
they are eligible according to this petition. 55.2. Yes, Manoj. My instructions are that
They have
8717.
1.5. 1.5 years. Yes, Manoj. That is, we are
will be
placing it
placed.
before the advisory board. They have completed 14 years. Now we will be placing it before the advisory board. By Monday, I'll get some more instructions whether it could be released at what point of time or the advisory board could take a decision.
Both husband is in prison, my lord. One is single wife is searching for alliance for their daughter. They want their presence of the.
Let us see on Monday. We'll see.
Please.
We'll see on Monday.
Is not
55.4.
14250. Not, sir. My instructions are they are not eligible for premature.
I call it in earlier. 55, 1425.
Aneksha?
No, objection ಆಗಿಲ್ಲ.
Yes.
ಮುಂದಿನ ಕಳಿಸಲಾಗಿದೆ. ತದನಂತರ ಪರಪ್ಪನ ಠಾಣೆಯಲ್ಲಿ ಕಲಂ 442 ದಾಖಲಾದ ಪ್ರಕರಣದಲ್ಲಿ ಗೌರವ ನ್ಯಾಯಾಲಯವು ಆದೇಶದ ದಿನಾಂಕ 15/9/2024 ಪೊಲೀಸ್ ರಿಮ್ಯಾಂಡ್ ಆದೇಶದೊಂದಿಗೆ ದಾಖಲಿಸಿದೆ. ಪ್ರಕರಣ ಫಲಿತಾಂಶ ಬರುವವರೆಗೂ ಒಂದಿಯ ಕಾಲಿಪೂರ್ವ ಪ್ರಕರಣವನ್ನು ಮುಂದೂಡುವುದು ಸೂಕ್ತವೆಂದು crime number 409 coordinate crime. The coordinate crime granted the interim order on 26th April 25. Case number 59. Following the order dated 8/4/25, it is further clarified that competent authority shall consider the case of petitioner for without taking into consideration of pendency of the imputed crime. In the event that case of transmitted this interim order to the or it is now responding to the
Page 58.
Minute, sir. I will get some instructions, but what I understand now is, since there is violation of 191(2)(1)(2)(j)(2), to say that 6 months has not lapsed the cooling period from the last day of his parole and surrender, that was on 22nd of December 2024. He will be eligible only from 23rd of
June.
July.
23rd of?
Yes, sir. 23rd, 6 months he has to complete, and 23rd of
6
July
months.
he will complete.
6 months after last parole.
Yes, ma'am. December in the
in this petition seeking to place
22nd.
my case before the court without considering my pendency.
He would actually complete it today or tomorrow, 22nd, 23rd. 22nd December he surrendered, so 23rd he will be eligible. He has to now make an application, we'll consider him. 23rd gadre 6 months complete agada.
No, correct. But the Supreme Court direction is it must be
Yes,
done.
ma'am. People who have
So
completed
much.
14 years, this prisoner has completed 14 years.
So
16
much.
years in total he has completed.
16 years.
Yes, of course he has completed.
So I mean, apart from the general direction,
Yes, sir.
we will say that this has to be placed before the advisory board.
Yes, we'll do that.
The petitioner 14250 in 55.4 has sought for a direction to set aside the endorsement at annexure F. And further direction for strict adherence to notification at annexure A. In the case of the petitioner, that in terms of the endorsement at annexure F, petitioner's case for premature release is not being placed before the advisory committee, has been rejected. It's submitted that one of the reasons assigned is pendency of crime number 419 of 2024. Full stop. It is pointed out that by virtue of the order in criminal petition 4707 of 2025, the investigation of the said crime has been stayed. No, the one ನಿಮಿಷ ಏನ್ ಬರ್ತಿದ್ದೀರಾ? One ನಿಮಿಷ. By virtue of the order in criminal petition 4707 of 2025, the coordinate bench of this court has directed that the competent authority would consider case of the petitioner for premature release without taking into consideration the proceedings in crime number 419 of 2024. In light of the said submissions made, the case of the petitioner to be placed before the advisory committee considering premature release if otherwise the petitioner is eligible. Full stop. This full stop. We'll keep it pending though. We'll keep it pending. Huh? Yes, yes. ಆಮೇಲೆ ಬೇರೆದು ಕಾಮನ್ ಆರ್ಡರ್ ಶೀಟ್ ಮಾಡಿ. ದಿ learned additional advocate general Shri Banu Prakash has in response to the proposal of the petitioners has filed a memo detailing the timeline within which action would be taken. For further suggestions and say on behalf of the petitioners. Find out if some kind of a software could be designed to process it. Huh?
We are adhering to whatever the Honorable Apex Court has indicated or directed us to do so. Insofar as the 6 months minutes will get some instructions as to what is the procedure which is in place for identifying those prisoners
Earlier
who
in
are to
advance.
complete 6 months, so that we start the proceedings prior to completion of 14. I'll get that.
Find out. And whether we, some e-system could be worked out, at least to identify. And then some kind of a software could be developed, you find out.
I'll get that. Identification can be made in 16 years.
Correct. But for each step,
So that identification, the scrutiny can be done within that 3 months.
let us see. You come out with your suggestions and you can share your suggestions before them, before you make it before the court. We'll have it on Monday. Relist on Monday. Yes.
56.
ಇಲ್ಲಿ ಆರ್ಡರ್ ಇನ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಅದು ಮಾತ್ರ ಬಾಕಿದು ಕಾಮನ್ ಆರ್ಡರ್. ಎಸ್
In this case, Malad, both the applications have been considered. You sign ಆಗೋದು ಒಂದೇ ಬಾಕಿ ಇದೆ, ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾವು ಅಲ್ಲಿ ಕಾಂಪೌಂಡ್ ಕಟ್ಟಡ ಕಟ್ಟಕ್ಕೆ ಹೋಗೋಕೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. Status got to be maintained ಅಂತ ಹೇಳಿದ್ದಾರೆ.
My lord, on the last date of hearing, lordship has directed us to take decision insofar as the application concerned to the petitioner. My lord, the concerned officer is transferred, due to which we could not take a decision. My lord, if your lordship granted some more time, will.
How much time you want?
My lord, 2 weeks, my lord.
Within 10 days you do it. I'll fix a date. Let us
please.
Relist the
Meanwhile,
matter.
let there be a direction ಈಗ ನಾವು ಅಲ್ಲಿ ಕಟ್ಟಡ ಕಟ್ಟಕ್ಕೆ
In
ಹೋದ್ರೆ
fact,
ತೊಂದ್ರೆ ಆಗ್ತಾ ಇದೆ.
both the representation was considered and the order has been issued by the CEO, my lord. Only allotment letter has to issue to the petitioner. However, for respondent number 3, it has already issued. For petitioner land is concerned, only allotment letter is yet to be issued. That's it, my lord. Representation is considered.
Relist the matter after 10 days, date good. Both parties to maintain status quo as on date till the next date. But once they give it, then you must also take a reasonable stand. Let us see. Yes.
Meanwhile, my lord, let them not interfere with the putting up. ಶಾಪ್ ಕಟ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ interfere ಆಗ್ತಾರೆ. ನಾನು ಪ್ರತಿ ತಿಂಗಳು 30,000 ರೆಂಟ್ ಕಟ್ತಾ ಇದ್ದೀನಿ, ದುಡ್ಡೆಲ್ಲ ಕಟ್ಟಿದ್ದೀನಿ. ನಾನು
No, in so far as their allotment is concerned, he's saying don't restrain them from putting.
let the undertaking may be recorded.
In so far as the petitioner in the other writ petition, what allotment is made to him?
No, he is the respondent number 3. They have not filed any writ petition.
Okay, wait, let us see. Yeah,
Let
let us see.
there be not to interfere with the putting up of shop, my lord.
No, that he has challenged now. Let us see.
ಅಲ್ಲ ಇಬ್ಬರಿಗೂ ಅರ್ಧರ್ಧ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
The order ಬರ್ಲಿ, then we'll see what is.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹಾಕಿದ್ದೀನಿ, ಅವ್ರಿಗೆ ಅಲಾಟ್ ಮಾಡಿದ್ದೀವಿ.
Let an order be passed, then we'll put them on terms.
Please.
Yes.
57, Mahesh Kiran Shetty.
There's the judgment. It has to go to, last time my lordships directed me to produce that pro nits judgment, my lord. It clearly says, my lords, if it is not raised before the account is classified as a NPA, then that ground cannot be raised at the later stage. Now sale notice is issued. In fact, the petition has become infructuous. Because of the interim order, we have not conducted the sale at all, my lords, in this case.
Paragraph?
My lords?
Paragraph?
Paragraph 17, my lords. Ninth line from the bottom.
Read para 17.
Yes. Entire 17.
Yes.
Yes, ma'am. It is also pertinent to note that sufficient safeguards have been provided under the said chapter for safeguarding the interest of the defaulters, borrowers, for giving them opportunities to discharge their debt. However, if at the stage of classification of the loan account of the borrower as NPA, the borrower does not bring to the notice of the concerned bank creditor that it is a MSME under the MSMED Act, and if such an enterprise allows the entire process for enforcement of security interest under the SURFACE Act to be over, or it having challenged such action of the concerned bank creditor in the court of law tribunal and having failed, such an enterprise could not be permitted to misuse the process of law for thwarting the actions taken under the SURFACE Act by raising the plea of being an MSME at a belated stage. Suffice it to say, when it is mandatory or obligatory on the part of the banks to follow the instruction directions issued by the central government and the Reserve Bank of India with regard to the framework for revival and rehabilitation of MSMEs, it would be equally incumbent on the part of the concerned MSMEs to be vigilant enough to follow the process laid down under the said framework and bring to the notice of the concerned banks by producing authenticated and verifiable documents materials to show its eligibility to get the benefit of the said framework.
Now, when did they bring it to your notice?
My lords, now in the writ petition, this issue is raised for the first time, my lord.
Not before.
This is the second writ petition. Now, first time it is raised. This is at the stage of sale notice, my lords. An interim order was granted. Sale has not taken place, in fact, in this case.
They have not raised it before.
They have not raised it before, my lords. Before the account is classified as a NPA, they should have raised this issue. They should have come forward. Your lordships may see that circular, my lords, in that same judgment, it's extracted. For a moment, your lordships may see para 13, my lords, just above para 13.
Yes.
The salient features of the framework are as under. Before a loan account of an MSME turns into a NPA, banks or creditors should identify incipient stress in the account by creating 3 subcategories under the special mention account category as given in the framework. Any MSME borrower may also voluntarily initiate proceedings under this framework. Committee approach to be adopted for deciding corrective action plan. Timelines have been fixed for taking various decisions under the framework. So before it is classified as NPA, all these steps have to be taken under the framework. And they should raise this issue, which they have not done. So at this stage, when sale notice is issued, my lords, they can't come and say this circular is applicable and pro nits judgment is applicable.
Thursday. But the law is clear. We can't.
That is not the case. My lord, they, in fact, from day one, they have been misleading this honorable court. The third round of litigation, if your lordships could kindly.
Have you raised, forget about that. Have you raised this point?
Yes, my lord, in the earlier round of litigation also we have raised, I'll point out, my lord, it may be taken up for us.
You must produce material to show that you have raised this point before it was classified as an NPA. If that is not done, no doubt substantively you may have had a right. Now you cannot raise. That is the position of law. Thursday.
Much of.
Interim early grant is extended to the next day. Yes, relist on Thursday.
58.
I appear for respondent in this matter, my lords.
Yes. No representation on behalf of the petitioner. List week after next.
59.
Here for the petitioner, my lord, seeking the writ of mandamus for releasing the unpaid bills by DNP, my lords, for the COVID RT-PCR testing.
Yes.
Very covered, my lords, by the
Yes.
decisions of the coordinate bench.
No, what decision? They have to pay money, isn't it?
Pay unpaid bills, it is under a particular notification. I was allotted the contract to do the RT-PCR testing during the COVID period, my lords.
Yes.
This is of the year 2022.
My lord, my senior held up in another court, my lord.
That is there. Now, when will you pay the money?
How nami pay ಮಾಡಬೇಕಾಗಿರೋದು?
That's what I'm asking. What is that order?
My lords, the order is to pay the money, outstanding sums along with 6% interest. May I just pass on?
No, first we need to know how many other people they have to pay.
My lords, two other writ petitions were filed. They were also awarded the contract under the same circular. If your lordships for a moment sees the first.
So let us see. Yes.
My lord.
They had only appeared.
When do you want it?
They have only appeared, in fact, in both the matters.
4 days, man.
Huh?
4 days.
We'll have it on Monday.
Monday is the same stage.
This is the matter Monday in the same stage. Counsel for the petitioner submits that order be passed in terms of order passed in WP 16979 of 2024 and 16851 of 2024 for say of the respondents.
60. 60.
List V. Yes.
And the offense is 302, my lord. The petitioner has already undergone 6 years, 2 months.
Find out.
My lord, one submission, my lord. The endorsement was issued in the year 2022, my lord. And my instructions are that, my lord, there is no new application from the petitioner, my lord. Let him file an application now, my lord. That will be considered, my lord.
Now your application was rejected in 22. So you file a fresh one. I'll ask them to process it and fix some time.
It may be fixed, my lord. Time may be fixed.
It will take 1 month, my lord. Minimum 1 month to get the endorsement.
No,
Time may be fixed by
we'll
this.
fix a time limit because of your earlier application.
Yes, my lord.
The petitioner has sought for relief of being sought for a direction to the respondent to release him on parole. Please notice that the endorsement rejecting the earlier application was passed on 29/8/22. In light of lapse of time from the date of endorsement, it would be appropriate for the petitioner to make out a fresh application seeking grant of parole. If the same is filed before the competent authority within a period of 1 week from today, the respondents to take an appropriate decisions within 3 weeks thereafter.
Please.
Accordingly, petition is disposed of.
61.
For the petitioner. This is a petition by the estranged wife, my lords. She's been asked to leave the premises of the government accommodation by virtue of her husband having superannuated from the service, my lords. My only submission is, my lords, the application for alternative residence is already pending, my lords, before the Honorable Trial Court. I have addressed my arguments, my lords. Respondent number 4 is due to address it on Monday. Your lordship may kindly have it during the first week of, my lords. I've informed the petitioner to, my lords, find out an alternative accommodation, my lords. I know, my lords, only because they shouldn't be left homeless is why I have approached this Honorable Court.
If you say you want 4 weeks time,
Let them,
I can pass some order, but you can't keep it.
No, my lords,
So how much
it's,
time you want?
it's for the respondents' arguments on the 30th, my lords, before the Honorable Trial
No,
Court.
forget, delink that from this.
Where I've asked for alternative accommodation, my lords.
Delink that from this. Now, after order is passed, they will come to the High Court and get a stay of that order. So we really don't, you can't link that to this. You tell how much time you want.
My lords, your lordship may grant 4 weeks, my lords, I will.
You file an affidavit.
I file an
I'll have
affidavit
it day
next
after
day.
tomorrow. You
No, it's
file an
Monday, my lords, Monday.
You file an affidavit, but delink it from the other litigation.
Please, my lords.
List the matter in preliminary hearing list on Monday. Counsel for the petitioner submits that they would file a necessary affidavit seeking permission to stay in the accommodation for a period of 4 weeks. Affidavit to be filed in that regard. Yes.
Grateful, my lords. My lords, interim order may be extended.
Intermodern operations extended till the next date.
62 attend 63.
Yes.
Appeal for petition, my lord. My lord, under the Senior Citizen Act, my lord, the third respondent filed a
Is that
petition.
in interim order?
Interim order is there, my lord.
Then let us see.
My lord, the petition itself is not maintainable. In view of the, my lord, provision of the Senior Citizen Act against a daughter-in-law, my lord. When son is alive, my lord, they can't file a, my lord, petition against daughter-in-law. My lord, kindly take, my lord, definition clause,
Senior Citizen
section
Act.
2.
Daughter-in-law cannot invoke the provision.
No, against daughter-in-law.
Yes, daughter-in-law.
Against daughter-in-law, they can't invoke. Since son is there.
No, what is the case now?
Now, my lord, the third respondent.
This also respondent 2 number husband property, my lord.
No,
Not
just,
absolutely belong to
just
the.
1 minute, we'll see. What is the point you're raising now?
My lord, the section 2A.
Two, my lord.
Children.
Section
2A.
2A, my lord.
Definition class. Children's means, my lord, include a son, daughter, grandson, and granddaughter,
No,
but
who-
does not include a minor.
Now, who has invoked the provision?
Then the mother-in-law is invoked against daughter-in-law, though son is alive.
No, who has gone before the assistant commissioner?
My lord, the petitioner and third respondent are before assistant commissioner, my lord. Atte sose ಮೇಲೆ ಹಾಕೋದು.
Petitioner is the mother-in-law.
Yes, my lord, mother-in-law.
And respondent is the daughter-in-law.
Daughter-in-law. When, my lord, son, another son, elder son is alive, my lord. It is not, my lord.
No, where does this? No, where is this?
Well, the definition of children, who become children, my lord, it is there. My lord,
No, go to section 23.
23 ನಲ್ಲಿ for ejectment.
No, the petition is filed for what before the assistant commissioner?
Before,
Under
my
which
lord,
section?
to-
Under which section?
My lord.
7-1.
Huh?
7-1.
You're seeking for maintenance. She has sought for maintenance, is it?
Not maintenance, my lord. To vacate the scheduled property. May brief, my lord, a brief facts, my lord.
No, I'm not on the facts. We're only on the jurisdictional point.
Yes, my lord.
So you say under what provision the mother-in-law went to the, went before the.
To get vacate, my lord, the petitioner from, my lord, ground and first floor of the scheduled property.
So now direction is to be passed under what section?
ಅವರು ಹಾಕಿರೋದು 7-2 ಕೆಳಗಡೆ. ಪ್ರಾವಿಷನ್ ಹಾಕಿದ್ದವ್ರು 7-2 ಕೆಳಗಡೆ.
So then you point out under what provision you're saying it has no jurisdiction, for which you have to point out the power of the tribunal.
I am saying that, my lord, against daughter-in-law when son is alive, Against daughter-in-law, the petition itself is not maintainable under any provision of law. Under definition clause, my lord, she will not come.
Definition must be read in conjunction with the provision. So you point out, no?
And then, my lord, kindly come to annexure G, page number 93.
If the mother-in-law is proceeding against the daughter-in-law,
Yes, my lord.
then under which section she is claiming relief? Yeah, under that
My
section.
lord, kindly come to page number 93, annexure G, my lord. Petition filed by the third respondent. Page number 93, my lord. Provision of law, they have not mentioned.
Correct. So now you make out, you tell us that in section so and so, the relief is sought and they don't, the daughter-in-law will not come under the definition of children, there ends the matter. So you have to trace it to some provision.
Order of the Assistant Commissioner. Paragraph at page 111, section J. First paragraph, the AC right is under 4 and 5 of the.
Under section 4 and 5.
4 and 5.
The section 6, the proceedings under section 5 may be taken against any children or relative. So let's assume that the mother-in-law now has filed against the daughter-in-law. So it should be against children or relative. So the definition of children will exclude daughter-in-law. Relative.
2A. There, my lord, G. G is the definition of relative. G. Relative means any legal heir of the childless senior citizen.
Childless senior citizen.
Not a minor and is in possession of or would inherit his property after his death.
Yes. So Mr. Orla, they are saying that there is no jurisdiction because the power under section 6 says it can be only with respect against children or relative.
Lord, only thing is we are relying upon Lord, the act. Act has been given some Lord, meaning. And Lord, it's an act, Lord, which is of social importance. One judgment I'll give it to your Lordship, Lord, and then Lord, your Lordship may, Lord. Noted. Huh? Everybody on top. Please speaking.
D also can be read. D. D also will be read. And then D and G. The parent also. Otherwise also. The definition of parent also.
Section 24. Eviction ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ.
Eviction ಸರಿ ಯಾರು ವಿರುದ್ಧ?
This husband property. Husband property.
Yes.
Mumbai third share ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೂಪರ್. In number 189, filed by the very same respondent petitioner, seeking 1/3 share in the social property.
Jurisdictional issue. I mean, so far as eviction is concerned, the judgment says you can. But now under section 6, proceedings under 5 may be taken against any children or relative.
Yes, yes.
Now the respondent is a daughter-in-law.
My Lord, because what happened was there was my Lord a son. Son died. Thereafter, my Lord, she my Lord came into the picture.
No, but you examine this It's a jurisdictional bar.
On.
Another thing may I
Please
say, my lord,
Understand, because
my lord,
it may have some bearing, my lord, ramification, my lord, across the board.
No, but now they're simply filing everything, everybody's entertaining. Monday. Monday,
Lord, Monday ಸ್ವಲ್ಪ problem ಇದೆ.
you tell us when.
Thursday ಆಗ್ಬೋದಾ? Third.
Relist the matter on third in the
Please,
preliminary
wait.
hearing list.
apart from that, my lord,
It's no, only on the jurisdiction, not on merits.
Please, I understand.
Petitioner submits that the daughter-in-law would not come within the purview of persons as contemplated under section 6.
ಇಲ್ಲಿ daughter-in-law ನೇ. ಇಲ್ಲಿದೆ ತೊ. ಅದನ್ನು ತರ್ಸಿರೋದು.
ಅದ್ರಲ್ಲಿ entry ಮಾಡಿದ್ರೆ extend.
may request, my lord, ಇಬ್ಬರು ಮಕ್ಕಳಿದ್ದಾರೆ, ಇವಳು ಅನ್ಎಜುಕೇಟೆಡ್, ಅಲ್ಲ ಅದು ಈವನ್ ಸ್ಕೂಲ್ ಫೀಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಇಲ್ಲಿ ಅವರು ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಇಟ್ಕೋತಾರೆ, ಸ್ಕೂಲ್ಗೂ ಫೀಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
That you work it out, let us see. Next.
Petitioner, my lord.
My lord, I'm from R3.
Technical bid is rejected without assigning any reason. My bid, my quote is 40 lakhs less than the respondent number 3 in the bid value of 11 crores.
My lord, we have been served with a copy on
Let us see, just wait.
On the last date of hearing, instructed me that we do inform the, as LOI is already interested to the third respondent. Please keep informed the third respondent so that they may come through an advocate to place this time. My respectful submission is, prior to institution of the writ petition, the LOI is already issued and work is already started by the third respondent. My instructions are, Your Lordship is pleased to take to the internal ink page number 51 of the writ petition paper book here.
Yes.
Lordship finds serial number 1 in the second column, technical compliances. This bid was rejected under the non-fulfillment of the technical formalities required for the tender documentation.
Page
51 of the writ petition paper book. 5-1.
That is the tender technical compliance.
Yes, technical compliance. Serial number 1, Your Lordship finds here. Tender shall be rejected if it is not accompanied by the following. So this was the, if Your Lordship in the next page here, Your Lordship finds 1.8.3. Lordship finds that, I'll read out. In cases where one or more members of the JV is/are companies, the following documents shall be submitted. A copy of the resolution of the directors of the company, permitting the company to enter into JV agreement. Second, copy of the MOA, Memorandum of Association/AOA, Articles of Association of the company. Third, a copy of the certificate of incorporation. The fourth is one what we are relying upon here. Copy of the authorization/power of attorney issued by the company, backed by the resolution of the board of directors. This is where I emphasize here. Backed by the resolution of the board of directors in favor of an individual to sign the tender, sign the MOU/JV agreement on behalf of the company and create liability against the company. This is where was the point which compelled us to.
It's not done.
It's not been submitted with this requirement here. Next, I would like draw your lordship's attention to the next at ink page number 85 here.
So it was rejected at that stage.
Lord, kindly see the impugned order, whether all these things are pointed out at that stage, my lord.
My lord, our contention
Page
is-
14, my lord.
Contention is as per the tender document which is signed by the petitioner, accepted all the terms and conditions.
That's
When
all
they
right.
do not qualify, automatically it says it will be rejected.
Correct. So what they're only saying is that.
You should have made known to us.
No, if this is so, the rejection should have been at least.
Communicated.
Where?
Rejector is communicated.
14, page 14.
Rejector is communicated. He is against the rejection of the.
Kindly go to page number 14, my lord.
Lord, my instructions were, my lord, the person who enters into the tender document, signing the tender document.
Failed to satisfy the requisite eligibility criteria stipulated for JV.
All the-
That is all they state.
Has to understand all the terms and condition, before signing, uploading. This is all online uploading. It's not physical copies.
No, correct. Now, the fact that you are making an assertion may be true, but the reason
The manner in which
the
it is
reason of
communicated.
communication is wanting. At annexure A, you say failed to satisfy eligibility criteria stipulated
for JV.
JV. That is on the merits.
Yes, ma'am.
They're only on the point that this aspect is not made known to them.
It was communicated.
Wait, let them show.
Annexure A, page 14. That's a different reason. That's all they're saying. They were under the impression that this is the reason.
Failed to satisfy the requisite eligibility criteria stipulated for
For
JV.
JV. This is not the, now what you're saying, tender document.
My lord, it is in the part of tender document. If your lordship now
No.
pleases to take document number.
No, correct. So you put it in writing, that's all. They are not saying that that may not be true, but the reason assigned is different from what you're saying. Is
Kindly
what
go to page number 146, my lord. I have produced all those documents.
C, GCC. They have also enclosed GCC which starts from 56.
146, may kindly.
C.
Power of attorney I have produced.
Your lordship.
MOU for JV we have produced.
Joint
Some foul play can be attributed, my lord, having regard to the fact that.
No, they're saying they have produced the.
Yes, I have produced 146. Power of attorney I have produced. JV I have produced. No, had the not CV manual says if any shortcomings of these kind of papers, I should be informed. I would have made good.
The power of attorney should be backed by the board.
How the tender inviting authority will be subjected to prejudice had they called upon me to produce the documents which were not made available.
Lord, it is the part and parcel of the tender.
Now you put it in writing.
Yes, ma'am.
But till such time, let them. No, it is not that overnight the work order is issued. We know from last 10 years it is pending. Let them not precipitate the issue.
Any action taken subject to orders to be passed.
Yes,
the private respondent cannot plead equities in the event of suffering an adverse order.
My lord,
Please.
your lordship is pleased to take the order of
That's
the
all right.
Honorable Court dated 29/5/2025. This Honorable Court has already passed.
So now you file it.
The lordship has added not to plead equity. That's good. That's fair enough.
Now you file it in writing. The respondent, you appear for one. R1 to take their stand in writing regarding the reasons.
R1 and R2 both.
R1 and R2 to take the stand in writing regarding the reasons for rejecting the application of the bid of the petitioner.
Yes, ma'am.
Detailed particulars, madam.
Huh?
Particulars, details of the particulars on which they.
My instructions were there based on the LOA. The respondent number 3 has already.
No, that's okay. We have not disturbed it. But you put it in writing. How to mold the relief, we'll see.
Yes.
My lordship, I'm appearing for respondent number 3. I will also file my reply to the
relist on
Friday, my lord. Friday.
Monday, my lordship.
Because I need to send it. I need to take the comments.
2nd of July. Yes.
Yes.
Maybe a few more days more because we need to get it approved and get it signed and place it on.
7th. Inform.
Yes,
Kalyan.
I'll just keep him.
Yes.
My lordship, waited for a remission report.
My lord,
Yes.
my lord, on last occasion, my lord directed me to get the status of this premature release application, my lord. Now it is in the office of the governor, my lord. In a week or two, my lord, they may get the order, my lord. That is the status. And the parole time may be extended, my lord.
The counsel for the respondent state submits that the recommendation of the advisory committee is pending in the governor's office.
Yes, my lord.
Submitted that the parole earlier granted may be further extended.
Please.
Accordingly, The parole earlier granted is further extended by a period of 45 days.
Please, my lord. Or till the.
My
order.
lordship,
Conditions,
we requested for 90 days, my lordship.
conditions imposed in WP 8563. 8563 earlier round, is it?
Yes,
Huh? What are the conditions now?
8563, my lord.
The conditions imposed in WP 8563 of 2025 are to be extended in the present case also. The conditions so stipulated in WP 8563 of 2025 is as follows. So we'll keep it pending. Relist.
Disposed of, my lord.
Huh?
My lordship.
No, again he'll have to come for parole then.
Yes.
Relist after 40 days.
45.
66.
Thanks, Lord.
For the respondent, I
Yes.
handed over the movals of the petitioner, my lord. Complaints report I am submitting. He acknowledged it. Mobiles ಕೊಟ್ರೆ ನಮ್ಗೆ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗ್ತದೆ, ನಾವು ಏನು ಕ್ಲೈಮ್ ಇಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ. Annexure 1 page number 6 ಅಲ್ಲಿ ಅಕ್ನಾಲೆಡ್ಜ್ ಮಾಡಿದ್ರೆ ಸರ್ ಮೂವಲ್. ಪೇಜ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ಅಕ್ನಾಲೆಡ್ಜ್ಮೆಂಟ್ ಅವ್ರ ಮೂವಬಲ್ಸ್ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ. ಅದಾದ ನಂತರ ಪ್ಯಾಕ್ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲ ವೆಹಿಕಲ್ ಗೆ ಬುಕ್ ಮಾಡ್ಕೊಂಡು ಫೋಟೋಗ್ರಾಫ್ಸ್ ಹಾಕಿದೆ ಸರ್.
It is signed by
ಪಿಟಿಷನರ್ ಸಮೇತ ಅಕ್ನಾಲೆಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪಿಟಿಷನರ್ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ರು. ಇನ್ ದ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್. ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇದೆ ಸಮಯ.
The counsel for the respondent bank has filed a memo. Has filed a compliance report. And it is submitted that in terms of annexure R21, R21, the petitioners received the movables. Duly acknowledged. Full stop. Next, peruse the order dated 6/6/2025. Submission of petitioner was to the effect that the grievance raised is limited to recovery of the petitioner's movables in the premises which have been sealed. In light of the compliance report filed and annexure R21, petition is disposed of as not calling for adjudication, as a petitioner has received the movables. Yes.
67, 68, 69. 69. Joseph.
Madam, for the respondent number 3 company in this matter, my lord.
Please, Manoj. Lordship will kindly see
Your
the
permission,
earlier
my
order passed by this honorable court at Annexure P, page 129.
There is a jurisdictional issue in this matter.
Was the prayer in that petition, Millard's set aside, praying to set aside the proceedings, order dated 16/8/2022, the learned debt recovery tribunal dismissing the petitioner's petition, wrongly proceeding the premise of non-representation. Second prayer is.
No, which page?
Second page 129, my lords. WP number 15498.
Yes.
The prayer, my lords, preamble, the second prayer therein, direct the respondent 1, that is the learned debts recovery tribunal, to consider at the earliest the petitioner's miscellaneous application in date number so and so, maintained on the grounds of fraud and mischief shown therein. My lords, here also those materials are there, my lords. My lords, the fraud in obtaining the ex parte order, it's an ex parte order which I suffered. The ex parte order is of 2012. The recovery officer issues recovery certificate 8 years later. That was 2020. That time I come to know, that time I maintain this petition. My lords, the respond number 3 as an assignee comes into picture on 14/6/2018, 6 years after the fraud. Now, my lords, before his lordship passed the order, my lords, I'd cited 2007 for SEC 221. Based on that, my lords, the Honorable Judge, my lord, requests the Debt Recovery Tribunal consider my miscellaneous application. Your lordship had cited this judgment, my lord. Para 40, my lords. Kindly see para 40, my lords.
Lord, in this case,
I shall come to it. May I read, my lords? Paragraph 40, my lords, at page 237.
They have not considered your miscellaneous.
They have not considered, they are considering the application on grounds of delay. My lords, the fraud, my lords, those materials were there before the court on that, in that writ petition. I shall demonstrate, my lords, your lordship will kindly see annexed here, my lords.
No, correct. So now what is your grievance? Your grievance is?
Pardon, my lords.
What is your grievance now?
My grievance, my lords, is my miscellaneous application has not been considered. There is a court in considering one is a fraud. When it comes to my notice, I file a miscellaneous petition. That miscellaneous petition is wrongly dismissed, saying that on several occasions I have not appeared. I have produced that order sheet also. Now, my lords, the mischief, my lords, at page 31.
No, I'm not on the merits. Now, what is it that the DRT is required to consider now?
DRT is required to consider my miscellaneous application. That was the request which was made by this honorable court.
Oh, that was dismissed.
yes, my lord.
On the ground of delay, it is not considered. My miscellaneous application is not considered.
No, where is that order?
That order, my lord, your lordship gets it at
Ink page number 129.
120. That's annexure. 132, my lord's annexure Q. The operative portion, my lords, your lordship gets it at in result, IA, that is delay continuation application, and consequently MA are dismissed at page 140, my lords. My miscellaneous application as requested by this honorable court has not been considered.
No, but they've considered and
they consider only the delay application.
you have to.
Now, your lordship will kindly see, my lords, the fraud.
No, that's a different matter. Now, this order you challenge now.
My lords, I filed an application.
Dismissal
My lords, because that miscellaneous application was dismissed on wrong grounds,
Correct.
I filed another miscellaneous petition. What was directed to be considered is the miscellaneous application which was wrongly dismissed.
No, now
Now, your lordship will kindly see, my lords, kindly see page annexure, the mischief, my lords.
No, I'm not on the merits. Now, MA 14 of 23 has been dismissed.
Has been dismissed.
You challenge that now.
Now, your lordship, I shall, my lords, I have been already labeled as a guarantor for no reason. Even I have produced the evidence which I produced the list of documents which does not show any documents executed by me.
That order in MA you have to challenge now.
Your lordship will kindly see, my lords, annexure A, page 31.
Not on the merits. You have to challenge the MA.
Your lordship will kindly see, my lords, under section 31 of the RDB Act. I am required to deposit 10 crores, even if it is 25%, for no reason. Now, your lordship will kindly see of one moment, my lords, annexure A. They address what I have shown.
Okay, let us see. We'll hear it. I'll fix a date. We'll hear it.
My lord, in this case, my lord.
In this case,
section 20 is very clear. My lord, any order passed by the DRT, my lord, even if it is a question of a delay, my lord, the remedy lies with the.
No, I have not passed any interim order.
Yes, my lord.
They have
the interim order could not be passed, my lord. In this case, my lord,
I am at a threat of dispossession. Your lordship will kindly
my lord, in this matter, 2013 recovery certificate was issued. My lord, RC was issued not in the year 2018, 2013 recovery certificate has been issued. My lord, when the attachment was made and a notice has been issued to the petitioner, my lord, in the year 2020, in the year 2019, the petition has come before this honorable court by filing a writ petition, which is at annexure annexure B, page number 93. And my lord, this honorable court told this is dismissed for default. You go and file an application for restoration. My lord, thereafter, my lord, the miscellaneous application, restoration application was filed in diary number 2195 of 2020. My lord, that miscellaneous application was not prosecuted. And again, that has been dismissed for default on 16/8/2022. My lord, thereafter, one more writ has been filed before this honorable court. What he has referred, my lord, that writ, the honorable court observed a plural remedy could not be granted. Your miscellaneous application is pending before the honorable DRT. Go and pursue the miscellaneous application. My lord, thereafter, my lord, that miscellaneous application was dismissed. Then MA 23, which is the impugned order, my lord, 2023 was filed. My lord, again he comes before this honorable court. This honorable court directed him to go before the DRT. Whatever your contention are there, you urge before the DRT. My lord, the honorable DRT, after having considered all the facts and circumstances of the case, has come to the conclusion a miscellaneous application was filed after a decade. And my lord, the miscellaneous application was dismissed on 22/7/2024. My lord, after 22/7/2024, my lord, he has not taken up the matter. Once again, sir, taken up the matter. My lord, he participated. That is his miscellaneous application was dismissed on 22/7/2024. My lord, when the recovery officer again initiated the process, my lord, to take appointed the advocate commissioner to take the property, my lord, he is before the court. If at all, my lord, if he is aggrieved by the impugned order in MA 14 of 2023, you could have come before this honorable court or could have filed an appeal before the honorable DRT by invoking section 20.
Anyhow, there's no interim order passed. Relist week after next date.
Your lordship will kindly see the order sheet, my lords, of the DRT.
But let us see. I'll hear it week after next.
Much obliged.
70.
Much.
70 that I am putting for the petitioner, mother. Demand notice has been challenged, mother. Questioning, mother. Yesterday, mother, the petitioner has submitted one representation to the third respondent, mother. Yesterday, mother.
Yes. To pay the
25%, I am ready to pay 25%. In that regard, mother, a written submission to the third respondent, mother. It is still consideration, mother. Yesterday, I submitted, mother.
You have to pay 4,61,000.
4,61,000, out of which, mother, I am ready to pay 25% of that amount, mother. Remaining amount, mother, sought for time, mother, due to financial crisis, mother, because previous year, mother, due to loss, mother, I have not get any income, mother. I have submitted representation, mother, yesterday, mother.
Okay, we'll have it. Let the government consider.
Yes, sir.
Yesterday, I will file it in the registry, mother. Your lordship may kindly see that, mother.
Okay, I'll have it week after next week.
Please, mother. Please, mother.
This
This memo is filed before the registry, mother. In the office, mother, we are going to.
petitioner submits that he has made a representation to the respondent.
On 23rd, mother.
On 23rd. List
Still,
after 2 weeks.
sorry, mother. 2/6/2025, mother.
Yes, 2/6/2025. List after 2 weeks.
Please, mother.
Fourth matter, serial number 1, Ajay N. Ajay.
Lordship, this is we're challenging the Annexure A, your lordship, which is in page number.
Canara Bank.
Caveat has been served, your lordship.
KV Lokesh. KV Lokesh.
Yes.
So we are challenging Annexure A, section 14 order.
What ground?
Lordship, as on today, I am ready to pay a certain amount, your lordship.
Not before this court. You go before the DRT.
Your lordship, I had difficulties during this period, your lordship. I'm ready to pay the amount. There was an OTS that was also given in my name.
So you go by, will protect you. Go before the DRT.
Lordship, at least 2 weeks of time may be kindly granted, your lordship.
Yes.
Without precipitative action initiated by the bank.
Vignesh, yaru? Lokesh. Your friend Lokesh is there?
I'll inform you.
Huh? I'll dispose it of 2 weeks time. I think. It could have come up tomorrow only.
Today is the position that they were taking over, Your Lordship.
Lord, that being the case, my Lord,
As per the
that somebody filed a caveat, my Lord, have it tomorrow. Till
Tomorrow.
such time, my Lord wanted to pass a mortem, my Lord may pass. So somebody, my Lord, already in caveat.
Okay, orally you say nothing
I'll
will
inform
happen.
the same. I'll inform the same.
Relist tomorrow.
Please, Your
The fresh matters list.
Please.
Yes.
Serial number 2, Malaswamy. PM Malaswamy.
The respondents, my lord, started demolition of the buildings, my lord, were stating that this is a forest land, my lord, without issuing notices, my lord, and my lord, the issue whether the issue regarding, my lord, this Kadugodi plantation, whether it's a forest land or not, it has been already decided by this court, my lord, which has reached to Supreme Court and it has attained finality, my lord. No, my lord, the industries have come, my lord. This is a settlement, my lord. A cooperative society is a joint cooperative society was formed and handed over in 1950s, my lord. These are the persons who are the allottees of sites, my lord. Kindly see annexure A, my lord. 19, my lord. It's from the 1865, my lord. The land was a Karab land, my lord, which was there was a plantation, my lord. Then subsequently, my lord, under in 1869, my lord, a notification was passed, my lord, under forest rules, my lord, stating that it's a plantation and it's a forest, my lord. Then subsequently, my lord, kindly see annexure. This land out of the 711 acres, my lord, 562 acres have been de-requisitioned, my lord, and in order to give it to the cooperative farming, my lord. Kindly see annexure B, my lord. At page 26, my lord. Possession has been taken, my lord, and it has been handed over, my lord. Kindly see at annexure C, my lord. This is where mutation was entered in the year 1950, my lord, in favor of cooperative farming society. Then what happens, my lord? RTCs, my lord, since 1970s onwards, my lord, RTCs have been coming with the farmers in the name of the farmers, my lord, at page 28.
These are vacant lands.
Pardon?
Vacant land, is it?
It was a land, my lord. What happened, my lord?
So now what is the?
Now, my lord, it's houses have been built, my lord. Photographs have produced, my lord. Even that society has allotted the sites, my lord, at annexure E, my lord, page 30. This is allotment of site by the very same cooperative farming society, my lord. Houses have been built, my lord. Entire village has come, my lord. Settlement has come, my lord. Now, whatever the remaining land, my lord, out of the remaining land, my lord, the KADB has acquired some of the lands, my lord, and given it to the industries, my lord. Now, kindly, this, I will pass on this judgment, my lord. These two judgments in respect of the issue which has been covered by this judgment, my lord. The very same land, my lord. Kindly see paragraph.
Furnished to us also.
Paragraph 9, 10, and 11, my lord. Paragraph 9, my lord.
No, now what has happened now?
No, my lord, without notices, my lord. Now they are relying upon, though this land is not a forest land which has been adjudicated by this court, my lord. Now they are relying upon this Godavarman case, my lord, which where the full bench Supreme Court passed an order in 15/5, my lord, stating that under that we are recovering the possession, my lord. The houses have been built, my lord. Kindly see the photographs, my lord, where the entire might of the state is included, my lord.
Paragraph?
Paragraph 7, my lord. 9, paragraph 9. The Revenue Commissioner in Mysore by letter dated 4/7/1950 addressed to the Chief Conservator of Forest in Mysore and a copy to the Commissioner, making reference to the order dated 15/6/1950 in the matter of issue of discharge certificate as agreed by the Conservator of Forest dated 13/2/1950, communicated the fact of derequisition of 572 acres 6 guntas of Kadugodi plantation and requested it to hand it over to the Deputy Commissioner, Bangalore District. The Deputy Commissioner, Bangalore, by letter dated so and so, called upon the Amaldar was quoted to submit a report taking possession of the land from the Forest Department and also to submit if there is any plantation area under the military department. It was even in the military, now kindly see at paragraph. Consequent upon the release of the land to the revenue department, its possession was handed over to the Kadagodi Samika Vyavasaya Sahakara Sangha consisting of the members belonging to the scheduled castes and scheduled tribes for cultivation, pursuant to which the said members were put in possession of certain extents of land for cultivation. The said Sangha, when constituted a cooperative society registered under the Societies Act, was known as Kadagodi Joint Farming Cooperative Society, Vaskote Taluk, that having become defunct, deputy register of cooperative societies, so and so, appointed under the cooperative extension officer as liquidated to wind up so and so. Now kindly come to, based on, my lord, because these are industries which have been set up, they were also called upon to, because they were, it's a at page 41, my lord, paragraph 58. Paragraph. Having heard a learned counsel, peruse the materials and record, keeping in mind the admit effects, the following points are raised for consideration. Whether survey number 1 of Kadagodi classified as government plantation is deemed reserve forest under the Karnataka Forest Act. Now kindly see, it has been answered, my lord, at page 70, my lord. Page 56, paragraph 17. Page 56, my lord. Because nothing has been followed, my lord, the regulations. Apparently, the notification dated 7/1/1901. Page 56, my lord.
Yes.
Second paragraph. Apparently, the notification dated 7/1/1901 and issued under 23 of the Mysore Forest Regulation does not comply with any of the regulations under Chapter 2, so as to deem the land in survey number 1 of Kadagodi plantation to be state forest. The submission of the learned special counsel stands rejected. Regard being at the opinion that the land in question is not state forest under the forest rules of 1878, it cannot be gainsaid the notification issued under Regulation 23 declare the said land as state forest. Sequentially, the submission of the state that the said state forest is deemed reserve forest and 23 of the Karnataka Forest Act 1963 is unacceptable. Holding that, my lord, all these, my lord, the connected writ petitions were allowed, my lord. The other judgment, my lord, which was carried in the writ appeal, my lord, the writ appeal, my lord, kindly see, my lord, in the also the division bench holds that, my lord, the state is precluded from contending that it's a forest land, my lord. Last page, my lord. Therefore, at page 29, my lord, therefore the state government is precluded from claiming the land in question is forest land, having issued notification under the provision of KADB Act and landing possession to the KADB. The action initiated by the officials of the forest department having been held to be bad in law, so on so disposed of. This was carried in to the Supreme Court, my lord. SLP has been dismissed, my lord. Even the land which was granted to us, my lord, some of them have been acquired and compensation has been paid to them, my lord. Now kindly see the, my lord, the photograph. More than 30-40 JCBs, my lord, without notice. Now kindly see one of the annexure, my lord.
No, no, you are the owner of what extent?
We are, my lord, at sir, block number 30, 1 acre, my lord, and one house, my lord, which have been constructed, my lord. 1 acre, because 4 acres was acquired, my lord, and compensation was paid to us, my lord. I produced the annexure, my lord. Schedule I have mentioned, my lord, this is where one of the house, because one of the
there is a house.
House, my lord. Photographs I produced, my lord. Kata was there still 93, my lord. Now the revenue cancel the Kata at page 36 onwards, my lord. The photographs which
yes,
house, cattle sheds, everything is there, my lord. Annexure.
My brief instructions are that only 120 acres of vacant land possession is taken. In terms of pitting is carrying on to plant trees, my lord. They have not touched any of the buildings. My brief instructions today, my lord. They have not demolished any buildings. So therefore, my lord, I will take instructions. Your lordship may kindly see the prayer 2, my lord. Prayer 2 is direction holding that survey number 1 is not a forest land. So therefore, my lord, I'll place all those once it is notified reserve forest, my lord. The procedure under the act alone must be followed to de-reserve it. Even the court may not have the power to say that it's not a forest land. So I'll just take instructions, my lord. Let them also, if they're relying upon these photographs, my lord, that is to show.
No, I'll record the submission that no built structure
Yes,
will be demolished till the next date.
yes,
And then we will take.
yes, yes.
AG accepts notice for the respondents. Lord Additional Advocate General appearing on behalf of the state submits that no built structure
Yes.
will be demolished till the next date.
No, let them also, because the photograph they have produced, it looks like an ongoing construction. Let them also
No,
not.
it has been
construct.
demolished.
Let them also not construct in the
page.
meanwhile.
No, we are not.
They have not given the page number. But last two photographs in the petition looks like they are also carrying on the
No,
construction.
it was
Let there be an
demolished building.
order.
It's other than, it's not ours. It's a
Allah,
demolished
I don't know, the photographs they have shown.
Petitioner undertakes not to change the nature of the property as on date.
Yes.
Relist the matter on
1 week's time, may I request? 12th, Malad?
Let them not, my lord.
11th, Pada?
I've recorded there.
13th, Malad?
13th. Yes. 14th.
3.
So what is the now what is the they're saying that writ appeal?
I'll look into it, my lord, because that particular notification has just not this parcel of land. I'm told that nearly 21,000 acres of land is part and parcel of that notification.
No, this refers to survey number 1.
This
Entire survey number 1, my lord.
Orders refer to. So there's other extent also.
Other extent is what I'll take full instructions and place it before.
3. Viresh.
Yes, Viresh.
But in this, I am for the, but in this, only, the petitioner, what is, sought, what the petitioner is the purchaser of the land, but he has purchased the property on 4/2/2020, 4/2/2020, but on 38/2023, 3.5 years, but the competent authorities has issued a notification at the provisional attachment order was passed. After I purchased the property as against my vendor, then the competent authority has approached the special court under section 5 after the period of limitation. Without making as a party, all these orders have been passed. We are not a party to any proceedings. But revenue records are there. Conversion order was in our favor, and revenue record is for the industrial purpose. We have purchased it. Now, the competent of the special court has confirmed the order without making as a party. Therefore, I filed a writ earlier. After the confirmation, the auction notice was issued. Then I filed a writ petition before the court. Then the auction has not taken place. Then I withdrew it with liberty to challenge even the main order. That order I have challenged before your lordship. Now, they have come up with another notification. Today only we came to know. That is why, we have moved it yesterday. They are bringing all these properties for auction. Tomorrow is the date fixed. Only request, as far as the petitioner is concerned, I have purchased the property. I have produced all the material before lordship. Lordship may kindly take the sale deed. I have produced the sale deed at annexure A, page 20. This is dated 4/2/2020. My vendor has purchased for 9 lakhs. I have paid more than 2.5 crores. Please see this the sale deed copy at page schedule at page 35. Then
Two humble submissions to make, my lords. One, my lords, the conduct of the petitioner. 13th of December 2024, the writ petition is filed. Lords, the auction notification, my lords, is issued on 30th of May. It is the golden hour of time that the petitioner is waiting for. Kindly see the date on which the petition comes to be filed. Kindly see, my lords, when the date, when the paper notification is issued. The Bombay High Court, my lords, though under a similar, some other set of circumstances has said, the tendency of the petitioner approaching the court in the last minute and then imposing pressure should be avoided. That's the first submission.
Why did you move it at 2:30?
Tomorrow is the.
So why did you, it's a matter filed on
Malad,
13
we
December
filed it, Malad, we
tomorrow.
filed it. Please, Malad.
No.
13th.
Let it come tomorrow. No, you can't take the court for a ride. Let it come tomorrow. This is not the way. You file it in December 2024, you keep it pending and move it at 2:30. You should have taken an interim order long back.
No, 1 minute, Malad.
No, this is not the way. Don't look at the lawyers waiting and you make fun of it by moving it at 2:30. No, let it come tomorrow.
In fact, it appears they have moved it.
Why you have kept quiet for 6 months?
Move ಮಾಡಿದ್ದಾರೆ, but
No,
it was
6
not
months.
posted.
Why you have kept quiet for 6 months? Put it. I'll dismiss it on that ground.
And even otherwise, your lordships have taken a view that when a statutory appeal remedy is available, writ petition cannot be a short circuit method of overcoming that, please, my lord.
But in fact, on 28th, there was an order.
The matter is comes before the court on 21/4/25. For 5 months, you keep quiet. What is this?
Posted for during vacation.
No. Why did it come on 21/4? You kept quiet, though you filed it in December, waiting for the vacation bench. No. Why did you move it in vacation? Why you kept quiet for 4 months? You tell me.
Correct him.
No. Let him answer. Why did you keep quiet for 4 months?
On the last date of 28/3, Malad, it came before the court.
No, it has come on 21/4.
On that day, Malad, the court said.
No, why did you keep quiet for 4 months?
Malad, I kept moving, Malad, it.
No, don't tell me that. Don't tell me.
One more thing is, Malad, court issued a notice to the respondent, Viresh Pujiyar, and said if any interim order is required, then move the vacation bit. Liberty was granted, Malad. That time, Malad, nothing has happened. Therefore, immediately after vacation, again I have moved. During vacation, I did not know that the court has issued notice on the last date of hearing before vacation. Not that.
But this is all
correct,
stale claims.
I know, but there is they should have moved it. I agree with that. Unfortunate situation happened is they moved it, and court because of pressure of work, they said all that as and when it comes, you move it. They moved it. Appears last night it is not posted. Now yesterday moved, and today morning he has moved it. I agree with there is some. They should have taken it immediately. But only problem.
Now you have challenged the order of the special court, for which you have an appeal under section 16.
16 is there. But the question is, Lordship may kindly say, without giving notice, not under similar circumstances, this honorable court, where the procedure lapses and had not been heard, court has entertained the writ petition. No, only request is, Lordship may kindly let them not. Anyway, tomorrow is the auction date they have fixed. I have purchased it by paying huge amount, and we are in possession of the property.
Let them not. As far as the argument that I have not been heard, my lords, is concerned, my lords may kindly take section 12, clause 3, my lord, of the KPITF Act, my lords. Section 12, my lords may kindly take, my lord.
They are saying there are subsequent purchases.
I'll submit, my lord.
Section 12?
Section 12, clause 3, my lord.
12, 1 nodi.
1-2 is, my lord's court issued notice.
Yes.
That may not, that is, 12-3 is what is important, my lord. Section 12, clause 3. Any person, am I able to point out 12-3? Any person claiming an interest in the property attached or any portion thereof, notwithstanding that no notice has been served upon him under this section, make an objection as aforesaid to the special court at any time before an order is passed under subsection 4 or subsection 6. And my lords will kindly take section 3, clause 3, my lord. Section 3, clause 3, my lords may kindly take, my lord. Once, my lord, the government issues section 3 to notification. Section 3, clause 3, my lords may kindly take. The government shall also notify the ad interim order made in subsection 2 in the official gazette. But I will not expect the parties, my lord, to go through the official gazette, my lords. And 2 newspapers having wide circulation. And shall also cause to be affixed a copy of such order on some conspicuous place on the property so attached. But there is this, my lord, Three-layer protection given to any person who has an interest. Not a question come up before the Honorable Supreme Court. He who has been conferred with an opportunity of hearing, who does not enjoy the same, can he come back before the court and say that I've not been heard? But the Supreme Court has held, he who lets the moss grow below his feet cannot complain about the same.
No. Now they're claiming to be a subsequent purchase.
Please, my lord.
So you're saying they could have filed under 16.
Please, my lord.
An appeal.
Please, my lord. And kindly see, my lord, even if it was section 16 is filed, no, I assume, my lord, section 16 appeal is filed tomorrow. But then, my lord, ex parte, my lord, when there's a condemnation of delay of 2 years, but this is nothing but, my lords, a determined, definite, short causing of, my lords, a statutory remedy. So the question number 1, my lords, would be for my lords' kind consideration. Behorse the fact, my lords, that there is last minute mentioning. I'll not go on that, my lords. I'm a state. I will not stand on hyper technicalities. The question number 1, my lords, when there is a self-contained code which provides for a statutory remedy within it, but is a writ petition under the disputed question of facts more so maintainable, my lords, would be the first question. And
what happens to subsequent purchases?
Please, my lord. But if not, because the revenue records, my lord, the property is with me, my lord. It is not that I'm taking the possession of the property tomorrow. The property is vested with me. The possession of the property is with me. I've already conducted, my lords, the auction for the first time. Conducted. Nobody, my lords, came. This is the second time, my lords. What happens, my lord? The news is spread in the in around places that a petition is pending. As it is, my lord, it is an auction, a coercive, my lord, sale. So people do not come forward. So, my lords, the auction proceedings are not conducted. And this, my lords, is the modus operandi, my lords, of defeating the purpose of the provisions of law, my lord. First, my first submission.
What is the procedure after auction?
My lords.
After auction, what is the procedure?
But once the auction, my lords, is conducted, we will issue a sales certificate, my lord, and once the sales certificate is issued, my lord, there shall be a conveyance of the property in accordance with law. So a sales certificate is to be issued, my lords.
But the
So
amount
in case
really,
of a person who wants to object, what is the procedure? In case a person
But
wants
now, my lords, kindly see, my lord, this is not the original order that I'm implementing. I'm only implementing the order passed, my lords, by the Honorable Special Court. Section 3.2 notification issued by the government of Karnataka, my lords, is an provisional ad interim attachment. I filed a petition before
what is the date of attachment?
Ad interim, my lord.
Date of, yes.
Ad interim, I'll submit, my lord.
Is it before their sale?
Well, 30th of August 2023, my lord. Subsequent to the sale deed, it appears.
we purchased, not 3.5 years after we
My
purchased.
lords,
30th of August?
2023, my lords. Is the notification, my lords.
No, he says he has purchased.
Lord, it has not been reflected in the revenue records. My lords will kindly see, my lord, either 28(1) notification or 4(1) notification under the Land Acquisition Act or the KDB Act. Because as an authority, I will not go into a roving inquiry of title. I will only go by the available revenue records. If the names, my lords, are entered in the revenue records, my lords, I'll have no difficulty in attaching the property. And only to avoid, my lords, the legislature in its wisdom has thought it fit to mention that any person who claims the interest behorse the fact that notice has not been issued to him shall have to approach before the Honorable Special Court, my lord. So to say that I have not been issued with the notice, my lords, is only an alibi or an excuse.
No, correct. No, we are not on that point. The point is whether,
please, my lord,
since their name is not there in the attachment,
please, my lord,
though the property is attached,
please, my lord,
what happens now?
My lord, in terms of the order passed by the Honorable Special Court, my lord, section, my lord, 5.2, I will have to comply with the directions unless your lordship, my lord, would pass any order, my lord. So once I auction the property, my lord, I will identify, my lords, the highest bidder, and I will issue a sale certificate in his favor. So it is not that, my lord, tomorrow the position is with me, my lord. I'll let there be no two words on that. The position is with me. We will be with the competent authority, even in terms of section 3, clause 4.
Symbolic possession.
My lords?
Symbolic possession.
Symbolic possession.
Symbolic
Not the question.
It is a vacant land, so I'm given to understand, my lords, that the CA has taken the possession.
But there is a shed, there is a shed, and we taken it for establishing industry, industry. At that time, because of the COVID, so many problems have taken place.
But if at all there is any construction, there has to be a building plan. There has to be, my lords, the necessary. So let them put it before the court, my lords. Let it be recorded. Let it be recorded that there is a standing structure on the land in question, my lords. And even otherwise, my lord, tomorrow, once I hold the auction, it is not that, my lord, by the end of the day, tomorrow I'll be able to issue a sale certificate. So my lords may keep the matter pending, but let the auction proceedings go on. I will not, my lords, it may be taken up tomorrow or day after, my lord. Let them produce documents to show that there is a standing building. Now that.
But even if it is not.
Now that a statement has been made before this honorable court that there is a standing building, but then I assume that there will be, my lords, building permissions.
What is the process of confirming the auction?
My lords, there'll be no process, my lord. Once, my lord, section 3.2 notification issued by the government of Karnataka, my lord, I go before the special court and I seek that the ad interim attachment made by the government be made absolute. But the honorable special court, my lords, passes an order, sometimes rejecting my application, sometimes making the attachment absolute. Once the property is made absolute, my lord, I'm put on a condition that I should auction the property, bring it to the notice of the honorable special court, then my lord take steps to disperse the money amongst the eligible depositors.
So the auction is to be ratified by the court, or what is
Yes,
it?
Once sale auction is done, if I issue a sale certificate, I go before the honorable special court saying that I
Don't
got
issue the sale certificate, we'll see.
But may I make one humble submission? Because now that, my lords, an alternative remedy is available, my lords may kindly, my lord, protect them that I shall not issue a sale certificate, and it may kindly be recorded that there are building structures on.
There is
on
only
the
a
land.
shed, my lord. What I
Whatever,
said, there is only a shed.
whatever, my lord, whatever. And my lords may give them liberty to approach the, my lord, statutory remedy within 2 weeks, my lord, and
My lord,
so everybody's interest is indeed protected.
I'll protect you.
My lord, only one request, my lord. Only one request. I have no difference. My lord, what happened was, we, my lord, there is a revenue records in our name only. My lord, panchayat record, everything is there. Kata we have paid is in our name, tax we have paid. They have not shown our name. It is a converted land. They cannot go to the revenue records and say that, my lord, it is a
Conversion happened even
converted
before
land.
they purchased the property.
No,
Please
now
see,
I'll
my-
protect you.
Yes.
You go before the appellate authority.
And my lord,
I'll
time,
restrain them from issuing any sale certificate.
and my lord, time spent here may kindly be permitted.
Only here, my lord. Whatever
Time-
time has been
time-
spent in this writ petition, my lord, I have
No,
no
not
objection.
in this, my lord. Earlier writ petition was, this honorable court has given a
Earlier
liberty.
writ petition-
1 minute, your lordship may kindly see this.
So far as limitation, let it be, the court will consider. They're spending time before this court.
Please.
There are two proceedings, my lord. Earlier also we filed, this our court only permitted,
The
you
petitioners
challenge it the main order.
have challenged the order dated 9/1/24, passed in miscellaneous 1204 of 2023, passed by the city civil and sessions judge and special judge for KPI DFE cases. Full stop. It is learned senior counsel appearing on behalf of the petitioner submits that the petitioner has purchased the property which is now subject matter of auction proceedings through a sale deed dated
Sale deed dated, my lord, 4/3/20, sorry, 4/2/2020.
4/2/2020.
2020, annexure A, my lord.
It is submitted that the proceedings for attachment under section 5,
Not like
3.2, my lord. First attachment.
section
Section
3.2
3.2.
were initiated.
Yes.
For the 3.2 notification was issued on 30th of August 2023, my lord.
But what they have to do,
Section
is deputy commissioner has to send it to the
Three-two
government has to pass an
notification.
attachment, all these things are there.
3.2 notification
It has been issued by the government of Karnataka, my lord.
was issued by the government of Karnataka on
30th of August 2023, my lord.
As per
30th
annexure,
of August 2023.
as per annexure.
Accordingly, it is submitted that the name of the petitioner, despite his purchase on 4/2/2020, is not found in any of the orders of attachment
Yes.
subsequently made absolute by the special court. Full stop. Accordingly, it is submitted that the proceedings are not legally tenable insofar as the property in question is concerned. Third counsel Shri Viresh Mudiyal appearing for the respondent for the competent authority.
Yes.
That is respondent number
Number
2.
2.
Would submit that in effect petitioner is calling in question the attachment made absolute by the special court, against which order there is a substantive remedy
Under section 16.
under section 16 of the KPID Act. KPID FE Act 2004. Full stop. Perused section 16.
Yes. Any person including the competent authority.
The provision is broad enough to include any person as may be agreed by order of the special court. Noting availability of a substantive remedy, it would be appropriate to relegate the petitioner to avail of the appropriate remedy. Substantive remedy, to avail of the substantive remedy. As it would meet ends of justice by directing the respondents not to issue any sale certificate for a period of
2 weeks, my lord.
3 weeks, your lordship.
3 weeks from today. Yes. All contentions are kept open. Accordingly, petition is disposed of. AGA accepts notice for the respondent number 1 and 3. Notice to other respondents is dispensed for the present.
No, time spent, maybe.
Needless to state, the counsel for the petitioner submits that the time spent in the present writ proceedings as well as earlier round of litigation may be taken note of while
The present petition and earlier
calculating
petition
the
also.
limitation. Full stop. Needless to state, the request of the petitioner regarding time spent in the present proceedings as well as the preceding writ proceedings may be raised before the appellate court, which is open to be taken note of appropriately.
Please. One submission, Lord. The submission that there is a standing building or a whatever structure may kindly be taken note of. For this reason, my lord, the petitioner, my lord, has the audacity to come to the highest court of the state and make a submission. But I put up
ಅಕಸ್ಮಾತ್ ನಾವೇ ತಪ್ಪು ಮಾಡಿದೀವಿ ಅಂತಿದ್ರೆ ಅದ್ರಲ್ಲಿ ಏನ್ ಅದನ್ನ ಮಾಡಿ
ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದೀವಿ ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ನಾನು ನೋಡಿಲ್ಲ ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೀ ಮೈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆರ್ ದಟ್ ಇಟ್ಸ್ ಅ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್. The submission is that there is a standing construction. So let it kindly be recorded, my lord.
It is
obliged.
Yes.
Obliged.
Next.
No, why he is taking so personal?
No, nothing personal, sir.
Lord, I appear for the
Yes,
petition.
Vignesh Shetty.
May take my lords to the order of this honorable court dated 22/4, my lord.
What
I have, my lord. That would be 72,065 rupees. I have already.
What is their total due?
My lord, according to them, it is 7,26,000, my lord. Lord, what had happened? I had given a letter for foreclosure in the year 2019. In the 2021, they sue me before the civil court, seeking about 2,94,000 as the dues.
What is your profession?
I am a doctor, my lord. It was a home loan, my lord. Their suit got dismissed with cause.
So now on merits, insofar as your liability, what do you say?
My lord, insofar as my liability is concerned, my lord, I have cleared as on 2019. Their claim is I have not completed 170 EMIs. They are not ready to get into the calculations, my lord. That has already been noted by the civil court, my lord.
13.2, my lord, assailed before this honorable court. In fact, my lord, this honorable court directed on 22/4/2025, subject to deposit of some money, my lord, there's some interim order has been granted. Wherein, my lord, the interim order, my lord, which either my lord communicated to me, or the my lord, that money which is deposited, my lord, normally, my lord, they will deposit the money with bank. My lord, now petition saying that the money deposited before this honorable court. Therefore, my lord, we are not aware in respect of my lord compliance of interim order or my lord obtaining the interim order from this.
You have paid to the bank, is it?
No, my lord, I have deposited before this court because my claim is. No, my lord, there is no due at all. There is no due at all because that is what the.
What is the interim order of the court? What is the interim order of the court? You forfeit your interim order also.
No, my lord.
No. What is the interim order of the court? I can't do anything.
Lord, it does not say it to the bank also.
Yes, sir. To the bank.
No,
10% amount in due.
In due to the bank, my lord.
Huh? To the bank.
Not deposit to the bank, my lord. It is 10% of the due to the bank, my lord.
That's not the way it must be read. Nobody asks you to deposit before the court. It's always done to the bank.
Not because, my lord. No, my lord. If I may say this, my lord.
Sorry, it's a plain English which you have tried to read too much into it. You forfeit the protection of an order. With what basis did you deposit in before this court? And it's only 10%. You have taken the risk. It's your headache. I can't help it. Now what has happened?
Now they have went before the magistrate and obtained order for possession, my lord. My lord, I am filing that 2 applications seeking stay of that order and the vacation notice.
I'm not going to pass any order.
Lord,
You settle it, go before the DRT. I'll protect you.
No, my lord. They themselves have went before the civil court, my lord. They have suffered an order judgment by the civil court.
It is non-est if the civil court has passed any order. Civil court has no jurisdiction to intervene in these proceedings. Now you claim they have taken action. You challenge it before the
Lord,
DRT.
they themselves have come before this honorable court. There is an RFA pending.
RFA against what order?
Against the city civil court. Court's order, judgment, my lord.
Civil court is independent of surface. You know that.
Please, my lord, but
Parallel remedies. Who filed the suit?
The bank.
Those are to be liable to be ignored. Surface is a parallel proceeding. Surface you have to defend it on its own. Go before the DRT. I'll protect you for 2 weeks. Now what any auction is it?
No, my lord, only section 14 order you have taken. In fact, we are not aware of this order as well as, my lord, they are not compared to the interim order, which is I got in.
As on today, there is 10% deposited before this honorable court, my lord. It is not that I have not done anything.
No, that's your headache. You have misinterpreted the plain language of an order. The money has to be paid to the bank. How did you try to be?
Lord, may I say this, my lord? Lord, by the time I have come on record, I am on NOC, my lord, because I didn't know this. What the order was and what the submission was before the earlier court, my lord.
2 weeks I'll protect you. Go before the DRT. You raise whatever contentions you have. You raise before the DRT. I'll protect your possession for 2 weeks.
My lord, it may be had on Monday, my lord. I tried to convince kindly on Monday, my lord.
What for?
My lord, with the urgency I had come, my lord.
Correct. No, I'm saying why you want it on Monday. I'm relegating you to avail of the substantive remedy. So go before the DRT. I'll keep all contentions.
Lord, as on 2019, I have cleared all my debts, my lord. There is nothing remaining. They themselves have suffered an order from the city civil court. And
so you challenge that 13-2 before the DRT on the same grounds.
Lord, it may be made subject to RFA's outcome, my lord, in that case. Lord, they themselves have gone before the
Monday. We'll have it on Monday. Vignesh Shetty accepts notice for the respondent.
They served a copy of it.
Copy to be served.
Copy served.
Copy is served. Relist on Monday. Now, surface, I don't intervene. Whatever contentions you have, you can raise it there.
Until then, let them not precipitate, my lord.
That's why I'll dispose it off. I'll protect you.
No, my lord, until Monday, my lord. All that I'm saying is until Monday.
My lord may protect them for 4 weeks. Till such time, my lord, they wanted to settle at my lord inspect item instruction. If they're approaching the bank, with all fairness, we'll consider and we'll try to, my lord, settle the matter also. 4 weeks, my lord, if they're going to before the DRT, in case, my lord, they're not.
No, my lord, until Monday, kindly protect me, my lord. I'll convince, my lords.
No. What is the submission you tell? Let us see. If reason is there, I'll adjourn till Monday.
My lord, my submission is I have already cleared the loan. That has been observed by the city civil court. They have suffered that order and they come before this honorable court and still taking the action under the surface. Even after taking the entire money, I'll convince, my lords.
That is the case, my lord. I'll answer. My lord, transfer, my lord, and I have 52, my lord, very clear.
No, now you have filed some suit.
I filed a suit, my lord. I filed a suit. In fact, on the technicality, my lord, suit got dismissed. Because, my lord.
No, not on the technicality, my lord.
About 20 lakh, my lord, I have to file a OA before DRT. If the less than 20 lakh, I have to go before the civil court for recovery suit, which we have filed. On some technicality, my lord, civil court dismissed my suit, which against that, my lord, I filed an RFA. My lord, in respect of surface which I initiated, it's an independent action as per the transfer, my lord. I can parallel, my lord, I can initiate both action. Even though, my lord, that civil court, whether order is there or not, it is irrelevant. Against it, my lord, the prayer sought before this honorable court, my demand notice issued under section 13(2). That, my lord, there is a mechanism. Either they can challenge it or they can give a representation which will consider with all fairness. For my lord, kindly see the prayer which sought before this honorable court.
Issue 13-2, you challenge before DRT. You challenge before DRT saying it's the one without jurisdiction. I'll protect you.
Lord, until Monday, kindly, my lord. Until Monday, I'll convince my lord.
Convince on what point? I am not entertaining.
My lord, they are accepting that they went before the cities because that is the mechanism they had to follow.
No,
It is not that whenever the money is due or that is been adjudicated, my lord, whether the money is due or not. The city civil court says that there is no money due.
Where is the order?
My lord, kindly see page number 80, my lord.
Page
80. 80.
Yes.
That is a suit filed by the Canara Bank, my lord.
Suit for recovery.
Recovery.
How do you get over this?
Milord, we filed an RFA, Milord. Again, Milord, I make it same subject. In fact, against this order, Milord, we filed an RFA. On subsequent, Milord, some technicality, Milord, the Honorable Civil Court, Milord, pass an order. Now, Milord, my respectful submission before this on report, SARFAESI, Milord, is an independent action.
No, that is there. But if you are
when there is a due,
just your liability itself is determined by the civil court in a suit filed by you, then you are bound by it. How can you initiate proceedings when that due itself is negatived by the civil court, in which you are the plaintiff? Where is the finding regarding due?
As per
para 18.
Para 18.
18. Page number 78.
Yes. Read.
It is interesting to note that defendant contesting by saying that the defendant was to pay 20 lakhs on so for the tenure of 170 EMI, rupees 12,120. But she has paid 21,14,757 and it is reflected in exhibit P15, which is admitted by the witnesses. It is reflected in cross-examination of PW1, page 8, page number 2. 170 ಕಂತುಗಳಿಗೆ ತಿಂಗಳಿಗೆ 12,120 EMI ಪಾವತಿಸಿದರೆ ಒಟ್ಟು ಹಣ 20,60,910 ಆಗುತ್ತದೆ ಎಂದರೆ ಸರಿ. ನನ್ನ ಅಕೌಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಕಾರ ಪ್ರತಿವಾದಿಯವರು 21,14,757 ಈವರೆಗೂ ಪಾವತಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಅಷ್ಟು ಹಣವನ್ನು ನೀಡಲೆಂದು ನುಡಿಯುತ್ತಾರೆ. ನೀಪಿ 15 ಸಾಕ್ಷಿಗೆ ತೋರಿಸಿ ನಾನು ಹಾಜರುಪಡಿಸಿದ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಕಾರ ಪ್ರತಿವಾದಿಯವರು ಈವರೆಗೂ 21,14,757 ಪಾವತಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಅದನ್ನು ಪರಾಮರ್ಶಿಸಿ ಸರಿ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. Here the witness PW1 admitted the defendant that the defendant paid the more amount than which he has to pay. But it is pertinent to note that the witness has deposed that as the defendant was default in paying monthly EMI, the bank has put more interest to it. It is pertinent to note that the defendant has already paid more than the amount to be paid. She has availed 12 lakhs loan, and as per the amount paid, rupees 20,60,910, and also interest for which she has jumped the EMI as per the evidence of the evidence and the cross examination. She has paid 53,848 more, and if any, to taken as interest for jumping the EMI.
You find out.
Lord, I file an objection.
The petitioner relies on the order passed in OS 64 of 2021, and in particular to the finding at para 18. The trial court has recorded a finding that the petitioner has paid more than the due, more than within inverted comma the amount to be paid, full stop, close inverted comma. It is contended that proceedings under SARFAESI cannot be proceeded with when the bank has suffered an order before the civil court wherein the finding in effect is that there are no dues. Matter requires consideration. Learned counsel for the respondent submits that an appeal is filed against the said civil suit. However, in light of the peculiar case facts of the present case, the respondent to take the stand in writing. In the interregnum, respondent bank not to take any precipitative steps pursuant to the impugned order till the next date.
Lord, I have filed an application, Lord, seeking stay of the magistrate's order, Lord. Otherwise, police will not listen.
No. Court is
Allah, there was an interim order, Lord, earlier also.
That interim order is vacated anyhow. The respondent, I've stated not to take precipitative steps pursuant to the impugned order till the next date. Now you just see how much in case there is a small amount. They may just,
That's what I said to my friend. Let him approach the bank. With all fairness, we'll consider
you
it can
just
be
see if
closed.
there's a small amount, you wash your hands of it. It's only washing your hands of
The title
litigation.
itself.
Not that he is wrong or you are right. Litigation is not about that. Now just wash your hands of it and close it. If there's a small difference of interest because of some jumping of EMI, maybe something small, you try to settle it. No doubt you may be correct.
I'll convey the same.
I'm not on that point. But you wash your hands of such tension. This is avoidable tension.
I'll convey. Police.
Deeply.
Yeah. Huh? Answer requirement, big.
Objection was filed, 71 to 78.
Your Lordship,
71 to 78.
Weeks
71.
time.
Objections have been complied with.
Dates will be given in fresh matters list.
Indeed, Your Lordship.
My lords, with your lordships, kind leave, my lord.
Just 1 minute, I'm going serial wise.
71.
71.
Respondent 1, 2, 3, my lord.
Objections have been complied with.
We'll list the matter in fresh matters list on 1st of July. 72.
73.
73, he's not in this case. Only one objection.
When do you want?
Office objections.
Huh?
All office objections are clear, my lord.
List the matter in fresh matters list on? Yes. List the matter in fresh matters list on 1st of July. Yes.
76, it may be called on Monday, my lord.
Office objections to be complained about. 76.
My lord, it may be called on Monday, 30th.
80th.
77.
I will accept notice on behalf of respondent number 5 in this matter. Copy may be served upon me.
Vignesh Shetty accepts notice for respondent number 5. 5.
4, my lord. I have 4, respondent number 4, my lord.
4.
Copy.
List the matter in fresh matters list on
78.
17.
any urgency or next week?
Next week.
Date for 1st of July.
Date for me.
My lord,
78.
my lord, a week's time, my lord. Maybe
Week's
posted on.
time granted for necessary compliance.
79.
List the matter on date for.
2nd of July.
Yes.
79.
Relist. Nale to nale.
27th.
27th. You consumer forum tomorrow. But consumer forum matter. Yes. Next.
Lordship, serial number 89, lord.
82.
I'm going serial wise. Please wait. Yes. 82.
Second time.
Time granted for necessary compliance.
83.
The Amel dates could fresh matters list.
83.
Next.
84. 85.
List the matter in fresh matters list.
47.
Office objections to be complied with.
86.
My lords, I appear for the petitioner, my lords. Would like to file an withdrawal memo, my lords.
List
Will a withdrawal memo.
the counsel for the petitioner has filed a memo which reads as hereunder.
The petition has become infructuous, my lords. Therefore, I'm withdrawing the petition.
In light of the memo filed, petition is disposed. The petition is dismissed as having become infructuous.
Yeah, please, my lords.
87. Connected matters. There are total 14 connected matters. That already matters are applied.
Relist in This is a fresh matter. Office objections to be complied. Relist the matter on.
2nd of July.
Yes.
88, dismiss 89.
18 and I appear for petition, but only objection is that certified copy of Annexure A,
No,
but
when
that is served through me in mail. Kindly, that may be overruled.
When do you want?
Lordship,
When do you
waiting
want?
for the,
Monday, my lords. There is urgency, Monday.
Lordship, there is an urgency, Lordship.
List the
Monday.
matter.
Auction has been done, 25% has been collected. Tomorrow is the due date for the balance. They have not fulfilled their bona fide. You gave 10 days time. Today is.
No, there was no
I have
interim
an
order,
urgency,
my lords, but the
Lordship.
only order was that subject outcome
Feel
of
the
this
The
petition.
auction will be frustrated by this date, Lordship.
When do you want?
Kindly dismiss it, Lordship.
When do you want?
It has to be dismissed today.
Not
Tomorrow I
af-
want.
After 4:45, I will not pass any orders. So you tell me when.
Tomorrow.
My lords, 27th, senior is not, 27th, my lords. 27th.
27.
91.
91, I pray for respondent, my lord. Copy of the petition not served upon.
Yes, my lordship, I'll be served. Kindly let it be permission notice, my lordship. Objection will be complied.
Office objections to be complied with. Relist the matter and fresh matters list on.
2nd of July.
Yes.
92.
Appearing for the petitioners, my lords.
Relist on.
My lords, tomorrow,
Deal
my
is
lords,
done.
there's urgency in the matter. Tomorrow.
Protection for what?
My lords, the construct ಮಾಡಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ property ನ. ಅದು advocate.
Date good.
26th.
26. Yes.
93.
Appearing for petitioner, my lordship.
I beg to appear for the respondents number 1 to 3. The lordship has already similar matters have been disposed on 6/6 of this 25-year. This
Relist
matter may be tomorrow, my lord, because it has to be disposed of by virtue of your lordship's order here.
Relist on. 26th.
Lord, interim order may kindly be extended and serial.
Interim order earlier granted is extended till the next date.
94.
In this case, I appear for petitioner.
I pray for respondent as well.
Earlier point of time.
Relist on.
Sale take, my lord, sale before this honorable court, sale not taken place. This honorable court, my lord, directed me to consider the one-time settlement offer, which we considered, we rejected. I placed a memo before this honorable court. Nothing survived for consideration in this junction.
Sale didn't take place.
Still not taken. I filed a memo on that.
27th, it may be taken.
List the matter and preliminary hearing list on. 27.
Great for me.
95.
In the meantime, my lords, I request my lords, come on record, what is the amount due?
I stated, I filed a memo with the statement. I filed it before this honorable court. 99 lakh, I filed it already.
My lordship, in this case, I am the petitioner, my lordship. What happened, my lordship, Karnataka Public Service Commission, this court passed an order dated on 20th April 2025, my lordship, directed the KPSC to provide the scribe, my lordship. But KPSC, Karnataka Public Service Commission, my lordship, not complied the order passed by this honorable court. It summons to contempt of the court, my lordship. And office, regarding the office objection, only two.
Exam is over.
Yeah, exam is over, my lordship. What happened, my lordship?
No,
And
correct. Now
Now-
you're blind, is it?
yes, scribe, my lordship, provide scribe, because he has met an accident. On that day, my lordship.
No, correct. So now what we can do, you're seeking, what is the relief you're seeking?
No, already exam is over, my lordship.
So I'll have it next week. Let us see.
Yes, my lordship. Only two objection regarding objection is to only
That
two
we'll see.
manuscript, my
That
lordship.
we'll see. Release the matter on.
Fresh matter, my lordship. Will comply the office objection, my lordship. Only two manuscript is there, my lordship.
Matters. Yes, 96. List in fresh preliminary hearing on.
1st of July.
This is a fresh matter or a notice issue?
Last date they submitted that they are going to increase the ODS.
Notice issue. Again. Preliminary hearing list on first.
97.
Date good. Yes.
98.
Same date. Yes.
9.
99. 2nd of July.
102.
100.
Respondent, my lords.
Sir.
Let's make one submission in this one.
Let us see.
Instead of hearing on a matter may be portion for hearing on merits. Because earlier occasion also the very
No. Here you can't hear any matters. So So at least it comes up like this by default. Relist on
3rd of July.
3rd of July. Uh, 1st of July.
103 dismiss, 104, 104.
104 petitioner, my lords, interim order to continue.
No, wherever interim order, it will stand continued.
Please.
Relist week after next.
Please.
105, my lord, I appear for the petitioner's counsel. IA number 1/23/2025 is filed so far as collection of the hundi amount in the temple and to
Let us see, I'll
deposit in
relist
the.
it. Let us see, I'll relist it.
It
I'll
can be
relist it.
posted on 26th, my lord. There's some urgency in the matter, my lord.
Relist
Because
on.
the amounts are.
27.
Hundi, 26th irli Swami. 26th.
The board is full. We'll see 27th.
Oblige, my lord. Oblige.
27th date. Put.
Okay. Oblige, my lord.
106. 106. 107, 108, 109.
My lords, I appear for respondent number 10 in this matter.
For respondent number 6, my lords.
My lords, this is,
826.
my lords, this is a matter where my social media is blocked, my lords. I have extreme urgency.
Relist it. I'll relist it.
May I request for it in the fresh matters list, my lords? I've already filed an IA for vacating, my lords.
In the preliminary hearing list on.
27th, my lords, may I
If it
request?
requires hearing, then it.
No, my lords, I'm willing to, my lords, I understand your lordship's board. I'm willing to make a reasonable concession, my lords.
First of July.
My lords, may I request for it on Friday, my lords? My entire social media is blocked. I'm a social worker
Friday.
and based on a fictitious OS.
Friday, I have a bench in the post lunch. It won't reach on Friday.
My lords, may I request for tomorrow then, my lords?
The
My
board
lords,
is.
and Monday on 30th in the fresh matters list, my lords.
30th in the preliminary hearing list.
Very well. I'm grateful.
Interim order and operations is continued till the next date. This is the only relief I can give.
110.
Yes,
110.
relist on.
7th of July. 111 dismiss, 112.
No, 110, my lords.
Relist on.
He's not called, 110. I filed vacating.
Relist on. 7th. Yes.
I'm for responding in this case.
Tomorrow. 113.
112.
Yes, 112, my lords.
12 you date.
For respondent number 2, my lord. 112. In this case.
112.
12.
My lords, and for respondent number 2, my lords.
Huh.
We have filed wakalat yesterday, my lords. Kindly it may be taken up after 2 weeks, my lords.
Not after 2 weeks. 7th.
113. Akash B. Shetty.
Relist on.
114. Sirajuddin Ahmed.
Relist on.
1st of July. 115.
Your lordship, appearing for the petitioner in 115. It may
Relist on.
anytime next week, your lordship.
8th of July.
Yes.
Grateful.
116.
My lords, I appear on behalf of the petitioner.
Relist on.
117.
Interim order may kindly be accepted.
Wherever interim orders, they stand extended.
117.
Relist on.
18.
Petitioner will kindly extend to the interim order.
List week after next.
119.
And it is with regard to the imposition of 5 times penalty, but it is covered by your lordship judgment.
This is the matter.
Yes. 18th order passed.
Royalty.
Imposition of 5 times penalty.
Royalty.
Yeah, for royalty, imposition of 5 times
ನಾಳೆ
penalty.
ಆಗುತ್ತೆ ಬೇಡ.
We will dispose of it also.
ನಾಳೆ.
I have intimated.
Relist tomorrow in the preliminary hearing list.
Yes.
Yes.
120. 120. Ashwin.
Date code.
121.
Yes. Next.
122.
My lords, for the petitioner, my lords, there's a genuine urgency in the matter. It might become infructuous, my lord. It was actually date given for 20th. It was not listed. I moved it for 2:30.
What is the urgency?
My lords, the respondent number 3, the Mysore Turf Club, is conducting their operations with a person who's being an interested party sitting on the board. The state was supposed to secure instructions.
Shortly.
No, the preliminary instructions are this, my lord. We are a licensing authority. If at all, if it has any, this is like the same thing where the insider trading, my lord, where the stewards cannot be the horse owners. and the 50% of the
You
members.
take
can-
out hand summons to
Yes.
that unserved respondent.
He has to
Yes,
serve the
my
notice
lordship
upon them.
permit-
Petitioner has
And
a liberty to take
also
out
he has to
notice.
file the complaint to the company, because the Mysore Race Club is a registered company. If any terms of the bylaws have been violated, then he has to complain to the authority, not to the licensing authority.
Relist. The petitioner is permitted to take out notice by way of hand summons to the to the respondent subsequently added. Relist on.
My lords, the next racing day is tomorrow, my lords. Thereafter that, it's next Wednesday, at least Monday, my lords.
Without them, I can't pass.
Yes, I'll take out hand summons, my lord. At least Monday, 30th, my lords. First of July. 30th, my lords. Next racing day is on 2nd, my lords.
Let us
123 might same matter. We posted on tomorrow.
listing.
Right matter.
The royalty and the mail ಹಾಕಂಗಿದೆ
Preliminary.
covered ಅಂತ for disposal ಅಂತ ಅವು for list for disposal ಅದು ಆಮೇಲೆ ಇನ್ನೊಂದು list for disposal ಅಂತ.
125 appear for the petitioner.
ಯಾವತ್ತು ಶುಕ್ರವಾರ ತಗೊಂಬೋದಾ ಅದಿಲ್ಲ ಸೋಮವಾರ ಸೋಮವಾರ short date Tuesday first at 2:30. I'll take it up at 4 o'clock and 2:30 on first.
Small issue, lordships.
First.
Is to do one.
Relist on.
Serial number 2, Sangamesh.
I'm for the respondent bank, my lord. In fact, petition has become infructuous. When OTS was given, that was also not been complied with. I withdrawn the OTS.
I'm the petitioner, lords. The OTS was offered, we have not complied. The lordships can dismiss it, lords.
Shall I record?
Your lordships can.
Yes, I have given the letter.
The lordships can say that the OTS was offered, which was not complied. Therefore, the petition.
This is the matter. I will not. In fresh
But
matters list
my lord,
tomorrow.
may kindly say the
Fresh matters list tomorrow. I'll dispose it tomorrow.
as a fresh matter, my lord.
I don't want to pass any orders before getting this.
Serial number 3, again 4.
My lords,
Relist on.
4, my lords.
Relist on.
My lords, next week only need.
14th.
Interim order and application extended till the next date. Interim orders will stand extended, whether you mention or not.
5.
My lords, I appear for the petitioner, my lords. My lords may have it after 2 weeks.
Next week date good. Relist on.
9th of July.
Yes.
6. Madhu.
Yes.
7.
Lords, in 7, I appear for the petitioner. There's some urgency. I've sought directions. They are not granting me a permission on the ground that your lordships have already stayed in this writ petition.
Yes,
The whole
government.
operations are at a halt. Would your lordships have it?
Okay, lords, we have it next week anytime, my lord. We'll
Yes,
check
in
the email and
preliminary
check
hearing
the
is
instructions.
2nd of July.
But could it be a little earlier, 30th of
My lords, serial number 8, I appear for petitioner, my lords. Any date next week, my lords.
Relist on.
2nd of July.
Date.
9.
Appear for the petitioner.
9.
Relist on.
2nd of July. 10.
My lord, in 10th, my lord, we have sought only for mandamus. What has happened, my lord, in 2022, we completed the tender work. And my lord, BBMP has deposited the entire money. My lord, in that, my lord, may I request it for preliminary hearing, my lord?
List in preliminary hearing list on.
Tomorrow, my lord.
1st of July.
Yes.
11. He got heart attack.
Relist on.
1st of July.
Yes.
12.
I appear for petitioner.
Let us see. Let us see. Let us see. Date is there, 27 jaga is there. It won't reach. No, no, I don't pass any orders after. Yes, next.
Serial number 12, I appear for petitioner.
Relist on. Relist on. 8.
13.
Lords, I was having a benefit of interim order, my lords, but that was kept open. With that, my lords, I will not comply on office objection.
List in preliminary hearing list on.
1st of July. 14 August 15.
Relist on.
It's been 6 months since the incident.
Relist on.
It is 27.
Not yet.
4th of July.
4th of July. Yes.
16.
And for the petition, after a change, my lord,
My lord, it is an,
correspondent matter.
my lord, it's an
They seized the
appealable
claim.
order.
Huh?
It's an appealable order. Order under the KPME Act. He has to approach the appellate authority. My lordship may have it.
And tomorrow, my lord.
It's the matter, short date.
Tomorrow, my lord, my urgent, my lord.
26th. You have to go under section 16. Disposed of the matters. Yes.
17.
Ali 16 Ali Viresh B. Budi is directed to accept notice for the competent authority.
No, this is not that, my lord. This is a
Ah.
KPME Act, Karnataka Private Medical Establishments Act.
Okay.
The appellate authority is the deputy director of medical education.
Yes, yes.
17.
17 for appellant petitioner, your lordship, from morning
Relist on.
today it is stated, your lordship, it is covered by the decision of the
1st of July. Yes.
taking transfer of
Preliminary.
authorized ground.
Number 19.
Yes. Date.
My lords, if I may make one submission, my lords.
My lord, serial number
Lordships.
21. Serial number 21. 21.
My lord.
My lord, serial number 21, my lords.
With my lords.
Serial number 21.
My lord, serial number
Serial
22,
number
my lord, I
27,
moved this
my lords.
matter. It's a GM Forest matter, my lord. Serial number 22, my lord. In that, serial number 22.2 has to be delinked. 22 and 22.1 may be continued. Kindly post it in a preliminary hearing because, my lord, these people,
Press for the extension of interim order.
my lord, they are running resorts in an eco-sensitive zone, the Murkan Gudda. And, my lord, they have diverted a natural stream, my lord. That is the urgency, my lord.
My lord, 21.
Serial number.
Press for the extension.
22.2 will be delinked
Delinked, yes, my lord.
separately next week.
Yes, my lord.
My lord's list 21.1, my lords.
Your lordship may kindly have it for 26 in the preliminary hearing, my lord.
22 and 22.1 is the matter preliminary hearing list on
26th, my lord.
26th. Interim order in operation is extended to the next date.
Serial number 27, my lords. Serial number 27.
Yes.
27, my lords, it had to be in the fresh matters list because my interim order, my lords, this court had observed that it would consider the granting of an interim order after service of summons or notice on both the respondents. It had to come up in fresh matters list, my lords. My stormwater drain has been damaged by NHAI.
This is the matter in the preliminary hearing list on.
My lord's
Grateful,
21.1.
My lord, serial number 31, my lords. My lord, 31 is covered by my lord's judgment. My lord, 31 is covered by my lord's judgment. It may kindly be had in preliminary hearing, my lord. It is with regards to recreational club, my lord. My lord has disposed of similar matter today also.
This is a fresh matter, is it?
Yes, please, my lord. Serial number 31, list
Just
number 2,
1
my
minute,
lord.
just 1 minute. List 31
Yes.
in preliminary, in fresh matters list.
My lord. My lord, serial number 25, my lord. It is also, my lord, covered by judgment, my lord. Serial number 25, list 2, my lord. Serial number 25.
32, my
Please,
lord, stay may be
Food and civil
extended.
supplies matter, my lord. 25, my lord. Covered by matter, my lord.
What? PDS.
PDS, my lord.
Fresh matter, is it?
My lord, it is a B group matter, my lord. The covered by matter of this similar.
Preliminary hearing list.
My lord's 20.
32, my stay may be
21.1.
extended.
Transfer of authorization.
Please, my lord. Husband was died, my lord. The petition was given representation to the respondent.
Shivram matter itla avate ಆಗ್ತದೆ.
My lords,
Obliged, my
21.1, my lords. It's an auction, 21.1, my lords. It's an auction matter. The sale certificate has already been issued, my lords. If it
20?
21.1, my lords. It's connected with 21. There's urgency in the matter, my lords. It's an auction.
Short date.
7th of July, my lords.
My lords.
36, my lord.
7th of July, my lords.
36.
My lord, serial number 30.
There is no order at this honorable court.
Stay may be extended, my lord.
Direction to
32.
the investigation. Already three months is over. My property has been
Serial
stolen
number
by the 36, my lordship. Kindly short any next week, my lordship.
The fresh matter, is it?
Yes, my lord. Still there is no interim order.
List.
My lordship, serial number 30, it's 39, my lordships. Convict son is assaulted, his head is blood clotted, my lordship. Need to go for a better treatment, my lordships.
Parole.
Yes, my lordships.
Delist on.
Lordship.
My lord, serial number 30.
Lordship.
My lordships.
Now others dates we have given, what else?
Lordship.
Last date hearing, my lord, lordship order for list.
Stay may be extended, my lord, in all the cases.
Stay will be extended in all matters which are not
Yes,
taken.
sir. Yes, ma'am.
Order officially list ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ, B group ಅಲ್ಲಿ ಬಂದಿದೆ.
Seal number?
38.
It is, no interim order is considered or it has to be disposed of.
It has to be disposed of. Similar matter has been, my lord, there is no criminal case against the petitioner from 2016, my lord. Similar matter, all the order passed by the son of an.
Detention, preventive detention.
Notice.
Date code, preliminary hearing.
Lordship.
My lordship,
Hand
serial
delivery
number
of
30.
today's order in serial number 49, 80 and
It
81.
will be uploaded. It will be uploaded.
My lord, serial number 30 kindly.
With regard to the premature release, my lord, petitioner is in custody since 17 years. my lord. Currently, the list one only preliminary. He is seeking for
30?
premature release, 33 minutes. List two, serial number 33.
A list along with Monday.
Please.
My lord, serial number 30, it's an
batch.
emergency parole, my lord.
Huh?
Emergency parole, serial number 30.
Date code, short date.
Short date.
Notice for 5, 6
1st of July, my lord, kindly please. my lord.
At 73, I take notice for 6 and 7. 73.
I told it.
My lord, serial number 20, my lord, the date may be fixed and the interim order may be extended, my lord.
Interim order will stand extended. Date you make a request to the court office.
Lordship.
Much obliged.
26th and 27th fresh matter. Because we have already initiated by virtue of the lordship's order, the estate officer has already initiated the proceedings as your lordship has directed. This matter is now fresh, therefore. It should be tagged on so that we continue the proceedings. They're all from the same slum dwellers of the railway.
Some jurisdictional point there.
On that particular point.
They're showing BDA.
All the
No, correct. They're saying BDA has given a letter. In one matter where order is passed, I remanded. In some matters, they've taken stay just to get the numbers. In some matters, they've taken stay. In some matters, they've taken stay, you find out, and you have it on a common day, we'll see. They're saying BDA allotment, so you have no jurisdiction.
on that ground, your lordship has directed.
No, correct. Where ex parte order was passed, we sent them back.
This particular matter, only notice is issued and.
Correct. In that, they're saying there's no jurisdiction, and they refer to some Supreme Court judgment. Have a look at it. They're relying on BDA allotment.
My instructions were there when all the matters are clubbed together, maybe the second round would be all on a common issue.
Let us see. We'll see on the next date.
In the fresh matters.
Not fresh matter, preliminary hearing it will come.
Your lordship, serial number 24, your lordship, 3rd of July maybe.
I noticed.
कि मेरे को कहाँ छोड़ के चला गया?
ಸರ್ ಅಲ್ಲಿ ಕೇಳಬೇಕು ಅಲ್ಲೇ ಕೇಳಬೇಕು